Right, okay, good morning everyone. It's 10 o'clock and the inquiry is resumed. It's day 7 of the inquiry today, although we've had quite a break since the first portion, which took place in August. So we're coming back to finish off with the last 3 days of sitting, and there'll be a site visit on Friday. The normal reminders before we get started. Could I just ask, please, anyone with mobile phones to make sure that they're switched off? And I understand that Ruth Cadbury MP was going to speak this morning, so thank you. I'll come to you in just a moment. So in terms of what's going to happen this week, Ms. Cadbury is going to make a short statement this morning, and then we have the planning witnesses for each of the parties to hear from over the course of the next couple of days. After that, we'll have a session on conditions, planning obligations, and then the closing submissions. There's been quite a period, quite a break in between. So there's been a flurry of documents that have been submitted during that time. I think all of which I was expecting. They were discussed during the first part of the inquiry. But I'll just run through those now to make sure that I've got everything that I should have. So I've seen a draft section 106. I understand that's not the final document yet. Is there an update on that this morning?
Sorry, sir. It was submitted to you, I think, on Friday. In terms of the draft document, we will just see with Mr. Inger's colleagues as to where the final document is as well. Yeah, but I don't believe there's any further changes required.
Right. Okay. So has the council had an opportunity to see that?
Yes, all the matters are largely agreed. Unfortunately, both our solicitors working on it were on leave yesterday, so they weren't able to complete it yesterday. But there's no outstanding matters from the council's perspective.
Right. Okay. So I can take that as the final version of the document. Yes. Good. Okay. And we'll obviously come on to have a discussion about that later in the week. Good. Okay. So I've also seen a SIL compliance statement from the council, which justifies those obligations. A set of conditions which has been agreed between the council and the appellant. A suggested site visit itinerary and a route for us to take on Friday. Is that agreed between all of the parties?
I believe it is agreed, sir, but I did receive some discussion from Miss Malik as well as Satwinder as to a few additions to that agenda.
Right. Okay. Miss Malik, is that... Right. Okay. Thank you. That's helpful. Did anybody else want to say anything about the... Yes? Sorry? You'll be available, right. But have you seen the route that's been proposed?
So yes, there's no issues with the route. We've just got to make the necessary arrangements for Friday, but Mr. Adan will be available. The route is all fine.
Right. Thank you.
Okay. We can check that and get it added.
Yes. Okay. Thank you. Right. Good. I've also seen a plan which sets out the distances to local services, which has been discussed between the council and the appellant. A drawing showing some potential privacy screens to the balconies of Block A, following on from discussions at the first inquiry. So first part of the inquiry. So, and I understand that that's just an option that's being shown that could be secured by condition if it was thought necessary. Yes.
Correct. Yes.
Okay, there's a statement of common ground on daylight and sunlight. A plan showing the agreed amenity space areas. A plan showing the distances between various buildings in the vicinity. A statement on heritage impact and an updated equality impact assessment. So as I say, most of that has come as a result of the discussions in the first part of the inquiry. Are there any other documents that I should have that anyone wants to raise now?
So there are two short documents from the Gurdwara. The first of those is just an errata sheet for Mr. Robinson's evidence this afternoon, just to save your pen. And there's also a note just correcting the position on the financial, the cash in the bank that the Gurdwara has. You'll recall that you were sent the draft by accident
Yes.
shortly before the close of the inquiry. That's been redated. The information's the same substantively in it, but that's also been provided. And they've been sent to Mr. Salter with the parties being copied in this morning. I've got paper copies if anybody wants one as well.
Yes, please. Is that was sent by email this morning?
It
did
was,
you say?
yeah.
Right. It hasn't made it to me yet. So if you could pass
I'll
up.
hand up some paper copies. Bear with me.
Thank you. Anyone got any comments about that?
We'd like to
Wait, I'll have a look at it. And
So just while Ms Clutton's handing that around, there is an updated core document list,
Yes.
which in section 16 includes a number of additional documents, which I think extend beyond those you just mentioned in some instances. For
Thank
example,
you.
the council has provided a map with routes to Inwood Park, which is now listed as core document 16.11.
Yes.
So I think they are all there in section 16 of the core documents. But
Yes, there was an email from Mr. Tickle which set out those documents in section 16. Is that what you're referring
Thank
to?
you.
Yes.
So just to say, there's a couple of other ones. There was a transport note, there was a heritage note, I think, from the council, and there was also a confirmation that the carbon offset payment was to be slightly modified because of the overheating, the pig lopping in the MVHR, which I think came from the council's expert as well.
Right. Is that so? Is
And that's
that
been
to
picked up
inform the
in
planning
106
obligations
That's been picked up in the
discussion?
106, yes.
Right. Okay. I haven't seen anything specific on that, I don't think. But if it's going to be, if it's just the background information that
It is,
sets out the financial contribution, that's fine.
sorry, so the transport note, there was a transport note submitted, I think, which wasn't on your list, but
Right. When was that submitted?
I think at the same time as some of the other documents you referred to, such as the agreed amenity space areas,
Yes.
the statement of common ground on sunlight and daylight. So if it for any reason hasn't made its way to you, we can get it
Yes.
sent again.
Well, I think if you could send that one over to me, if it wasn't on my list, then I'll make sure that I've got it.
Thank you.
Right. So, firstly, can I just check that everybody else has seen all of those documents and is content that they can be dealt with during the course of the inquiry? We've got the planning witnesses yet to come. Yes.
Yes, sir, with the exception of these, which I haven't looked at yet, but I've got them now. I don't know what they say. But
Okay. Well, you can let me know if there's anything that comes of that
Thank you.
during the course
Yeah.
of the inquiry. Good. All right. Well, are there any other housekeeping matters to raise before we continue then?
Just very quickly, so I believe there will be a fire alarm tomorrow at 10:30. It should run as normal. Hopefully, it's not as long as it was last time.
Yes. Okay, fine. So that's tomorrow. Thank you.
Sorry, sir, there's one, I don't know if Mr. Ingham may want to mention it, but the council has just issued its Regulation 18 on the revised local plan. If you remember, they'd withdrawn all of the sections that were progressing at the request of PINS, and they've now just issued a Regulation 18 for a new local plan, which came out, I think, end of last week, the start of this week.
Yes, and I saw a note on that as well, and I don't think anybody's making any points about how that it has any implications for the inquiry. No. Okay, thank you. You're not hearing very well. Okay, yes. So if everybody could make sure their microphones are on and close to them when they're speaking. Thank you. Right, okay, well, if there's nothing else then, Ms Cadbury, if you'd like to come and use the microphone at the front here, and have you prepared something that you're reading in writing?
I do. I can forward it.
That would be helpful if you would.
I'll forward it, but I'll also give you my notes because I will. As you can see, I've scribbled some extra bits.
Right, okay, thank you. Yes, if just saves us all making long notes if you're able to provide a copy afterwards. Thank you. Okay, when you're ready then, please. If you just press the button on the microphone, it'll come.
Okay. First of all, thank you very much for enabling me to speak today. I was, like a lot of people, not in the country when this inquiry opened, and I wasn't able to attend. So thank you for that, Mr. Boniface. I'm Ruth Cadbury, the Member of Parliament for Brentford and Isleworth constituency since 2015. For 25 years before that, I was an elected Hounslow councillor, during which time I spent spells as a member of and chair of the planning committee and was the cabinet member for regeneration from 2010 to 2012. I have a diploma in town planning and worked as a town planner for Planning Aid for London and for a local authority until about 20 years ago. More recently, in 2021 to 2, I was Labour's shadow planning minister. I know the area of the site very well, having visited the Gurdwara on numerous occasions since it was first opened. And I've met residents in the surrounding homes on their doorsteps as their MP or candidate during a general election period. I'm speaking in support of Hounslow Council's decision to refuse permission for this application. And I'm taking a public stance, something I don't do very often, but I'm doing it on this application because the planning case for the application is, in my view, very weak on the following grounds: the agent of change principle, the density and impact of the housing elements and their impact on both the Gurdwara and neighbouring homes and on the proposed special school, and because of the noise environment, particularly from aircraft. But I'm going to start with housing numbers. The extent and height of the housing blocks compromise the proposed school playground and the school itself, the activities in front of the Gurdwara, and the daylight and aspect of existing neighbouring homes. The number of residential units on this site increased from 90 in the original planning brief to 124 in this application. Now, if the proposed housing is enabling development for the school, I've seen no justification that I'm aware there is a justification for the level of housing to be enabling development. There are 2 free schools that have been developed in recent years in this borough, Nishcam and Boulder, neither of which required enabling housing development. They were funded by the Department for Education in full, as I believe. Hounslow Council has exceeded its targets for housing delivery, and work on the new borough plan identifies a significant potential for future residential development across the borough on sites that are not compromised in the way this site is. So, in my view, delivering an additional 34 units on this site is not essential to delivering the housing target. Moving on, the impact of and on the ceremonial and gathering space. I understand that the conception of the design and the initial site meetings of the parties involved with the application, that is A2 Dominion, Orchard Hill Trust, the Department of Education and their agents, and I believe possibly Hounslow officers. These were held in lockdown when there was no activity at the Gurdwara, there were no planes overhead, the land in front of the Gurdwara looked like a car park. And I believe the Gurdwara trustees were not actively aware of the scheme because of lockdown, there was no one covering their office. Thus, there would probably have been no information to those attending those site meetings that would highlight the normal activity that takes place on the space in front of the Gurdwara. As you probably know, Mr. Boniface, the Gurdwara is frequently a place for religious, celebratory, funeral, and other functions, and the outside space is crucial to this activity, during which the parking area is cleared of cars. These functions are necessarily often noisy, and they can take place through the night. This will be disturbing for the residents in Block A living in the single aspect flats with balconies overlooking the car park or gathering area. Furthermore, any partying on those balconies, which people in flats are entitled to have, would be unacceptable to worshippers for whom alcohol, smoking, and cooking of meat in the vicinity of a Gurdwara is unacceptable, and activities for which I believe the Gurdwara would have little if no remedy in law. And I move on to the agent of change principle, which is now enshrined in national and London planning policy, whereby the occupation of a proposal cannot impact on the existing community or religious activity, or even the industrial activity. Despite revisions to the plans, flats in Block A will still have balconies overlooking the space in front of the Gurdwara and opening living and bedroom windows. Paragraph 8.42 in the application document says the applicant will include references to the potential noise from the Gurdwara in any marketing information. I do not believe this is adequate mitigation and do not believe the suggested Section 106 agreement has adequate power, such as the information being passed on to future occupants or owners of those flats. This condition would not prevent future occupants using environmental law to restrict Gurdwara activities that impact on the peaceful enjoyment of their homes. The impact of the development on the vulnerable children in the proposed school. There is no doubt about the need for a new special school for children with social, emotional, and mental health needs in this borough. I'm well aware of that. However, this cohort are hugely vulnerable to the environment around them. The proposed playground is to be overlooked by housing, and I believe the layout and the level of overlooking, particularly from height, compromises the amenity and safeguarding risk for children in that playground, as well as the aircraft noise, which I'll move on to shortly. I'm concerned that Hounslow's SEN officers were not consulted about the details of this application, nor saw the plans, the elevations, and the visual representations relevant to the school. Nor have I seen evidence that they supported the details of this application and the relationship between the housing and the school. And maybe we're not aware of the noise environment either. If this application were to be approved, there should be a condition relating to noise insulation, such as that recommended in the acoustic report by SOL or SOI. Due to the impact of air traffic noise at the site, it is recommended that provision is made for a fully mechanical ventilation system. In any teaching space or space for quiet study or concentration, openable windows should not be relied upon for summertime boost cooling or intermittent boost requirements. And now aircraft noise. Paragraph 8163 to 166 confirms that the site of the local plan confirms that the site is within the Heathrow noise contours area, i.e. within the 63 dB LEQ contour. Paragraph 9.12 of the local plan states, I quote, consistent with the ICAO balanced approach and advice from the airport operator, noise sensitive development should not be located within the 69 dBA contour, but in the case of family housing and non-residential noise sensitive development, also outside of the 63 dBA contour. And this site is just at the point of the 63 dBA contour. Now, I appreciate that a subsequent site brief did say that this site was suitable for housing and schooling, but it just goes to show just how noisy this environment is. And the initial noise assessment dated June 2022 was done at a time when Heathrow Airport was not at full operational levels and when planes, Norway planes were landing in the westerly landing path. The proposed school and housing will be located under the final approach to Heathrow, which means that for 70% of the year, planes land at Heathrow in a westerly direction, which is determined by wind direction, and that proportion is actually set in national agreement. And Heathrow is now back to almost 100% operation. Formal agreements determine that the landing pattern alternates between the northern and the southern runway between 7 a.m. and about 11 p.m. and swapping runways at 3 p.m., swapping between the north and south on alternate weeks. There is no restriction on flights at all between 6 and 7 a.m., and they're almost all landing at that time. And before 6 a.m., there are an average of 16 flights arriving, generally from 4 a.m. This means that for a third of the year, the proposed school, which of course school finishes at around 3 p.m., the proposed school will experience flights landing overhead for the whole of the school day. That is every 60 to 90 seconds, every other week, during which time the noise never ceases, it just rises and falls. And if those present here today, they are, when I walked up from the station at about 8:30, they were landing on the southern runway every 60 to 90 seconds, and that is the site is just to the south of us. So that is an opportunity to see that happening. There's no guarantee that when you do your site visit, Mr. Boniface, the planes will be landing westerly. If the wind changes, you'll be on easterly and you won't experience it. But we are the same, your visit was on the same week, so the timing is before 3 p.m. when they're on the southern runway. So when the planes are landing overhead in this part of Hounslow, the noise never ceases, it just rises and falls. Furthermore, the residents of the proposed blocks will experience significant aircraft noise day and night. And in order to comply with current residential and education, acoustic and ventilation standards, any mitigating conditions will require the school and the homes to be hermetically sealed for the periods when the planes are landing overhead, and require expensive mechanical ventilation and, for some rooms, even more expensive cooling. This building is such a building, but when one is teaching or living or studying in that school or living in those homes, one won't have the choice as to when it's going to be pleasant to open the windows, go outside on a balcony or into the playground or into the small amount of open space. So that means that the school playground will be unusable for teaching and potentially even for playtime, be traumatic, particularly for this cohort of students. I understand that it is possible to mitigate for open space in just these environments, as some of the flats on the A4 in Brentford have done by providing an indoor open space. But I do not believe that this application provides sufficient usable indoor recreation space for the school or for the homes to be usable when people want to, at times when it's very noisy. And finally, Mr. Boniface, the sunlighting and daylighting impact. A number of existing homes adjacent to the site will lose daylight and sunlight from their primary windows, as will a number of the proposed homes. I do not find this acceptable for either my current constituents nor potentially my future constituents, and do not believe they should live in homes that do not meet basic amenity standards. Thank you very much.
Right, okay, thank you for that. Are you willing to answer any
Oh, yes,
questions
sorry,
that
yes, of
Mr.
course.
Strawn may have for you?
Good morning. Thank you, sir. I'm not going to ask very many questions. We've covered a lot of the ground. I just check, Ms. Cadbury, when you refer to, for example, noise assessments of the proposal, have you actually looked at the noise assessments which take account of aviation noise and the agreed position with the council? Have you looked at those documents yourself?
I've looked at the SOL document. I don't know if it was June 2022.
Right. Nothing else?
I haven't.
And similarly, have you looked at the evidence from Orchard Hill College and Academy Trust as to the way in which the school will meet its specialised needs?
I haven't, but
No.
I'd be interested to know if they have operated a school of the nature of the cohort of children in an environment as noisy as this. I mean, this is perhaps the noisiest part of the UK, or whether they have consulted any school operators, not them, if they are not operating in such a noisy environment, whether they have talked to designers and managers of schools with this cohort of children in this environment.
So you haven't looked at any of the supporting information from them or the Department for Education or the letters that come in support of the application?
I haven't, but I have visited all of the schools in the borough when I was on Heathrow Airport's community noise buildings insulation scheme. And what I do know is that managing a school day, even where the internal ventilation and acoustics are adequate, it is not. The heads still have to deal with children needing somewhere to play during the school day, needing fresh air, needing place to stretch their legs, and for those teaching the cohort of children where there's a high level of stress, children who are hypersensitive to environmental factors such as children with autism and so on, which is the need for which this school is proposed. They need calm, they need peace, they need fresh air, they need a natural environment. They will also be going to and from the school at the beginning and end of the school day. And
Ms. Cadbury is turning into a very long answer. Mine was just a simple.
It's very
factual...
difficult to manage, is the answer.
No, well, that wasn't the question, was it? The question was a simple one. Had you, in your assessment of this application, looked at the relevant material that's available to any member of the public, including you, for example, from Orchard Hill College and Academy Trust? And I think the simple answer was, no, I haven't.
No, but I have spoken to many managers of schools operating schools in this noisy environment, which is probably unique to the UK.
Thank you very much.
Right, okay, well, thank you for that then, Ms. Cadbury. Right, is there anything else before we move on then to deal with the planning evidence? Thank you. So, Mr. Furr, then, if you'd like to introduce your last witness, please.
Thank you, sir. I will. Mr. Ringer, you have prepared a proof and rebuttal proof, and I propose to introduce you to the inquiry by reference to sections 1.1 to 1.3 of your main proof of evidence. You are Nathan Ringer.
Yep.
And you're a senior planning officer at the council with a degree and a master's degree in planning, and you've held that role since October 2019.
Yes, I have.
Thank you. Now, you confirm that you were not the case officer for the application. Have you familiarised yourself with the officer's report and with the appeal site?
Yes, I have. I wasn't the case officer for the original application. I didn't have any involvement with the assessment of that scheme. I was very much so aware of the application. It was the talk of the town, you could say, due to the amount of objections that we did receive. But no, I wasn't involved. And then upon being appointed, the council's planning witness, I familiarised myself with the core documents, rewatched the planning committee meeting and the officer's report.
Thank you. You'll be aware that the views expressed by the case officer in respect of the issues raised in the reasons for refusal aren't consistent with your views or with the conclusions reached by members. Do you have any comment on that?
No, I don't. When I initially went through the officer's report, I disagreed with the conclusions that were made in relation to the main issues at hand. I agreed with a number of my colleagues' assessment points with regards to matters that don't relate to the main issues. But the assessments that we've discussed, I didn't agree with.
Okay, thank you. I understand that you have a number of minor corrections that you'd like to make to your proof of evidence. Could you just run through those, please?
Yes, I do. So beyond the initial corrections that I had in my rebuttal, I have 4 additional corrections. So at paragraph 6.37, the final 2 sentences should reference.
Just wait for the inspector to get there.
Apologies, sir.
It's page 52.
So yep, the final 2 sentences of paragraph 6.37 should state 112.8 square meters rather than 104. The second
Okay, just wait for the inspector to make the correction.
Apologies.
Okay, the next I think is page 57.
Yes, thank you. So page 57, paragraph 6.52. The healthcare contribution is omitted from the heads of terms, although this is included in the statement of common ground. Then on document page 73, paragraph 7.2.
I think that's page 63.
Sorry, 63, paragraph 7.2.
Just
In compliance with the development plan section, I state that the proposal complies with policy EQ5. That is an error as demonstrated by the rest of my assessment.
so take out EQ5 from the second bullet point.
Yes, please.
Okay.
And then lastly, on document page 45, paragraph 6.16, I cite conflict with policy D6D. As we have discussed, there are adverse impacts in regards to daylight and sunlight that I consider should be weighed in the plan and balance. But having regard to the benefits and the context of the scheme, I don't consider the proposal to be, or the adverse impacts to be unacceptable in line with that policy. So I would like to remove the conflict that I cite with D6D of the London plan.
So which paragraph are we looking at? 6.16?
6.16.
6.16 is the first mention of it on paragraph 45.
Sorry, page 45.
Page 45, sorry.
The second line in paragraph 6.16 mentions conflict. Well, it mentions D6D. And I think there's an allegation of conflict with that policy. But the policy itself refers to unacceptable impacts, which involves the weighing of countervailing matters. And Mr. Ringer's position is there's no conflict with that policy, but there are harms that should be weighed in the planning balance.
So
That policy, sir, is also referenced on page 64, paragraph 7.5.
And the fourth line of that paragraph.
7 point, sorry.
7.5 on page 64. Thank you. Now, Mr. Tickle notes in his evidence that in the council's statement of case and in your proof, you identify conflict with a number of policies that weren't referred to in the reason for refusal. Can you please explain why you've referred to additional policies in your proof?
Yes, so firstly, as I mentioned, I didn't have any involvement with the original application, so I didn't have any involvement with the drafting of the specific refusal reasons. Now, in order to assist the inspector with his duty, it's my responsibility to make the inspector aware of any policy conflict that I consider to be relevant to the main issues. I didn't try to hide these additional policy conflicts within my proof, and I stated where they were new policies. And I consider that is necessary to allow the inspector to sufficiently fulfill his duty.
Okay, Thank you. Can you just assist me then? Because there's some suggestion in Mr. Tickle's evidence that, well, members didn't cite those policies, so you're going beyond the position adopted by the members in refusing permission. What comment do you have on that?
So as a general approach, when at planning committee, when members identify reasons for refusal, they don't specifically state a policy that they cite conflict with. So in this case, they stated that there was issues with, for example, agent of change and the impact of the Gurdwara on the residents of Block A. At the committee, they didn't state that the specific policy conflicts. It is then the role of officers who have delegated authority to draft the refusal reasons to attach those policies to the issues they identify.
Okay, thank you. Mr. Ringer, you're speaking quite fast.
Apologies.
That's okay. It's just so that the inspector can take a note of your evidence. Okay, reason for refusal 1, please. Now, in your evidence, you say that it doesn't appear to you that noise from the Gurdwara was considered during the initial design of the site. What does that mean, please, in terms of compliance or otherwise with the principles of good design in the Pro PG document, which you don't need to turn up, but it's core document 12.8?
So I think the failure to adequately understand the noise from the Gurdwara, particularly at the stage of the committee, would be contrary to the principles of good acoustic designs within the Pro PG, which states that the good acoustic design involves a careful planning of a development right from concept design, having regard to those existing noise sources. And this process should begin at the earliest possible stage. So I don't consider that those principles have been complied with, as we've established that the appellant didn't undertake a sufficient noise assessment at that time of the original application. So I don't consider that to have been complied with.
Thank you. And what does that failure then to consider noise from the Gurdwara at the design stage mean in terms of compliance with policy D13, which we have at core document 10.1.6?
So I consider this failure to represent a direct conflict with this policy read as a whole, particularly criterions A, B, D, and E. So criterion A places the responsibility for mitigating impacts from existing noise and nuisance generating activities and expects the developments to pay sufficient heed to those and be designed in a manner that is sensitive to reflect those principles. Both Mr. Leach and Mr. Mannering in their cross-examination confirmed that the appeal scheme had not been designed with any understanding of the noise generated by the Nagara drum, which was only assessed after the application was refused.
Okay.
Meaning that the proposal was not sensitively designed based on an understanding of the acoustic environment.
Okay.
Which would be a direct conflict with criterion A. For criterion B, emphasizes new development must not prejudice noise and nuisance generating activities from remaining viable and continuing to grow without unreasonable restrictions being placed upon them. There's been a debate in front of the inquiry as to whether the frequency, level, or duration of these of the noise that is emitted from the Gurdwara would result in an adverse impact on the occupiers of Block A.
Mr. Ringer, sorry, slow down. Slow down,
Apologies.
just so the inspector can take a note. Otherwise, when
Just
he
take a
comes
sip,
to look
Roger.
back, yeah, that's okay. If you look at the inspector and where he's at to with the writing, that can sometimes help to see if you're going a bit fast. Okay, so sorry to interrupt. So
No
you were
problem.
on criteria B, and you were talking, I think, about unreasonable restrictions. and
Yes.
things.
Sorry, if we're going to look in detail at the policy, could you just give me the
Of
reference?
course,
that?
it's 10.1.6. Sorry, 10.1.16, so my mistake.
Thank you.
Thank you. Okay.
Yes, so as I said, criterion B emphasizes that new developments must not prejudice noise from nuisance generating activities from remaining viable and continuing to grow without unreasonable restrictions being placed upon them. As I said, we've debated whether the level, duration, or frequency of noise emitted from the Gurdwara would result in adverse impacts. It is the council's case that the noise from the Nagara would be significant, which is confirmed by Mr. Leach in paragraph 2.10 of his proof, and under cross-examination, he accepted it as a major noise source. And I consider that this would likely generate complaints from residents of Block A. Subsequently, I think these complaints would likely lead to unreasonable restrictions to the existing use of the Gurdwara's external areas, which is directly contrary to the agent of change principle. I think it's also important to consider the possibility of future growth as well. So whilst the council's case is that the development would result in unreasonable restrictions being placed on the existing activities, it is also important to consider that there is potential for future growth at the Gurdwara. Now, Mr. Adan has highlighted how the community presence of the Gurdwara has continuously increased since their doors first opened. Therefore, it wouldn't be unreasonable to assume that the duration and frequency of the noise generating activities, particularly at the Gatka, may need to increase. And I think this is important to consider when assessing compliance with the agent of change principle.
Mhm. Okay.
Then in Mr. Tickle's ST1, he focuses on criterion D. So criterion D states that development proposals should manage noise and other potential nuisances by first, ensuring good design mitigates and minimizes existing and potential nuisance generated by activities, uses, and activities located in the area. As I've mentioned, I don't consider the scheme to represent good design in both acoustic and general terms, based on the hierarchy mentioned in this policy, as well as other material considerations. Then criterion D2 states that exploring mitigation measures early in the design stage with necessary and appropriate provisions, including ongoing and future management of mitigation measures secured through appropriate obligations. Now, mitigation measures were not considered early in the design stage. The design and action statement shows that the design was not informed based on an understanding of the Gurdwara's operation or context. And it's important to say that appropriate mitigation measures should be proposed. I think as the appellant has gone straight to sound insulation through the building fabric, that doesn't demonstrate that all appropriate steps have been taken. And then finally, criterion D3 states that separating new noise-sensitive development where possible from existing noise generation of businesses and uses through distance, screening, internal layout, soundproofing, insulation, and other acoustic design measures. The appeal scheme has not followed the hierarchy of distance, screening, internal layout, soundproofing, insulation, and other acoustic measures. Once the appellant was made aware of the excessive noise emitted from the Gurdwara, increased specification glazing was proposed and alterations to the balcony treatment. And as I mentioned, I don't consider this to comply with this hierarchy, particularly as Mr. Manwaring confirmed that he had not revisited the layout or design of the appeal scheme at all once being made aware of the noise from the Gurdwara.
Okay.
And then lastly, criterion E. Boroughs should not normally permit development proposals that have not clearly demonstrated how noise and other nuisance generating other nuisances will be mitigated and managed. As confirmed by both Mr. Leach and Mr. Manwaring, the appeal scheme was not designed with an adequate understanding of the acoustic environment and could not demonstrate this understanding at the point of the committee decision, which is clearly contrary to this criterion. Even at this stage, I don't consider the appellant has demonstrated that the noise from the Gurdwara will be appropriately mitigated and managed. The mitigation measures will not follow the hierarchy of good acoustic design. As I said, it's jumped straight to alterations to the building envelope. Notwithstanding this, the council is still of the view that the noise impact will be significant once the character of the noise is taken into account, and that is likely to generate complaints from residents of Block A that could likely lead to restrictions being placed on the Gurdwara's operations.
Okay. Okay, so could I ask you to turn up policy D14 of the London Plan, which is core document 10.1.17?
Yep.
Just wait for others to get there too. 10.1.17, policy D14. Okay, thank you. Can you please talk us through your comments on the compliance or otherwise with policy D14?
Yes, of course. So Mr. Tickle claims that Mr. Leach's evidence demonstrates full compliance with this policy, and that the council's response from Tetra Tech confirms this is the case. As I mentioned, that there has been quite a significant debate about the impact of noise from the Gurdwara, which the inspector will now determine. But I don't consider the design process to have followed the agent of change principles, which are referenced in criterion A2 of this policy. That there is, and I consider that there is potential for unreasonable restrictions to be placed on the Gurdwara. And criterion 5 of this policy, again, follows that hierarchy of separating new noise-sensitive development from major noise sources such as road, rail, air transport, and types of industrial uses through distance screening, layout, orientation, uses, and materials, in preference to sole reliance on sound insulation. And as I mentioned, I don't consider the appellant's reliance on sound insulation without testing alternative solutions to comply with the hierarchy that this policy sets out. I do accept that due to the site allocation and the strategic importance of this site, that it is a suitable location for both residential and educational uses. However, the appellant has not shown nor explored any alternative solutions on the southern portion of the site which would achieve a similar quantum of development with an increased separation distance from that significant noise source. At paragraph 3.14.1 of this policy, it states that the management of noise should be an integral part of development proposals and considered as early as possible. I don't consider this to be complied with. As I've said at the time of the committee decision, the appellant had failed to take a sufficient understanding of the acoustic environment and did not provide members with sufficient information to make an informed decision on the level of harm that would be experienced by the potential future residents of Block A. Even now, sufficient assessment has taken place. The council's review remains the same, that the residents of Block A will be exposed to significant noise impacts that would likely generate complaints. Indeed, Mr. Tickle does accept this hierarchy of mitigation that I have mentioned now. Within his proof at paragraphs 04.5.14 and 04.5.15 and within ST1, he recognizes that developers should reduce, manage, and mitigate potential impacts of noise through distance screening, layout, careful design, uses material, and then, if necessary, by adequate insulation of the building envelope. And I consider there to be a clear conflict with that hierarchy. So, as I mentioned, in terms of location, without regards to the specific blocks, the location of the uphill site itself is appropriate for these uses. But I don't think that means that any layout or configuration should be considered acceptable, and any scheme has to be sensitive to its context. With regard to careful layout and careful design, again, I don't consider this to be complied with in any way. Once the appellant was made aware of the potential noise emitted from the Gurdwara, without carrying out a comprehensive assessment on the Nagara noise, the appellant opted to include higher specification glazing on the balconies and balconies to Block A. And the appellant didn't provide any information to suggest that they explored alternative solution in terms of layout, form, and design that would show or demonstrate that the adverse impacts in terms of noise could be mitigated, and instead relies on solely insulation to the building fabric. And indeed, Mr. Manwaring in his cross-examination said that it would be highly unprecedented to change the orientation of a building to accommodate a specific noise source, which I think is clearly a blatant disregard of this hierarchy the policy set out. And even with the selected mitigation measures, the appellant has not showed that the impacts have been managed as far as reasonably practical. No evidence has been prepared to show that they have even considered an alternative design or layout that moves Block A further away from this noise source.
Thank you. Could you please turn up Local Plan Policy EQ5, which is core document 11.1.20? (11.1.20). Okay. What comments do you have, please, on the compliance or otherwise with this policy?
With policy EQ5, it makes it very clear that the design of a proposal should be informed by an understanding of the acoustic environment, which, as we have established, is not the case for the appeal scheme. And again, the failure to carefully design the layout of the appeal scheme based on the significant site constraint that is the Gurdwara means that the hierarchy of mitigation as expressed by this policy has not been followed.
Okay, could you turn up the PPG on noise, which is core document 9.5? Okay. How do you say the appeal scheme performs against the PPG?
So the PPG sets out that good acoustic design needs to be considered early in the planning process to ensure that the most appropriate and cost-effective solutions are identified from the outset, which I've stated I don't think is the case for the appeal scheme, as they've jumped straight to reliance on insulation to the building fabric. And due to the fact that the appellant didn't have a sufficient understanding of the noise that is emitted from the Gurdwara when they devised their scheme, and at the time of the committee decision, it was clear that the guidance in the Pro-PG hasn't been followed, as the most appropriate solution wasn't identified from the outset.
Sorry, what you said Pro-PG there, did you mean PPG?
Yes, apologies, yes.
Okay, thank you. Okay, fine. Are there any particular parts of the PPG that you draw the inspector's attention to in that core document 9.5?
I think most of the document is relevant to the matters at hand in this appeal, but I think the section on how it can be established whether noise is likely to be a concern, and what factors influence whether noise would be a concern would be what the inspector should have a look at.
Thank you. Can I ask you just to look at the part on PDF page 7, which comes under the title, How Can Planning Address the Adverse Effects of Noise Sources, including where the agent of change principle needs to be. So it explains there, in general, for developments that are likely to generate noise, there are 4 broad types of mitigation, and it runs through engineering, layout, where possible optimizing distance between source and noise-sensitive receptors, then use of planning conditions to restrict activities allowed on the site, and then the 4th bullet point, noise insulation.
Yes.
How does that sit with the other policies and guidance that you've mentioned so far?
I think it's broadly in line with the hierarchies that set out by the policies and material considerations I mentioned. reducing the noise generated at source is not possible for this application. And then we have layouts, planning obligations, which generally follow the hierarchy that has been set out by those policies I've mentioned.
Thank you. Now, as you've mentioned, there's a disagreement between the noise experts as to whether the adverse impacts of the Nagara noise are significant, and that will be a matter for the inspector to determine. Could I ask, please, in your view, is the agent of change principle in policy D13 only concerned with significant effects?
No, it isn't. It's concerned. It's not only concerned with significant adverse impacts. Policy mentions noise and other nuisance generating activities or uses. It doesn't distinguish a threshold for triggering this policy, and I do not consider nuisance to mean significant adverse impacts, particularly when other policies in a development plan do explicitly state that.
What do you understand noise nuisance to mean?
I think nuisance would mean a general annoyance and something that causes a level of frustration that wouldn't significantly impact your health, but you still may find it annoying, frustrating, worthy of complaint.
Okay. Thank you. Now, this discussion about unreasonable restrictions, what do you consider would be an unreasonable restriction on the Gurdwara?
So I think an unreasonable restriction would be, firstly, I don't think that if there was complaints received, I don't think the Gurdwara, specifically the drummer of the Nagara, would be asked to play at a specific level.
Asked by who, do you mean?
So, for example, if complaints were received and the council contacted the Gurdwara to mitigate the noise complaints that were being received, I don't think they would be asked to reduce the sound that is, or the level of sound that is produced. And it would be unreasonable to do so if we had to expect them to have... Just
pausing you there for a moment. Why don't you think that the environmental health team would set a level and say, well, you can't play over this sound power level?
I think it would be... It'd be difficult to monitor that. They would have to set up specific equipment within the vicinity of the Gurdwara. The drummers would have to be aware of what to be doing. I don't think that would be achievable. And then in terms of other unreasonable restrictions, I think any restriction that limited where the Nagara could be played, how often, in which location, how loud, the duration, or the restrictions on uses of certain areas, I think any restriction of that kind would be considered unreasonable.
Why is that? Why do you think that would be unreasonable?
I think it would be unreasonable because the Gurdwara are currently undertaking these activities, and the agent of change policy is very clear that it shouldn't restrict the existing activities that are taking place and shouldn't prevent future growth. So if those restrictions I've mentioned were put in place and they weren't allowed to play in certain areas at certain times or for certain periods of the day, that would certainly be unreasonable.
Paragraph 187 of the MPPF, don't need to turn it up, but that deals with the agent of change and it does refer to significant impacts. How should the London plan policies be read in light of that national policy?
Well, the London plan policies form part of the development plan, which takes precedent. The MPPF is an essential material consideration, and the two documents are intended to be consistent with each other, but they're not required to exactly replicate each other. This paragraph does refer to significant adverse impacts, but I do not consider that to mean that there is no conflict with the agent of change principles within D13.
Okay. Thank you. So whether the noise is significant or adverse at some other level below significant, what's your overall view then on compliance with the agent of change principle?
I think even if the level is considered to be somewhere below significant, it would still be contrary to the agent of change principles, which reference nuisances and other noise generating activities and doesn't explicitly say that significant adverse impacts trigger that policy.
Okay. Now, in your proof of evidence, it's paragraph 6.5. Let me just get the page number. Page 42.
Yes.
Can I just check? I think there might be another correction. You identify conflicts with parts A and D9.
Yes, I believe that reference to D13 there should be D3.
So, sorry, that's in the third line of paragraph 6.5. Is that right?
Yes, that's correct.
So it should say conflict with D13 parts A, B, D, and E, D14 parts A1 to 6, and D3
Part
nine.
D9, yes.
Part D9. Okay. Why do you say there's conflict with, well, let's turn up that core document. So policy D3, I think it's core document 10.1.8. Okay, why do you say there's conflict with part D9?
So part D9 of this policy states that proposal should help prevent or mitigate the impacts of noise and poor air quality. And as I mentioned, I don't consider the appeal scheme to have been appropriately designed to mitigate the impact of noise on the potential future occupiers of Block A, and therefore I do not consider the appeal scheme to be in accordance with this policy criterion.
Okay. Thank you. You also identify in your proof conflict with policy GG2 of the London Plan. That's core document 10.1.2. And the specific area of conflict you identify is with criterion D.
Yes.
Now, Mr. Tickle, in his evidence, says that the appeal scheme complies with this because it strikes an appropriate balance between optimising the development potential and integrating successfully into the surrounding environment and protecting neighbouring amenity. What's your view as to compliance with this policy, having regard to his comments?
Yeah, so criterion D states that the proposals must apply a design-led approach to determine the optimum development capacity of a site. Now, I don't consider this to be achieved, as I don't consider the appeal scheme to successfully integrate with the surrounding built environment or protect or minimize the impacts on neighboring amenity. The key to a design-led approach, amongst other things, is to successfully respond to the context of any site, which in this case would be the Gurdwara and the properties on Perkins Close, as well as the various other uses around the site and Hanworth Road to the south. This means that responding to the existing character and distinctiveness on surrounding context and balancing the capacity for growth, need for housing, and key factors such as access, cycling, walking. Now, this policy states that, as well as the design-led approach LPG, that capacity testing should be the product of the design-led approach and not the driver. As the design and access statement showed, and as Mr. Mannering confirmed in his cross-examination, apologies, the design and access statement references page 25, paragraph 3.1. Mr. Mannering confirmed that the initial design was informed based on a brief to provide 115 to 130 dwellings, which shows that the capacity testing was the driver and not the product, which is contrary to the design-led approach as expressed by this policy and other material considerations.
Okay. Now, Mr. Tickle also makes the point that the council hasn't alleged any conflict with local plan policy SC4, which deals with scale and density. And he says that that indicates that the council therefore supports the overall massing and design of the scheme. What's your response on that, please?
Well, in my proof of evidence at paragraph 6.19 on page 46, I make it clear that I consider there to be a conflict with SE4, in particular criterion A, B, and D. And this policy is also listed in the reason for refusal. So clearly we do cite conflict with this policy. Criterion A seeks to optimize housing output, taking account the policies for context and character. Criterion B requires the application of the design standards contained within the local plan to ensure the delivery of high quality developments that do not compromise the amenity of existing or future residents. And then criterion D expects proposals to preserve the amenity of neighbouring properties by demonstrating compliance with prevailing daylight and standards and habitable room separation distance. I do not consider the appeal scheme to have complied with any of these criterion, as the development has not sufficiently responded to the site's context, and the amenity of neighbouring properties would not be preserved, particularly on the Gurdwara and Perkins Close to the north. However, I don't cite conflicts with criterion SC4 relating to the actual density of the scheme. I do not consider the overall density of the proposal to be unacceptable. Whilst this is the case, it doesn't mean that the massing of the design or design of the scheme should be supported or is demonstrated to be acceptable due to the harmful impacts the appeal scheme would have on neighbouring properties. But in general, I think the density of the scheme is appropriate.
As to policies SC5 of the local plan, let me just get the reference up. Core document 11.1.6. Now, Mr. Tickle's view is that this policy isn't relevant to the appeal scheme and that the appeal scheme complies with it in any event. What's your view, please?
So the objective of SC5 is to provide the highest quality of internal and external living conditions for all new developments and future occupiers. I do accept that this policy doesn't make a specific reference to noise or noise management, but the overarching objective is to provide high quality living conditions. And this inquiry has established that noise has the potential to harm the quality of accommodation that is provided for occupiers. So I do consider that the adverse impacts of the future occupants in terms of noise represents a conflict with SC5, despite it not explicitly referencing noise.
Okay, policy CC2 then of the local plan, that's core document 11.1.8. Again, please, your comments on Mr. Tickle again says not relevant. Can you explain your view as to its relevance?
Yes, I disagree with it. I certainly think that this criterion is relevant. So criterion R specifically states that development should be designed to mitigate noise issues on areas of the borough that do experience significant noise issues. It does mention air quality as well. And I do not consider the appeal scheme to have complied with this due to the significant noise that would impact the occupiers of Block A. But notwithstanding this, I think these two policies, if they were removed from the reason for refusal, the conflict with D13, D14, and EQ5 renders the appeal scheme contrary to the development plan as a whole, notwithstanding the fact that I do think these policies are relevant.
Understood. Thank you. Reason for refusal 2. In your evidence, you refer to the Mayor's housing SPG which discusses the importance of achieving adequate visual and acoustic privacy. And it includes a reference to past planning guidance and separation distances of 18 to 21. Explains they can still be a useful yardstick, but adhering to them rigidly can limit the variety of urban spaces and housing types. How have you treated the SPG's guidance as to separation distances?
I have treated it as it is intended to be treated, and that is as a useful yardstick. There is an element of flexibility that can be provided to ensure the optimum form of development, and I haven't applied those standards rigidly when completing my assessment of the appeal scheme.
Okay. The council doesn't take issue with the distance from Block D to 29 to 44 Perking Close. How do those distances perform against the yardstick?
Yes, they are marginally below the yardstick. 16.4 meters between Block D and numbers 29 and 44 Perking Close. Around 2 meters, 1.6 meters short of that yardstick. I think that should be applied flexibly, and I don't think the relationship with the habitable rooms within Perking Close or within 29 to 44 Perking Close are unacceptable.
Okay, thank you. Now, the guidance talks about rigid application of minimum distances can limit variety in urban spaces. And it's in that context that a dispute has arisen about whether the appeal site is in an urban or suburban area. Before we explore that, can I just ask you, even if the area is characterised as urban, how, if at all, does that affect your view about the acceptability of the separation distances?
Yeah, so I think even if the inspector did consider the area around the entirety of the appeal site to be considered urban, then the useful yardstick would still not be adhered to. As you highlighted, rigidly applying this can restrict density and restrict the developments that take place in our cities. However, it is important to recognize that 18 to 21 meters is considered the optimal relationship by this material consideration, and development should ideally seek to achieve this. It isn't always possible or practical to do so, which the appellant argues is the case for this appeal scheme. But I don't think it should ever be completely discounted when assessing proposals, particularly in urban environments.
Okay, just as to the extent of the shortfall against the yardstick, I think the minimum separation distances are 9.3 versus 9.6, so around that area. Even in an urban area where the yardstick should be applied perhaps more flexibly, what comments do you have on the extent of that shortfall? I
think even in an urban area, the relationship should be considered unacceptable. The distance of between 9.3 and 9.6 meters is around half of that recommended distance, and in my view, it does represent an unacceptable impact on these neighbours' living conditions.
Okay, I'd like to turn then to the urban versus suburban issue.
Great.
Now, Mr. Tickle, in his evidence, refers to the council's SPD, which includes a diagram that identifies suburban areas in dark blue shading. And the dark blue shading doesn't cover the appeal site, which is shown in an orange shading, which reflects urban terraces.
Yeah.
Okay. Could I ask you then for why it is you say the appeal site's context is more suburban than urban, given that it isn't shown in dark blue?
Yes, and I'd quite like to take you through my assessment of this issue holistically, starting from my appointment of the appeal scheme and conducting my initial site visit. So my starting point for this assessment and classification of this area stem from my local knowledge and professional judgment, which the housing SPG does encourage. I'm a member of the central area planning team, which is mainly within the Hanworth area. The appeal scheme is with it slightly outside of that boundary. It's in the west area, but it's 270 meters from the town centre. And I do have a good local understanding of this area of the borough in particular. When I first visited the appeal site, I to do my site visit exercise to understand the site constraints and the character of the surrounding area. I come from Hounslow House through to Bell Road and Hanworth Road, arriving at the site, turning right onto Thompson Road where the industrial properties are, then walking through Perkin Close, west on Williams Drive, south down Hibernia Road, back to the southwest corner of the site, then walking through the Goodwara premises and exiting the site back towards Thompson Road, Derby Road, and up to Hounslow House where we are now. And it was at this point when I completed this exercise that I first concluded the area to be suburban. It was clear to me, particularly due to the north and the west of the appeal site being predominantly residential, two-storey, semi-detached terrace properties of low to medium density.
Take it a bit slower, Mr. Ringer.
Apologies.
Okay.
So then turning to the housing SPG definitions, the central is defined as areas with dense development, a mix of different uses, large footprints, typical building heights of 4 to 6 stories within 800 meters of walking distance of a international or metropolitan center, which...
Mr. Ring, could you just give me the reference to that, please?
Yes, it is page 44 of the housing SPG, sir.
So the housing SPG itself is, just bear with me, it's core document 10.2.9, I believe. What page did you say it was, sorry?
Page 44.
Okay, bear with me. Let me just find the PDF. Yes, it's PDF page 44 as well. Okay, so yeah, we can see there, central, urban, suburban.
Yeah, so as I said, I think Hounslow Town Centre sits quite sensibly in that central definition. Then urban areas with predominantly dense development, such as, for example, terrace houses, mansion blocks, a mix of different uses, medium building footprints, and typically buildings of 2 to 4 stories located within 800 meters of a district centre or along a main arterial route. Then suburban areas with predominantly lower density development, such as, for example, detached and semi-detached houses or predominantly residential, small building footprints and typically 2 to 3 stories. Now, I would like to add with these definitions that I don't consider all full 4-story properties on an arterial route to be within 800 meters of a town centre to considered urban. And I do think an element of judgment needs to be had and not rigidly putting a site in or an area into these definitions. I do recognise that the appeal site is 270 meters from the metropolitan town centre. However, when leaving the town centre and travelling south via Hanworth Road, in my view, there is a clear shift in character. When travelling towards the appeal site, the building heights begin to decrease to predominantly two stories. The building footprints become smaller and the area becomes predominantly residential in use. And I consider that this change in built form and character represents a distinct change from the metropolitan centre to an area that is considered suburban in nature. And this has been added to the site visit agenda, but I do feel it would be a really helpful exercise, sir, to take a step out onto our terrace and view the appeal site from there, as I think is a great visualization of that change in character. Then, when considering the appeal site...
Mr. Ringer, before you go on, could you just take me to the diagram that has the blue and orange shading on it?
Yes, sir. That diagram is within the emerging SPD. I'll just find the core reference for you.
Is it 11.5.7?
Yes, the Character, Sustainability and Design Codes SPD.
Okay, let's just go to within that. I don't know if you have that on your electronic, because that's split into various parts.
Yes. I believe the page with the blue and orange, which Mr. Phil references, is in the part A of the document. However, I'll just confirm that.
Page 20.
Thank you.
I've got part A, A1, A2, A3. Is it part A1?
Yes,
I think it's
A1.
A1 introduction.
So that section of the SPD sets out the urban typologies and where they are in the borough, and I will touch on that very shortly.
Can I just ask you, please, to assist the inspector just by reference to that with where the appeal site actually is on that
Yes.
plan.
So I'll just go to the page now.
Which page was it?
Page 20, PDF
20,
page 20.
So if you sort of zoom in on the central portion of the map, sir, if I could just turn my computer and show you the image. Yes, that's the one. So in the central portion of the map, you see the light green area. That is Hounslow Town Centre. Within my note on the SPD, it does have a enlarged version of the area surrounding the appeal site, which may be more helpful for you, sir. I'll just check the page number of my note for you.
If you've got that, it's just above the railway sign.
Yeah.
So if you see the red railway sign, Hanworth Road's running diagonally, and you can make out the Gurdwara building next door to a blank site. It's all coloured orange. Does that help? I mean, I'm just
Yes, and on page 6 of my notes,
Sorry, so your note is core document 14.20.
Yes.
Okay, so let's
page 6, I think.
page 6. Okay, so on page 6, you've got an extract from that plan from the emerging SPD.
yes, and the appeal site is marked with a star on that page, sir.
Yes, I see it. Thank you.
So in terms of the site context, it's 270 meters from the Metropolitan Town Centre, as Mr. Tickle highlights. The area to the south of the site, we have the arterial route, which is Hanworth Road, day 314. Typical building heights of 2 to 3 stories with a varied mix of terraced, semi-detached and flatted properties. It's almost entirely residential, albeit with restaurant retail uses on Hanworth Road, as well as car storage and MOT repair centre just opposite the site, which I do think are compatible with both an urban and suburban area, and they are of medium to low density. To the east of the site, which is the area closer to the town centre, we do have a mix of uses. We have big box industrial on the immediate eastern edge of the site. We also have residential terraced and semis, as well as commercial properties. Building heights are mainly 1 to 2 stories, with 3 or 4 further east close to the town centre with a medium to high density. To the west, we have the Gurdwara, which is 3 stories and it isn't residential, but this is certainly a use compatible with a suburban area. We do have the industrial properties off Alice Way. Now, these properties are 2 stories, and there is an inherent residential character about those buildings. They have a mock Tudor facade and do take the appearance of a terrace property with parking in front of them rather than a typical industrial premises. And from the site visits I have undertaken, and as identified by the main issue, there isn't a level of noise or activity that is generally causing a disturbance that would make it incompatible with a suburban area. Then further west, we have Hibernia Road and beyond, which is solely 2 stories, residential, terrace, semis, and detached properties of medium to low density. To the north of the site, particularly Perkins Close, Williams Drive, and Grove Road. Perkins Close is, of course, 3 to 4 stories, is solely residential. Mr. Strawn referred to these buildings as mansion blocks within the dates in August. I wouldn't refer to them as mansion blocks, and neither does the SPD. So page A1.37 of the SPD shows that the mansion blocks are a specific typology within the document, which Perkins Close are not identified to be. Therefore, I don't consider them to be mansion blocks. And there is also very generous separation distances between these properties as established by the separation distances plan, which was provided and is core document 16.8.
You're obviously reading from something, Mr. Ringer. So you're
Yes.
just going very fast. You've obviously set out what you're going to say, and you're just running through it. Can you just give me that reference again? Because you're just
Yes, of course. We're beginning from the description of the
document
north of the
16.
site.
don't read out
16.8.
everything you've already written.
I'm not doing that entirely, Mr. Strong, but I've had a lot of
that's
time to
fine.
prepare and trying to make a succinct argument for the inspector.
No, that's fine. I just wanted
Core
to
document 16.8. That's the separation distances plan that has recently been submitted, which identifies the separation distances.
No. There was something about mansion blocks.
Yes, apologies. So on page A1.39 and A1.40 with the wider diagram of the typologies, and also on the previous page before that, sorry, A1.37 of the SPD.
Yep.
Which is document page, PDF document page 19 for the inspector. So we can see at the bottom end of where it says residential led perimeter blocks or free form, we have the lilac mansion blocks listed there. And as we can see from the diagram on the following page, as well as within page 6 of my note, that the Perkins Close properties aren't identified to be mansion blocks and therefore shouldn't be considered as such.
Okay. So anyway, you were then talking about separation.
Yes, yeah.
In Perkins Close.
Yeah, very generous separation distances of between 18.5 to 27.4 meters. And they are of a medium to low density. Then further north on Williams Drive, we have the Williams Drive cul-de-sac, 2 to 3 stories, entirely residential. Again, very generous separation distances of between 23 to 40 meters, terrace, semis, and detached properties and low density. And then lastly, Grove Road, which is entirely 2 stories, residential, semi-detached and cul-de-sac properties of low density.
Mr. Ringer, do I take it from what you're saying that you consider this to be a matter of professional judgment rather than being defined in a policy?
Not entirely. So I wanted to provide you my description of the site and then relate that back to the definitions and the other typologies suggested.
Okay. And so I've had a look around the site and I'll make a more detailed site visit. So I'll see the buildings that are around. So perhaps we get to the point that you're trying to make.
Yes, of course. So as I mentioned, the town centre should be considered urban, and then when putting the description I've just provided in line with urban or suburban, it is within 800 metres of a centre. To the east of the site, where there are a range of uses of mixed densities. To the south, there is an arterial route, predominantly residential, and to the west, there is industrial properties, so a mix of uses, although I have suggested why they shouldn't be considered urban. And then lastly, it isn't predominantly dense development, and there are a range of 3 to 4 story buildings. When comparing this to the definition of suburban, to the east, we have mainly 1 to 2 stories, although close to the town centre, 3 to 4. To the south, 2 to 3, predominantly residential, terrace, semis, and detached. To the west, mainly 2 stories, with the Gurdwara being the exception, predominantly residential, semi-detached properties of low density. And then to the north, 2 to 4 stories. And I don't consider that Perkins Close should be anyway considered urban just because it is 4 stories. It's solely residential, semi-detached, terraced cul-de-sac properties of medium to low density. So overall, when considering the wider area holistically, I think it's probably predominantly residential, medium to low density development with a mix of semi-detached, terrace, detached, flat buildings and cul-de-sacs of mainly 2 stories with some elements of 3 to 4. Now, I do concede that it is within 800 meters and along an arterial route with some mixed uses, particularly to the east. But I think holistically, when comparing the definitions to the description I provided, I don't think that the site should be categorized as urban and instead suburban.
Okay. Now, we see in that diagram that you've produced that the predominant typology around the appeal site is urban terrace. Why is it you say that fits more comfortably within the suburban typology than the urban?
Yes, so let me just pull up the page number, sorry. So again, in part A1 of that emerging SPD, there is a breakdown of these typologies.
Okay,
So
let's
starting,
sorry, let's just make sure we've got that document.
yes,
Page what, sorry?
it starts on page A1.43.
Okay, hang on. A1.
You can see that the suburban and urban terrace.
Well, I might see when I get there. Okay, PDF page 22. Which has the columns, villa, spacious, suburban, garden city, urban terrace.
Yes,
modern.
indeed.
Do you have that, sir? Yes. Okay, yeah. Oh, it's the emerging SPD. Okay, it comes after paragraph A 1.101. It's on PDF page 22. Okay. So, yeah.
Yes, so as we can see on this page, the urban terrace typology is characterized. Its urban form and street scene, a regular grid, mostly Victorian and Edwardian, tightly arranged rows of houses with on-street parking. Grid system provides a high degree of permeability and is generally easy to navigate with narrow tree-lined streets with continuous frontage and small gardens. The buildings are mostly built to a regular design in significant groups, narrow plot widths of 4 to 5 meters, with front doors serving a strong rhythm and relationship of street. Strong and coherent to the consistency of terrace architecture. This is under streetscape.
Yeah.
Streets have a narrow profile with shallow front gardens dominated by on-street parking. Low capacity for change. Typical story 2. Typical street width 12 to 20 meters, although as we've established, the street widths around the appeal site are significantly greater than that, or somewhat greater than that. The block sizes are 60 by 150 meters, which are actually a smaller footprint than the suburban typology identifies, with on-street parking, no public open space, private open space and back gardens, and then some details on the features and materiality. So, now, when I compare these key characteristics with the definition of both urban and suburban within the housing SPG, I don't consider any of these characteristics to conform with the definition of urban. The urban terraces around the site are predominantly low to medium density buildings, terrace, semi-detached and detached properties with smaller building footprints and are mainly 2 to 3 stories, which would align with the definition of suburban within the Mayor's Housing SPG. Therefore, I do accept it is labelled an urban terrace, and I consider, but I do not consider this to mean that the typology should generally understood to be urban in character.
Okay. Thank you. At Appendix ST2, Mr. Tickle sets out a number of precedents where he says the council has accepted separation distances of less than 18 to 21. Do you have any comments on those, please?
Yes.
Let's just take out Appendix ST2. So that is in the appendices to Mr. Tickle's main proof. Okay, so starting then with Charlton House, Albany House.
Yes, so firstly, having gone through the officer's reports for these applications, which aren't core documents, it does, in each case, distinguishes between separation distance between the new dwellings, which will be provided by the development, and the existing properties. Now, I think in every, having gone through the reports, in every example provided, I believe the separation distance between the new development and existing buildings are in excess of 18 meters.
Okay, so hang on. So there's a distinction, you say, between distances within the proposed development?
Yes.
Okay. So in every example, separation, sorry, could you just repeat?
Yeah, so in every example, I believe the separation distances between the new development and the existing properties are above the 18 meters recommended yardstick.
Okay.
So taking you through each example, Charlton House, 13.7 meters is the distance identified between the neighbours within the development. This is a greater distance than the distances we cite conflict with in the appeal scheme. This distance is also not directly opposite habitable rooms due to the design and orientation of the buildings here. And again, as I said, is distance within the development. Moving on to the next example, we have Cavalry Barracks. So again, minimum distance of 12 meters between the properties within the development. Again, greater than the distances that we cite conflict. Then 69 to 76 High Street, it's within a town centre, so it's a central location rather than urban. And the minimum distance between developments, between habitable rooms within the development is 7.2. So quite far below the useful yardstick. However, the officer's report does highlight how opaque and spandrel windows were used to mitigate any sense of overlooking to those compatible uses within each other. So I think the design of this specific scheme ensures that there is no unacceptable overlooking between the new occupiers.
Can I just pause you there for a moment? Well, here the appellant says, well, we can have obscure glazing as well. What's your comment on whether that would overcome the council's concerns in this case?
Yeah, so the obscure glazing and various design measures have been added after the fact, and I think in general the use of having to use obscure glazing does suggest that this is a suboptimal relationship, and even with the use of these obscure glazing, the perception of an overlook of a perception of a loss of privacy would still be there, and it would also create. And I do think that those two blocks would create a very intrusive and overbearing relationship on those habitable rooms, as well as the amenity space of Perkin Close. So I don't think that the obscure glazing in this case overcomes the harm that would be there.
Okay.
So that within the example given for 6976, there is a distance in the bottom right-hand side shown as 7.01, but this is the distance to a blank facade with no windows on there. So I don't consider that distance to be representative of an acceptable distance. And then lastly, we have Manderson House. Again, distinguishes between the new buildings within the development, the new habitable rooms, rather than the existing properties. So the minimum distance is 11.5 between the blocks, so slightly greater than the distances within the appeal scheme again. And as I mentioned, between the new occupiers, so there would be no loss of privacy that was enjoyed by existing residents. New residents would be going to the site aware of the relationship and would be able to make an informed judgment on whether they thought that was an acceptable quality of accommodation for them to reside within.
Thank you. Reason for refusal 3, please. Communal amenity and play space. Now, we do have a document now which sets out the various positions, which is core document 16.7.
Yes.
Okay, and on the first page it sets out the appellant's calculations, and on the second page it sets out the council's calculations. Can you just explain to me, just for amenity space, please, what is your figure?
So my amenity space figure for the just pull it up now. So for the northern courtyard, I consider there to be 384 square meters of communal amenity space, and then on the southern courtyard, 518 square meters.
Does that in total make up 902?
Yes.
Okay. And how does that compare to the appellants?
The appellant states that within the southern courtyard, 600 square meters of amenity space will be provided, not including the 107 square meters of play space.
Yeah.
And then for the northern courtyard, the appellant claims that there is 315 square meters of amenity space, not including what they cite to be
Right.
276 square meters of play
Understood. So
space.
their position is 915 and yours is 902.
Yes, a marginal difference.
Okay, fine. Thank you. Whether it's 915 or 902, please, what is your view as to the acceptability of the amenity space that's provided on site?
So the severe lack of communal amenity space in this case, and given the context of the site within an area of deficiency, the current level of communal amenity space would result in a number of residents needing to rely on other facilities within the borough in order to have their play, relaxation, and informal recreation.
Sorry, can I just pause you there? I should have asked you this before. What is the policy compliant figure?
The policy compliant figure, let me just pull it up for you now. So it was once the
private amenity.
yeah,
or
once the private
over-provision,
amenity
yeah.
over provision is reduced, it was 1,708 square meters.
Okay.
So a shortfall of 806.
Okay. Okay. Fine. So understood. Can I just ask you for the figures on play space?
Yes. So I consider both the appellant and I agree that there is 107 square meters of play space within the southern courtyard. And then again, a marginal difference for the northern courtyard. I believe there to be 377 square meters. And the appellant believes there to be 383.
Okay. Okay. And the policy compliant quantum?
The policy compliant quantum, so there was demand for using the GLA's yield calculator, 48.9 children this scheme would provide for. So 10 square meters for that would equate to 489 square meters.
Okay. And where does the shortfall in provision largely fall? What age group?
The application hasn't provided any play space for over 12s. So
Okay.
that equates to, apologies, I just want to.
That's okay. So nothing for over 12s, but is that the only area of shortfall?
No, it isn't. There is
Okay.
also so I just want to double check.
Okay.
A 14.2 square meter shortfall for under 12s.
5 to
So
11s.
5 to 11s, apologies,
Okay.
yes.
Okay. Thank you. Why is it that you say for play space, the on-site provision is preferable?
There are a number of policies that highlight how important it is to provide on site rather than off site. There are considerations that do encourage it in certain contexts to have an off-site contribution, but it is always preferable to provide particularly play space on site, as distance is one of the key barriers to children's play. A number of development plan policies and material considerations, particularly the play SPG, which is core document.
That is 10.2.3. Is that the one?
Yes, that's it. The play and informal recreation SPD. It does make it very clear that high quality, suitably sized play space should be incorporated into all new developments generating more than 10 children, and that's referenced in a number of points of that document. The London plan at paragraph 2.2.16.
So sorry, what policy is that
I
associated
believe it's
with?
S4. I might just check that for you. It's not S4. Apologies.
That's
I'll just
okay.
pull it up now.
How much longer do you think you have left, Mr.
10
Phil?
minutes,
10 minutes.
5-10 minutes.
Apologies. I've just lost my reference.
Okay, bear with me. Is it not S4 play and informal recreation? Core document 10.1.26?
Yeah. Oh, yeah. Apologies. Yeah. I think that's it. Yeah. I put London Plan paragraph instead of the core document in there.
Okay.
Apologies.
That's okay. So London Plan Policy S4, what was the point you were making?
Yeah,
about
so
that?
it sets out the criteria to inform the type, quantity, and location of a required place-based provision for different age groups, placing particular emphasis on securing on-site provision, and the mayor expects this to be provided wherever possible. Paragraph 3.6 and 3.7 of the Play and Informal Recreation SPD emphasize it. Apologies, I don't have the page numbers.
Sorry. So you're moving off from the London Plan now. Is that right? And back
Yes.
to the SPG.
So paragraphs 3.6 and 3.7.
Okay, bear with me. So that's core document 10.2.3. Paragraph 3.6.
Yes, on document page 20. So both paragraph 3.6 and 3.7, they do emphasize how conveniently located places are essential for children, and explicitly states that fear of traffic in particular is a barrier for both parents and children for unaccompanied outdoor play. And as we have established, there is a main arterial route that is Hanworth Road, which does somewhat dissect the appeal site from Inwood Park, which is the closest site. Then moving on, paragraph 4.10 of the SPG, which is
4.10.
on document page 51, highlights how all children and young people should have access to play within a reasonable and safe walking distance of their homes. Distance can be a useful tool in helping to identify deficiencies in provision, but it will also be necessary to identify any barriers to children accessing those areas within the recommended distances, particularly referencing that where roads are in excess of 20 miles per hour, that does neglect children and parents from taking that route to visit off-site play spaces. And there are further references throughout this SPG highlighting the importance of this document, or importance, sorry, of on-site provision.
Okay.
And likewise, both moving on to communal space, both policy D6 and of the London Plan and local plan SC5 emphasize the needs for a sufficient quantum based on the scale of a development to be provided on site.
Okay. Thank you. What comments do you have, please, about the walking distances and route to Inwood Park? And you've produced core document 16.11, which I think shows some routes to Inwood Park.
Yes, I
Let's
do.
just get that one up. 16.11. So you've shown a number of different routes here. Can you just talk us through what you're showing?
Yes, of course. So the purple route, sir, which does somewhat overlap with the blue route due to the overlapping distances, is the route that I consider to be the shorter route that parents and young people would likely take. So that would be coming out of the appeal site and walking down Hanworth Road, and you can see that the distance or the route is relatively similar to the blue line, which is the appellant's identified route. This route has been extracted from Mr. Tickle's appendix, which is ST16. So I've just followed what he's plotted on the ST16 to map out his route to the site. Now, within ST16 and within the supporting documents, Mr. Tickle claims that that is 790 meters from the appeal site. I do disagree with that measurement. When using our GIS system, I measured the exact route to be 810 square meters, so slightly above.
Not square meters, just
Sorry,
meters.
not square meters,
Yeah.
meters, so slightly above. And then the purple route, which I think is the more likely route, taking account barriers to movement. And the reason why I say barriers to movement is because the appellant relies on the parents or young people making 2 crossings at the junction with Hanworth Terrace, whereas I think it would be more likely for people to continue on a straight line and only cross the junction once. This would then lead to needing to cross at Grove Road and then coming down and following the same route as the appellant. Now, as I mentioned, the SPD makes it clear that distance and traffic are significant barriers to children's play. Now, Hanworth Road is a very busy road. It's in excess of 20 miles an hour, and as we've established, is a main arterial route. I don't think this is a particularly attractive route for parents or young people to want to walk down. And I think that when you take into account having conducted and done the route myself, it doesn't feel like a safe route. It feels very busy. And in fact, where you can see where my route adjoins the appellants again on the corner of Grove Road, that intersection there is often very busy with cars coming off Grove Road and down Hanworth Road. So I do think that both of the routes we initially identify are potentially problematic in terms of parents and young people wanting to take that route. Then
Mr. Ringer, is there a crossing proposed as part of this scheme?
Yes, there is, sir, but the zebra crossing is, I believe, on the highways plan that was provided during the Section 106 negotiations. I believe that that's more to the southwest corner of the site rather than the corner that is closest to Inwood Park.
So where on this plan would it be?
I don't believe it is there currently.
No.
I think it's essentially, I think more or less opposite where the current vehicular access is. That may not be correct, so I don't have the plan in front of me, but it's more towards that corner of the site rather than the corner of the site that's closest to Inwood Park.
So neither party is expecting the occupants to use the crossing.
I think it. To go to Inwood Park, no, I don't think that you would use that crossing to go to Inwood Park. And then the green route that I highlight, sir, is 840 meters, and I think that this is
from which point of the appeal site? Sorry,
from the closest point of the appeal site to Inwood Park, so the southeast corner. That's 840 meters taken on a quieter strip on a residential street, which I think would generally be preferred by parents and young people. And it is also important to note that so we have these distances that are all in or around the 800 meter mark that is suggested to be the maximum for over 12s. But the plate SPG does state that this should be take into account the actual route from the front door of a dwelling. Now, I haven't measured out the routes from inside of the blocks, but just by the fact that these are 800 meters, does show that there would be more for the future occupiers when taking account the route they take from their front door, particularly when we focus on block block C and D, which is at the northern end of the appeal site. Now, the appellant on page 53.
Mr. Ringer, let's not spend too long. Are you saying that there's some significance as to whether it's 790 or 820?
I think they're marginal. I think of course that they are marginal. I calculate the appellant's route to be 810 rather than 790. So I do consider it to be the distance from Inwood Park to be too far to offset the harm caused by the under provision of both play and communal space. Now, I think this is also important to consider as the just within page 53 of Mr. Tickle's proof of evidence on paragraph 04.7.26 highlights how the southern courtyard for play space is almost policy compliant at 13 square meters short, whereas The appeal site is
Whereas the northern portion-
northern courtyard, sorry, is around 100 square meters short. So those with a larger area of deficiency would have to travel farther, as is from the north of the site.
Okay.
And I think that the distances are of particular importance because I don't think it's likely that parents or young people will go to Inwood Park to use the facilities in a manner that would offset the harm caused by the under provision of communal space in this instance, and particularly because of the area of deficiency.
Okay. Okay, thank you. Now, planning balance. The Statement of Common Ground, which is core document 8.11, identifies a number of benefits and weight to be attributed to them. Are there any differences between you and Mr. Tickle on those?
I don't believe there are any differences in the weighting. Apologies, I'll just go to the correct page in
It's
Mr.
page
Tickle's-
5. Oh, sorry. No, it's the Statement of Common Ground.
Oh, the Statement of Common
Core
Ground.
document
apologies.
8.11.
No, so there are no differences, I believe, in the weighting that we provide the benefits of the scheme. I think in Mr. Tickle's proof, he does highlight that the high quality communal amenity space is a benefit. I don't agree with that because I think the quality, the communal amenity space is deficient. And I also think that he, in his proof, mentions the 10% of homes to be accessible and adaptable for wheelchair users, and I certainly agree that is a benefit. Although whilst I haven't referenced it, I don't think it tilts my planning balance.
Okay. The second item in section 8 of the Statement of Common Ground is the government policy statement on planning for schools, which is agreed to be a material consideration, includes a presumption in favour of state-funded schools and attracts significant weight. And Mr. Tickle makes the point that that wasn't mentioned in the officer's report or statement of case or your proof. How, if at all, does that policy statement affect your planning balance, given that you did have regard to the great weight policy in paragraph 95 of the MPPF?
Yes. So if we turn up the policy statement for schools, which is core document.
It's 9.2.
Core document 9.2. It states that local authorities should give full and thorough consideration to the development of state-funded schools and that they should be afforded significant weight in the planning balance. Whilst my proof or my statement of case doesn't reference that, I reference the relevant policies of the MPPF and afford it material weight as a significant weight, as it should be given. So whilst I haven't referenced the document specifically, I have followed the direction, and indeed it is also included within the Statement of Common Ground. I would also like to note that I don't think this document was referenced within the original planning statement or the originally submitted statement of case by the appellant.
Okay, thank you. Just for the inspector's note, I think it's in your planning balance section 6.57, where you say that you attribute great or significant weight to the delivery of a school. That's page 59 of your proof. Okay, thank you. Now, you'll be aware that planning policies sometimes pull in different directions, and the important thing for this inspector will be to determine whether the appeal scheme accords with the development plan read as a whole. And we've heard your view about conflict with D1415 and EQ5, meaning conflict overall. And then in your proof, paragraph 7.9, you say that a scheme that properly took account of the noise from the Gurdwara and provided a sensitive design response could deliver comparable benefits while avoiding the harms.
Yes.
There isn't any alternative scheme before the inspector. So why is it you've raised that point?
Now, this scheme, sir, would deliver significant strategic benefits that as I weigh in my planning balance, should be afforded significant weight, and there isn't an alternative in front of you for you to consider. But I do think it's essential to consider the possibility of an alternative scheme, because these significant benefits should not be delivered at all costs. The inquiry has heard that both the acoustic and design teams involved in preparing the submitted proposal were not sufficiently aware of the operational activities of the Gurdwara or the level of noise that was emitted, and indeed the cultural sensitivity of the external areas in general, which are still being referred to as car parks. And we have also heard that the design was driven by a capacity brief, which is the antithesis of a design-led approach, which a development plan seeks to achieve. Now, when the appellant was made aware of the Gurdwara's significance as a site constraint, I think only a limited attempt was made to mitigate the harm identified by both refusal reasons 1 and 2, and they relied solely on mitigation to building fabric and failed to follow the hierarchy of good acoustic design or the design-led approach. No evidence has been provided to show that alternative solutions were at least tested to determine if the benefits could not be delivered without the harm we identify, and without prejudice to other sustainable development objectives. So as I say, whilst there are benefits to the appeal scheme that should be afforded significant weight in the planning balance, and notwithstanding the fact that I think that the harm in this case outweighs the benefits, that these benefits should not be delivered at all cost, and I consider it necessary for you, sir, to consider that an alternative scheme could viably be provided.
Thank you very much, and thank you for your patience. So I don't have any further questions.
Right, okay, thank you. Well, we've been going for 2 hours, so we'll take a break at this point before we begin cross-examination. Can I just say we've gone significantly over the time estimate on evidence in chief there, and I do want to finish the inquiry this week, so could advocates please bear that in mind and try to stick to the time estimates that I've been given. Right, well, we'll just take 15 minutes now then until 12:15, please.
I failed to spot the time. I'm sure you'll tell me. And can I just say, so I hope this is acceptable. Let's see if everyone's content. We've already gone a long way in this inquiry, and I'm not going to repeat cross-examination of this witness of other things I've dealt with other witnesses so far as I can help it. And for example, I've already spoken to Mr. Ubaka and Mr. Scrivener. But unless I'm told I have to, I'm going to try and keep it to what Mr. Ringer is adding by way of evidence and where we disagree. So, Mr. Ringer, with that in mind, please do say if you don't understand my question.
Of course.
Or you can't hear it, and I'll try and repeat it. But if you do hear it and understand it, a direct answer would be most helpful.
Certainly.
Thank you. I think some easy questions first. You've explained in your proof of evidence your qualifications, and I can see from that you're not a noise expert.
No, I'm not a noise expert.
And you, I think I may say so sensibly, so far as your assessment, at paragraph 2.1, say you rely on the evidence of Mr. Scrivener.
Indeed.
You continue to rely on that evidence.
Yes.
And you would invite the inspector to rely upon that evidence.
I would invite the inspector to assess all of the evidence that has been presented in front of him at this inquiry.
Yes. Is there anything you disagree with in the evidence of Mr. Scrivener, or are qualified to disagree with?
I'm not qualified to distinguish on any specific noise matters.
Right. So I'll come back to that in a moment when we come back to policy. And you also, I think, are not an urban designer or architect.
No, I'm not.
And in that respect, there is evidence from an architect and urban designers before the inspector, isn't there?
Yes.
Yeah. And you're not a sunlight, daylight surveyor or expert in that area?
No, I am not.
Okay. You are a planner, of course.
Yes, yeah.
Yes. And as has already been referenced, you are a planner at Hounslow, and there are, in fact, in front of the inspector, the views of other planners from Hounslow, aren't there?
Yes, there are, in the form of the officer's report.
Yes. And just so the inspector can be clear as to what that planning input is, can we agree that it's material, i.e. relevant?
Yes.
Yes. And bearing in mind some of the experience that you referred to, your own experience, but the experience exhibited by those other planners, that is, would you agree, considerable experience? We've got the evidence of a principal strategic planner and indeed the head of development management at Hounslow.
Yes, indeed. Both the original officer who wrote the report and the head of development management have been planners for a longer period than I have. Yes,
and very familiar with the borough and its urban or suburban location.
Indeed, I would caveat that and say that I've been at Hounslow Council for longer than the officer who wrote that report. I haven't been at the council for longer than the head of development management.
Okay, and is it fair to say that their views as independent assessments of this scheme should carry considerable weight?
I'm not sure whether they carry considerable weight. I disagree with the original officer on a number of points relating to the main issues.
I know you disagree, but insofar as they're matters of judgment and the inspector's faced with disagreement, he can attach considerable weight to the views of the head of development management and the principal strategic planner at Hounslow.
I agree weight can be attached to their assessments.
Well, I know weight, yes, but considerable weight.
I'm not sure whether considerable weight. Yeah, considerable weight should be attached.
And we can see what their views are from the officer report. We're not going to go through that, so you're very familiar with their conclusions. I'm not going to go through it again in detail, but just to be clear, CD 6.3 tells us who those people were in case the inspector needs it. It's the report was written by Edward Nash, who I believe is a principal or was the principal strategic planner at Hounslow?
Yes.
The case officer was Kiri Shuttleworth.
For the original pre-application advice.
Yes. And the report was then presented, as often is the case for these reports, by the head of development management, Matthew Rees.
Yes.
And so that collective view, if I can put it that way, is reflected in the officer recommendation of this scheme.
I would like to, I don't think Kiri's professional judgment is reflected in this scheme, as having read the pre-app advice notes that it does not prejudice the assessment within a formal application and wasn't confirmation that the scheme was acceptable. And in fact, within all of the pre-app notes that Kiri wrote, there are still details on agent of change that needed to be addressed. So I don't think Kiri's assessment within the pre-app notes is considered. And then, yes, obviously the officer report.
I'm happy if you want to. I'm not going to go back over the detail of the pre-application notes. We've been through that in relation to what they describe and where we got to. But can I just then also, if we need to, we can turn up CD 6.3, which is I think that's the supplementary report.
6.3 is the printed minutes of the committee meeting.
Minutes. Yes, there's an addendum report, CD 6.2.
Yes.
And it's a short point. I think it was agreed by others that those views of officers took account of all of the objections that were made, including those relating to agent of change, the Gurdwara's use of the car park area, the noise assessments, every single point that's been ventilated in this inquiry.
Not every single point. There's no mention of the Nagara within his report, and there's no mention of the Nagara within the Tetra Tech responses. So it suggests that he didn't have a sufficient understanding to make that judgment.
The Nagara being the use of the drum.
The use of the drum.
Right.
Yes.
Okay. We'll come back to the use of the drum. In that respect, we're back into noise, aren't we? Yes.
Yes.
Yes. Okay. So every other element, you make a caveat about the Nagara drum. Okay, I'll come to that, see if that changes the dial. But there's no suggestion from you that their assessment is based on anything other than a full understanding of the scheme and its relationship with its surrounding area.
Yes, apart from the issues relating to noise.
Well, okay, you say I'm not agreeing with you, but I'm going to park that. Fine. And it's a very thorough report, isn't it?
Yes, it is.
Yeah. Now, when we come on to planning balance matters in due course, we can see as you say, you've attached great weight to certain things, significant weight. We'll come back to that at the very end. Just to pick up on the point you dealt with it towards the end, the great weight you gave to the delivery of the school, and you, in fairness, you do attach great weight. You invite the inspector to attach great weight, as does the appellant. The point about CD 9.2, however, I think you slightly misstated. There's a presumption, isn't there, under the ministerial statement in favour of this school development on this site? It's a presumption.
There's a presumption, and the delivery of a school should be afforded significant weight.
Yeah. Well, there are two different things, aren't there? You start off with a presumption in favour. You also attach great weight.
Yes, but I also don't think you could attach any more weight than significant to the delivery of the school.
Fine. I'm just distinguishing. Do you agree, Mr. Ringer, there's a distinction between a presumption in favour and questions of weight?
I think this document needs to be read together, and the document is there should be a presumption in favour of the school to provide significant weight. I think those come hand in hand. Presumption and significant weight are very similar.
All right, that's your view, is it?
That's my view.
So
yes.
they're not different.
Well, I think in terms of this policy statement that they're very similar.
I'll let the inspector apply, but there are two specific things identified, aren't there? The inspector decide whether they're different. You start off with a presumption in favour of the school and considering it.
Yeah.
And you also have to attach great weight to the delivery of the school.
Yes.
Okay. And I don't think any of this is in dispute, but since it was raised by others, it's common ground, isn't it, with the council and indeed you, that the school being proposed, special educational mental health school, is one which has been designed carefully to be appropriate for the delivery of the necessary environment for these pupils.
Yes, I agree. I don't have any issues with any aspect of the school delivery.
And the point made by the children and adult services arm of the council is an important one in this context of identifying the need for this specific type of secondary school provision in this location. See Mr. Tickle's Appendix 4 and the letter from the Children's and Adult Services dated the 7th of July 2023. Yes?
Yes.
And there is already a need for delivery of this school to meet existing and indeed future needs.
There is.
Yeah. And no one else has identified an alternative location or proposal, yourselves or anyone else?
No, as I said, I think this appeal site is suitable for that use.
Yeah. And we can agree, can't we, similarly, that I think you tackle this in your evidence, that whereas the allocation, I think, referred to a split of residential versus school in terms of site area, you accept that the split that's been identified 50-50 arises out of meeting the school needs first, which only requires 50, and then it's therefore sensible in principle to use the remainder for residential.
Yes, I agree.
So it's compliant with the allocation in that respect.
Yes, I don't cite any conflict with the site allocation.
Now, I'm going to try and take things as quickly as I can, but I think the key areas of difference I've been able to identify from your evidence, and it's slightly changed in relation to your examination in chief, so I'll try and keep up. But it appears to be, in regard to the reasons for refusal, there is a distinction between you and Mr. Tickle about whether this is an urban and suburban location.
Yes.
Is it is it fair to say that that distinction is not one that you make? It's not one that's shared by the other officers. They're content with what was proposed in this location.
The officer's report does refer to the site as being in an urban location.
Right. So the inspector can note, if this is a matter of judgment, that the head of development management for Hounslow regards this site as an urban location.
No, the officer who wrote this report regards it.
Okay, but sorry, the report is adopted and presented by the head of development
Yes,
management.
it is.
So it's the view of both of them.
Yes, but I don't think when presenting the application to the committee, Mr. Rees ever referred to the site as being in an urban location. That's solely referred to, I think, 3 or 4 times within the officer's report.
He was presenting the report and
Yes.
drew out the key elements.
Yes.
Of it. Yes. So
And he agreed with, yeah.
He agreed with it. So
Yes.
let's not split hairs.
No, I don't mean to.
Insofar as the inspector wants a judgment from others about whether this is an urban location, this site, the view of the head of development management and the principal strategic planner for the Hounslow is that it is.
The officer's report refers to it as being urban, and that isn't my
And answer to
professional
my
judgment.
question, Mr. Ringer, please. I was trying to simplify.
That is the answer to your question.
No,
The
I know it's
officer's
not.
report, which we've confirmed, is both the work of Mr. Nash and Mr. Rees, confirms it's urban.
Yes. So it would have been simpler to say yes,
Yes.
but unless I'm wrong, in which case say no.
Sorry,
So I
sir,
try-
he is assisting in the answers he's giving. He's not trying to be difficult, but he is entitled to give the answers he wants to in response. He's not being evasive.
Well, and that's your commentary. Can I just, Mr. Ringer, let's get to the point. All I was asking, if the inspector is interested in a judgment of others about whether this is an urban and suburban location, he's got the view of the head of development management and the principal strategic planner that this is an urban location, hasn't he?
Yes.
We'll come to why that might be in a moment, but let's just be clear about that. Right. Now, I'm going to take it as read that the statement of common ground sets out a huge amount of common ground between the appellant and indeed the council and yourself about the scheme overall, sustainability, transport, etc., where there's no issue. Correct?
Correct.
Yep. And just before we tackle the area of differences, can we see if we can agree some general points of principle as to how to deal with those differences? You referred to a number of policies, for example, and we've got calculations of play space and amenity areas, but can we just agree before we get there that there is an important principle that the council should adopt a consistent approach to its consideration of schemes of this kind under the same policies?
Yes, I agree.
Yeah. And that applies to, say, the way you choose to calculate areas for amenity space.
Yes.
Yeah. Okay. The second important point, which is reflected in all sorts of decisions, but also policy, a scheme should not be refused if it could be rendered acceptable by the imposition of a condition.
Yes.
And if matters can be controlled by condition to an acceptable level, again, that you would agree is not a reason to withhold consent.
As a general approach, yes.
Yes. And can we also agree, we've heard an awful lot of views being expressed by others. I'm not holding you to them, Mr. Ringer, but as a matter of planning principle, we should not be affected in the assessment of this scheme by those views which are not proper planning considerations.
Do you mean in terms of the objections that were raised by
Yes.
members of the public?
Yeah, do you want me to give you an example?
No, I don't think you need to. In general, a planner's role is to go through those objections, highlight what ones are planning objections with relevant planning implications and what ones are elements that don't have any significance in the planning balance. For example, someone may say that affordable housing could result in antisocial behaviour, which I believe one of the members of public did, which I'm sure we both agree is completely not the case.
Yes, and it goes a bit further than that because, for example, you mentioned affordable housing. Planning policy is very keen to ensure that affordable housing is integrated with market housing for obvious reasons.
Yes.
It's good planning.
Indeed.
The same principle applies to segregation generally, doesn't it?
What do you mean by segregation generally?
There shouldn't be segregation of communities, be it affordable or religious.
Certainly not.
No. And the same principle in planning should apply to the principle of criminal behavior or racist behavior. One shouldn't be planning on the basis of that sort of behavior being tolerated in any circumstance, should it?
No, it is against the law, and we shouldn't assume that.
No.
But I do also think it is important to take into account what we heard from a number of objectors who experience that type of discrimination and have experiences with that. I don't think either you and I or I could say with confidence that wouldn't be the case.
No, but the point is that the planning system should assume the criminal law, the sanctions are there to stamp out that sort of behavior.
Most certainly,
if
yes.
it will occur. Okay. And that principle applies to, say, use of balconies, doesn't it? I know lots of balconies in the town centre. Of course, if people started throwing bottles off them and shouting racist abuse from passers-by, that would be a breach of criminal law, various other laws.
Indeed, it would.
It's not a reason to disallow balconies, is it?
Of course, no.
There's no planning basis for saying, well, that might occur, therefore you should refuse planning permission.
On the specific note of racism, or as you say, a glass bottle being thrown across the balcony, I don't think I would assume that in any application.
No, okay. And we're just dealing with general principles here. Another well-known principle, reasons for refusal need to be clear, complete, precise and specific. I
Indeed.
think it's in the old cost circular, it's now in the PPG,
Yes.
because they represent what the appellant has to tackle in relation to the council's reasons.
Yes.
Yeah. And this case hasn't been back to committee for approval of any variation of the reasons for refusal, has it?
No, it has not.
Okay. Let's then deal with, I'm going to go slightly out of turn if it's convenient. So, well, let's deal with noise first. That is the first issue, reason for refusal 1. And I was going to be much shorter on this because I'd understood, Mr. Ringer, you were relying, and I think you already confirmed again to me, you are, 2.1 of your evidence made it clear, reliance upon the assessment of Mr. Scrivener. Is that right?
Yes.
And then when we get to the section on reason for refusal 1, which is section 6.1, to 6.11, you make clear your 6.2, your assessment draws upon that of Mr. Scrivener.
Indeed.
And your assessment, your understanding was the evidence provided by that witness demonstrated that in placing block A on the boundary, it's likely to have placed unreasonable restrictions, unlikely to be remedied by any reasonable mitigation measures. And the positioning of block A on the boundary of the site is likely to result in future occupants suffering from a significant adverse impact to the noise incident.
Yes, that's what that paragraph
That's
says.
your understanding
Yeah.
of his evidence.
Yeah.
So the inspector's got a note of Mr. Scrivener's evidence, but I just want to tackle the way you've sought to deal with it today. And there's various reference to good acoustic design you made, albeit not as a noise expert. And I'm not going to go over that again. But the inspector does have a clear note, I'm sure. Indeed, there's a recording of this. But Mr. Ringer, my record of Mr. Scrivener's evidence is that it's very different from his written evidence.
Yes, Mr. Strawn, Mr. Scrivener did concede a few points that were contained within his evidence, yes.
Yeah, but that's the assessment that you're relying upon, isn't it?
Indeed.
Right. You didn't mention Mr. Scrivener once in your examination in chief, did you?
No, because the information we've heard of this inquiry has certainly evolved. We've heard noise evidence from Mr. Scrivener, Mr. Duncan, and Mr. Leach, and the inspector will draw on all 3 of those evidence as I have tried to integrate into my chief answers.
I'm interested. Fine, and he can consider all of the evidence. I'm just interested in the evidence, your written proof. You're relying upon Mr. Scrivener. He is the only council noise expert being put up, isn't he?
Yes.
There were some other noise consultants who were satisfied with the scheme, who were instructed to review the noise assessment from Mr. Leach, but they weren't put up.
I don't think they were entirely satisfied, and as I mentioned, none of the Tetra Tech responses mentioned the Gurdwara, the Nagara drum, and as we know, there was no study of that drum that took place before the determination of the application.
Right. Let's deal. Mr. Scrivener hasn't he?
Yes,
Yeah.
he did.
And my record of it, and I'm sure the inspector will correct me if I'm wrong, is that Mr. Scrivener, having considered the evidence, and there's plenty of detail there, I'm not going to go through it all, dealt with 2 types of use of the Nagara drum. There's the use for the Gatka, which takes place once a month in the courtyard.
Yes.
Yes. For about an hour.
Yes.
And there are 3 ceremonies per year which take place, one starts in the broad area of the courtyard, and 2 flag raising ceremonies.
Yes.
Yeah. So far as the GAT is concerned, Mr. Scrivener, accepted that the noise conditions, both internally in Block A and on the balconies, were acceptable, didn't he?
Was based on British Standard 8233. And so you will have a note, and I'm just keen to ensure that these questions aren't unfairly put, because Mr. Scrivener did not depart from his overall position that 4142 was the appropriate standard.
Well, that's not my recollection, but this is let's do it as a hypothesis. If I'm right, and the inspector's got his own note of what Mr. Scrivener was content with, if the GATCA creates, when it's played once a month for about an hour in the courtyard, doesn't create unacceptable living conditions for Block A, in either externally or internally, there's not an issue, is there?
I think if the inspector determines that there is no observed impact on the occupiers internally, externally, then yes, then there wouldn't be.
Well,
but I think the evidence we heard, particularly from Mr. Leach, that it is significant. We've heard the Old Trafford decision does establish that 14 events a year isn't infrequent. So I still think that. Yeah,
Mr. Ringer, you're not. You sort of say if qualifying yes. If you don't understand my question, please say. But if you do, just answer it.
No,
say
I
no
think,
or yes, and then
I
qualify.
don't think it's a yes or no answer, Mr. Strawn. I think if the inspector considers that there's no observed impact at all internally or externally.
Right, Mr. Ringer. So you're imposing a test of no observed impact. Where is that test come from?
I don't mean to a test come from. I'm trying to answer your question.
That wasn't my question, was it?
You said if there was significant impact.
No, I didn't even say that.
Can you please repeat your question then, Mr.
Acceptable living conditions, externally, internally, which is how I put it to Mr. Scrivener. But we went through a whole load of different ways of testing that. Sol, Lowell, the inspector will no doubt have a full record of the delights of establishing what the relevant levels were. But rather than you getting into areas which I don't think you have any expertise on, tell me if I'm wrong.
No, I don't know. I don't.
If the outcome of that is that the living conditions internally and externally are acceptable by reference to those standards, then there's no issue with that taking place, is there?
I think if the inspector considers that the impact from the GATCA wouldn't cause a nuisance, then there would be no problem.
Well, that's putting another test in. So the definition of a nuisance was something that I addressed specifically with Mr. Scrivener, and he agreed that no resident experiencing those levels would have a reasonable basis for complaining about noise nuisance. Do you recall that?
I do recall that.
Right. If that's right, there's no issue, is there? If Mr. Scrivener is right about that, and that was his end conclusion, there's no issue.
If that is what the inspector determines.
Yes, but it's what your witness concluded.
Yes, but there's also contrary evidence in front of the inspector that he would need to consider.
Fine, Mr. Ringer, but you be good to your word and rely upon the assessment of Mr. Scrivener. What you should have made clear to the inspector is if Mr. Scrivener's my witness evidence is relied upon, there is no issue in the playing of the GATCA.
But as Mr. Ford said,
playing of the Nagara for the
playing of the Nagara, Mr. Scrivener never conceded that 4142 wasn't an appropriate standard. So there are still contrary things for the inspector to determine.
Well, I don't think that's right, Mr. Ringer, but I tried to move away from the detail and just focus on the words you used about nuisance. And that's what I put to Mr. Scrivener. If Mr. Scrivener is right that a person complaining about noise levels that we were talked about wouldn't have a proper basis for doing so, there is no issue.
No issue in terms of policy D13?
Well, or any issue.
Yeah, I think if it's determined that there is no impact on them, then no, there wouldn't be.
No, that's why Mr. Ringer, that wasn't the question I put to you, was it?
No
Mr.
impact. Strawn is the answer I'm giving you to this question.
Yes, well, it wasn't. The earlier answer you gave me was that if there's not a nuisance caused.
Yes.
Right.
Which the agent of change seeks to protect against.
Right. And that's the point I put to Mr. Scrivener. He accepted there wouldn't be a noise nuisance from that noise environment. No one would have a reasonable basis. If that's the position, there is no issue, however, whichever policy you look at.
If that is the agreed position.
If that's the position of Mr. Scrivener.
If the inspector agrees with that position, then yes.
Yes, but that's your, I'm looking at your proof, that's
Yes.
the evidence you rely on.
Yes, it is when writing my proof, yes.
Yes, so putting the two things together, the evidence you rely on, Mr. Scrivener's evidence on that, there is no issue, is there?
I still don't agree that there's no issue. I do think that taking account the character of the noise of the Nagara, that there will be harm to the occupiers
Right,
of
so
Block
now
A.
this is where we get to the meat of it, Mr. Ringer. You're now getting into an assessment of noise character for which you're not an expert.
No, I'm not an expert.
And it's contradicting your own witness who was content that the playing of that Gatka for those periods of time would not create a nuisance.
I don't think he ever confirmed that playing it for that period of time would
Yes,
not
he
cause a
did.
nuisance.
Yes, we went through
If
it. We
that is what Mr. Scrivener agreed.
Right. So can I come back to the point? If the inspector is holding you to your 6.2 and you're going to follow the evidence of Mr. Scrivener, it does follow. However, whichever policy you look at, that there isn't going to be an issue from that because there isn't a reasonable nuisance cause.
I don't agree. I don't think Mr. Scrivener conceded at all of the points that you say he did. And obviously, as you say, the inspector has the copy of that and will be the one that makes the judgment.
Right. Well, let's try and be a bit more helpful about this. The other three events, do you recall that?
Yes.
The position has always been of the appellant, and you can trace this through from Mr. Leach's evidence. And indeed, this is the position, I think, of the other noise consultants, Tetra Tech, that insofar as noise is caused by those events infrequently, 3 a year, do you recall that?
Yes, but it's not just 3 events per year.
What other events?
Well, you would consider the Gatka and these 3 events together. The residents of Block A wouldn't think, oh, that's that and that's the
Okay,
Gatka.
so you want
gonna
15 in
listen to them.
total, but I'm just trying to part. There's no, on the evidence I summarized from Mr. Scrivener, no noise nuisance caused by the playing of the Gatka in the courtyard. Right?
Based on 8233. I'm sorry, we mustn't lose sight of that because otherwise the questions are put on an unfair basis. And if Mr. Strong wants to say on the basis that Mr. Scrivener did concede X, then that has to be made clear.
No.
Yes, it
no,
does, because
well-
otherwise the question is put unfairly.
Okay, well,
You can go back and look at your notes.
I've got extensive notes. It was a couple of months ago now, so I will have to refer back to it. But you can both make submissions about what your position is in due course.
Absolutely. So as long as it's not put to Mr. Ringer, Mr. Scrivener conceded X, which is a matter of dispute. And so why? I mean, that can be put as a hypothetical.
Let's take out the argument. So you can even go and watch it if you want again, but I don't. You may not want to do that. Let's just take it. If I'm right, Mr. Scrivener has accepted that there isn't a reasonable nuisance caused by the playing of the Gatka on whatever basis. The addition of 3 events per year that were identified as cause, as where the Nagara is played, are all additionally they're an issue, aren't they?
Sorry, Mr. Sean, I don't understand the question.
Well, putting it simply, there are, in terms of noise events that you're concerned about, there are the playing of the Gatka once a month in the courtyard, and there are the 3 events, I think 2 take place around March and April and 1 in November.
Yes.
Yeah. And on the good acoustic design principles or any of those policies that you're referring to, stick with those 3 events for a moment. If the position is that insofar as noise is heard from those events, if the position is per Tetra Tech, per Mr. Leach, that it's not reasonable to design a whole scheme around such infrequent events, then there's no reason to move the buildings, is there? It would be completely disproportionate?
I somewhat disagree. If you are right and there is no impact, then
No, I didn't say no impact, did I?
for the frequency of those 3 events wouldn't be
didn't say
enough
no
to generate
impact,
a
Mr. Ring.
nuisance. To generate a nuisance, I believe you said. Is that
No,
correct?
I didn't even say that.
Well, can you repeat what you said then,
I
please,
dealt
Mr.
with
Strawn?
the GATCA.
Yes,
I'm dealing with the 3 events.
the 3 events.
Whatever view one takes about those noise events, whatever levels they cause, and we've got specific evidence about that, whether it's acceptable, those are infrequent events, and it wouldn't be reasonable to redesign the whole building around the use of 3 events per year, would it?
There is still the potential for them for that to cause a nuisance, and,
Yeah. Well,
and
I
that would
asked-
be contrary to the agent of change policies, which would require at least the testing of alternative layouts to see what the most appropriate solution is.
Yeah, and so I asked Mr. Scrivener about those causing a nuisance and perception of nuisance in terms of frequency, just as one wouldn't, for example, design housing around bonfire night or fireworks for an annual event in a park or Christmas events. The infrequent events don't lead one to cause one to design buildings around them, do they?
I disagree. I still think you should take that into consideration when
example.
designing the screen.
Give me an example.
An example of what, Mr. Strawn?
Where any building design is required to take account of, for example, firework nights.
I don't think I couldn't provide you with an example that's designed to take a firework night into account, but it is clear that the policies are clear that you have to have an understanding of the acoustic environment to be able to inform your design proposal, which, as I've mentioned, I don't think is the case.
Right. Now you're getting into process. I'm just dealing with the substance. So going back to process and your application of these policies, we don't accept your characterization of Mr. Leach or Mr. Mannering's evidence. But the building design did and was based upon a noise survey, wasn't it?
Not a sufficient one.
Well, you say not sufficient one, we'll come to sufficiency. A noise survey of the area. The principal noise source, the predominant noise source in the area are Hanworth Road and aviation, aren't they?
Yes, indeed.
Yeah.
But it has to be tailored. Those assessments have to be tailored to the local context, and it wasn't in this case because it didn't take account the activities of the Gurdwara.
Sorry, Mr. Ringer, it did take account of the activities insofar as they were present during the noise assessment.
But we know that Mr. Leach didn't test the Nagara before the application was submitted, so that there wasn't a sufficient understanding.
Fine, so you say, but the buildings, just take it in stages. There was a noise assessment for the building design, which dealing with the principal noise sources, on any basis, the principal noise sources of road and aviation, correct?
Yes, those initial reports did deal with road noise and aviation, yes.
And so the buildings, the windows, say on Hanworth Road, the Block A, they have acoustic design to deal with aviation and road noise, don't they?
Yes, they do.
Yeah. You say the playing of the Nagara wasn't taken into account. That was raised subsequently, wasn't it?
By who?
By the Gurdwara in response to the application.
Having gone through the officer's report and the summary of the consultations, that is clearly that and Mr. Adam was unchallenged about the fact that he let Mr. Leach know, or the design team know, that about the Nagara, and that didn't take place.
No, Mr. Ring. All right, let's get off controversial topics and just deal with the reality. When, doesn't really matter for my purposes, but when the issue is raised about the events that may cause specific noise assessments were done, weren't they?
On the Gurdwara?
Yes.
Yes.
Yes. The conclusion reached by Mr. Leach, Tetra Tech, and I would say Mr. Scrivener, but we can leave that aside, is that the building design is sufficient to deal with that noise, isn't it?
Again, the understanding wasn't good enough to be able to say that that's certainly the case.
Sorry, Mr. Ringer. their assessment, their evidence to the inquiry now
Yes.
is that the building design is sufficient to deal with the infrequent noise events from the 3 events per year and the GATCA, isn't it?
No, I don't think it is sufficiently designed still. I think,
I'm not asking for your view, Mr. Ringer. You're not even a noise expert.
No,
I'm
I'm
just
not.
dealing with Mr. Leach and
Mi-
Tetra Tech.
Mr.
Their
Leach,
views were that the building was sufficiently designed.
Mr. Leach, his evidence is that he thinks it's sufficiently designed. As I said earlier, I don't think Tetra Tech had a full understanding of the site conditions to be able to make an informed judgment.
Right.
So I don't think that should be considered.
That remains Mr. Leach's position.
If it remains Mr. Leach's position, yes.
And if I'm right about Mr. Scrivener's evidence saying that there isn't a noise nuisance caused by the GATCA or indeed those 3 events, it would also be the evidence of Mr. Scrivener.
As I said, I don't think that's completely what
All
Mr.
right.
Scrivener agreed. Taking
If
into
that
account
is the
character of noise.
case, if that's the case, so Mr. Leach's position is clear to you. Query what Tetra Tech's position is. We say it was, but the inspector can come to that. And Mr. Scrivener, you raise a question mark, fine. But if that's right, that take Mr. Leach's position, there is no even reasonable basis for reorientating the buildings to accommodate a noise effect which is already adequately mitigated, is there?
No, I don't agree. The policy is very clear about the process, and whilst you say that the appropriate mitigation is used on those elevations, we don't know that that's the case because nothing else was tested and put in front of
No,
us.
sorry, Mr. Ringer, there's already double glazing, triple
Yes,
glazing,
triple
whatever
glazing,
it is.
very
in
high specification.
Present for dealing with aviation and road noise.
Yes.
Yes. And Mr. Leach's evidence is that that is sufficient to deal with the noise from the Gurdwara. He doesn't even think it's necessary to deal with the occasional events at all.
Which I think is contrary to the agent of
Yeah,
change
but that's
principles.
fine. Well, so you say that's a difference in view. But if that's right, then there would be no basis for redesigning the building, would there?
No, because it does make clear that appropriate mitigation, whilst the appropriate mitigation for the road and the aircraft noise might have been that specification, but particularly for the western facing units on Block A, that you haven't determined that is the only appropriate outcome or the only appropriate compromise that can be delivered.
If the design of the building with the double glazing addresses the noise from the Gurdwara, that's sufficient, isn't it?
If the inspector thinks that the glazing protects residents from the Gurdwara, then yes, but then I
Right.
still don't think it follows the hierarchy of good acoustic design.
Well, I just totally disagree with that, Mr. Ringer, but let's be clear about that. If the building is sufficient in its form and the layout, and my assessment of Mr. Scrivener's evidence is correct, I don't agree with your point about the good acoustic design, but it's not a reason for refusal. One wouldn't be turning down a building for not following a process if the end result were an acceptable relationship, would you?
I do accept your point, but I still think that there will be impacts from the Gurdwara on the occupiers of Block A.
Well, so impacts is a term which I don't know how to quantify in this context, and I've had a debate about what an impact is with others and how one quantifies it. So leave that. Can I just be clear, Mr. Ringer? If the conclusion is that this building does result in an acceptable relationship, the question of process, how one got there, is not going to change the outcome, is it?
No, I do think it does change the outcome because the policies are very specific about not relying solely on insulation without testing other alternatives.
Sorry, are you saying that if there is an acceptable relationship with the Gurdwara in this design, you would still invite the inspector to turn down the scheme?
I think if the inspector,
a yes or no answer,
I don't
please.
think it's a yes or no answer, Mr. Shawn. So I'm going to do my best to try and answer that properly. I think of course, if the inspector thinks that there's no harm, no nuisance generated from the activities of the Gurdwara in any manner, then it wouldn't be. But I don't think that that's the case because the policies are very clear about a process, and it's also a matter of growth and viability.
That's not an answer. It's a very confused position, Mr. Ringer, because
Mr.
you
Ringer,
say
please don't worry about what I might think. the question that's being put, I've written down that you agreed, and it seems now that you don't agree. But what's being said is if the outcome is acceptable, then would you refuse permission because a process has not been followed to get there?
No, I agree. If you consider all outcomes of it, if the final product in general is acceptable, then you wouldn't refuse it based on the process. But the policies, not just agent of change, but the design-led approach in general the development plan makes it very strong that the process is a very important part of developing a scheme.
Well,
so I do think it does need to be considered.
Well, Mr. Ringer, just to be clear, we consider, the appellant considers, and I've heard evidence about this, we did follow the principles. But I'm trying to cut through the huge amount of time one spent talking about the process. The inspector did correct, as I understood your answer, did correctly record your answer. If the end product that the inspector is looking at results in an acceptable, I'm using the most neutral term I can, an acceptable relationship, having regard to all the factors, that is not a reason for, there's no other reason for refusing the scheme on that ground, is there?
No, yes,
yes is going to be ambiguous by
of
definition.
course. Yes, I agree. If the inspector considers there to be no impact, then that would be the case. But I still
please,
Can I
Mr. Ringer, don't say no.
No,
because you're not answering my question. Sorry, Mr. Ringer, I didn't put it as no impact, did I?
No, you didn't.
Right. I said if there's an acceptable relationship,
yes,
whatever the impacts are, if there's an acceptable relationship, there's no other reason for refusing the scheme.
If there is an acceptable relationship, you wouldn't refuse the scheme, but it doesn't mean that it complies with the policy or the one specific criteria. And it may comply with the policy as a whole, but there may still be conflicts with regards to the specific criterion about process.
All right. So insofar as there's a criticism about process, it doesn't mean that this scheme is non-compliant with the policy taken as a whole. The substance is more important than the form. Would we agree, Mr.?
I think they are equally important, to be honest. I think the development plan in general makes it very, very clear that the process is important.
Right. Are you, sorry, am I clear? I don't want to misrecord you, Mr. Ringer.
Indeed.
If there's an acceptable, if the inspector concludes there's an acceptable relationship with the scheme as it stands, no matter how one got there, that's not a reason for refusing.
Yes.
Right. Okay. Just to help the inspector on agent of change principles, and I did ask other witnesses about this. The agent of change principle is expressed in the MPPF, isn't it?
Yes, it is.
And it is expressed by reference to significant adverse impacts and unreasonable restrictions.
Indeed.
Yeah. In your answers in examination in chief, you appear to suggest there's some difference between a significant adverse impact and some other adverse impact. If you're talking about insignificant impacts, are you?
Not insignificant. I think the exact term I used was a level below significant.
Well, what is that level? Where does the inspector find this benchmark?
I believe
If it's not in the MPPF.
No, but the MPPF is read in line with the London plan, which doesn't state significant impacts.
That's not how it works. But anyway, taking the MPPF first, national policy, it would be a test of whether there's significant adverse impacts, wouldn't it?
If you tested the scheme against the criteria of paragraph 187, yes.
Yeah. Well, that's the agent of change principle in the MPPF, isn't it?
In the MPPF.
And then those significant adverse impacts, if they are caused, have to result in unreasonable restrictions.
It says that would likely cause unreasonable restrictions.
Likely, yeah, fine. Your point, I think, was to suggest, well, the London plan might be adopting a different definition to that in the MPPF.
Yes.
Yeah. And that would be unusual, wouldn't it?
I think, as I said in my chief, Mr. Strawn, they're read in line with each other. They're meant to be consistent with each other, but
Yeah.
they don't have to completely replicate the text. Now, if we look at D13 and it doesn't say significant impacts, it
Sorry,
says
where do you want to go to?
policy D13, criterion A, the
Yeah,
agent
you
of
just had to.
apologies,
You had to
apologies.
give everyone the opportunity to get there. Which bit? You got a CD reference you want to?
10.1.16.
Yeah. Hold on. Yep.
Criterion A, the agent of change principle places responsibility for mitigating impacts from existing noise and other nuisance generating activities or uses on the proposed new noise sensitive development. Then if we turn to policy D14, which is,
Can we just, before you go there, it helps you by telling you what the agent of change principle is in 3.13.3, doesn't it?
3.13.3, yes, it does.
What does it say?
The agent of change principle is included in the MPPF. The PPG provides further guidance on how to mitigate the adverse impacts of noise and other impacts such as air and light pollution.
So it's incorporating
Yes.
the test in the MPPF, which is
Yes.
one of significant adverse impacts. Isn't
Although it does state how to mitigate the adverse impacts. And then, as I was
Yes.
about to say, if we go to policy D14, it does distinguish significant adverse impacts. So I would assume if D13 intended to protect against significant, then it would have stated that.
If the policy had. Sorry.
So if
Okay, well, let's go on to the next bit. So far, reading policy D13, agent of change,
Yes.
as described in 3.13.3, it's seeking to apply the same agent of change principle in the MPPF, national policy.
is seeking to be consistent with the MPPF
Yes.
as the London plan is as a whole.
Right, fine. So it's seeking to be consistent with, and we agree that's a test of significant adverse impacts.
The MPPF states it's significant,
Yeah,
but the London plan doesn't state significant adverse impacts.
Well, okay, I'm just seeing the inspector's got to decide if there's some, I mean, this would be quite significant, of course, wouldn't it? If
Yes.
the London plan has a different agent of change principle to the national policy.
But I don't think.
Sorry, Mr. Ringer, that would be quite significant, wouldn't it?
Yes, it would be. But if
Right,
we read the
let's
policy, you wouldn't refer to a nuisance generating activity as causing a significant adverse impact.
Sorry, I don't know what you're now referring to. I'm just looking at the two
So criterion A of D13,
criterion.
A.
Yes.
So places responsibility for mitigating impacts from noise, from existing noise and other nuisance
So
generating
it's got
activities.
to be a noise nuisance.
So I don't think the way nuisance generating activity is the same as a significant adverse impact.
Right. Where's your basis for saying that? Where's your basis that a noise nuisance can be insignificant?
It's my professional judgment that a nuisance doesn't have to.
Your professional judgment.
Yes.
As a what? An environmental
As a planner.
health officer?
As a planner.
Right. Okay. So in order to get to a conflicting position for the London plan with the MPPF, you read noise nuisance as covering things which aren't significant adverse impacts.
Yes.
Right. One alternative way of reading it, one might say, I'm going to suggest to you entirely logical way, is that noise generating uses consistent with the agent of change principle has to be ones based on significant adverse impacts.
I don't think so. I think if
I know you don't think so, but that is another way of reading these paragraphs.
No, but if exactly, if policy D13 intended to reference significant adverse impacts, it would have done so.
Well, it does. It refers you to the MPPF.
To the but it doesn't
But
say significant
just to-
adverse impacts.
Right,
The next
so,
policy
hold on.
D14 does reference significant adverse impacts. So I would assume if it applies to the same thing, then you would do that.
So can I just be clear? Your assessment of a noise nuisance arising could come from an insignificant noise.
I think so. Yes.
You think
Whether
so?
it's insignificant or a level below significant.
And how does one assess that?
Well,
Is this an area goes outside your expertise in assessing noise impacts and their,
I'm certainly not able to make an assessment, like go and conduct a noise assessment and make a noise assessment, but I can read the London Plan policies, and my interpretation of this policy is that it doesn't have to be a significant adverse impact in order to create a nuisance.
right. And just to be okay, the inspector's got your view and others' views. What's the test then?
The test, it doesn't. The policy doesn't distinguish a threshold, but there's enough evidence in front of the inspector to be able to determine if there is a significant impact. I'm not sure what that test would be.
No, this is about non-significant. This is something lower. I've got significant adverse impacts in the agent of change principle. You say you can have a noise nuisance which isn't based on any significant noise impact, could be insignificant. What's the test the inspector's applying then to noise nuisance then?
I think there is some guidance. If I could just have a look at the core documents lists, particularly in the noise guidance. Apologies, I'm just trying to find the core document.
I've gone over the 1 p.m. Sorry. Is this going to help us identify what a noise nuisance is?
No, but I think there's distinguished levels in the Pro PG as to what to how it impacts, and there are varying scales of that significance. I just wanted to check before providing my answer to you.
Yeah, I'm just trying.
So the Pro PG, which is core document 12.8, it does set out varying levels of impact. As I said, I'm not a noise impact,
No,
so I'm
you're
not
not.
sure how that's impacted. But as I said, I don't think that the agent of change D13 policy is triggered by only significant adverse impacts.
Right. You said that several times, so I'm trying to give the inspector some assistance as to what you say the test is. I've got noise nuisance, and we've got evidence from others about what that is. Anything else you want to draw the inspector's attention to?
No, I have nothing to add.
Right. And the same point about, I think we'll stop in a minute of that, but just to complete the picture, policy D14. D14A1, avoiding significant adverse noise impacts.
Yes.
And then reflecting the agent of change principle.
Yes.
It means you're responsible for the agent of change principle places responsibility on the person bringing the noise, coming to the noise.
Yes.
Yeah. Nothing there that suggests that there's a lower threshold.
Well, it's
significant.
Two different criterion. It says reflect the agent of change principles in D13, and we know that D13 doesn't mention significant adverse impacts.
Well, okay, you're back to a chain of then reading D13 with 3.
No, I don't intend to read it out, but they're two separate criteria, and it doesn't say avoid adverse impacts by reflecting agent of change principles. It's two separate points.
Can we agree that just simply takes you back to what the meaning of agent of change principle is in D13?
Yes.
If it means MPPF C3.13.3, then it's the same test.
But I think it would have distinguished between significant adverse impacts if that was the intent of the policy.
All right, that's your view. Okay.
That's my view.
I'm conscious I've gone over my time, but sorry, not my time, but the 1 o'clock.
No, you've got a while yet, I think. But fine, we'll stop there. We're an hour in, so we'll come back and continue after lunch. Mr. Ringer, obviously cross-examination's ongoing, so please don't speak to anybody about it. Right.
I'm happy to have a 45-minute lunch if everyone's happy, bearing in mind we're a bit behind time. I'm not necessarily behind time, but
No, I
if
think we'll stick with
you're
an
still-
hour, and that's fine. Right, thank you. We'll adjourn until 2:15, please. Right, thank you, everyone. Let's resume, please. Mr. Strawn, let's continue with cross-examination.
Thank you, sir. Good afternoon, Mr. Ringer.
Good afternoon, Mr. Strawn.
I think I've explored everything I need to with reason for refusal one, bearing in mind the other evidence we've heard. Apologies, I won't be repeating everything again with you.
No problem.
Let's move to reason for refusal 2. And as part of that, pick up this debate about urban and suburban. Can we agree, in fact, the issue of the location of the site and its character is also relevant to the question of amenity space?
I don't think there are any policies that expressly highlight the difference. But yeah, I think in general, yes, it would be acceptable to say that sites in a central or more urban location may experience difficulties in providing a certain level of communal space.
Yes, it's a factor that the council regularly, as we can see from some of the reports that Mr. Tickle has identified, takes into account when deciding whether or not to accept amenity space which doesn't meet the full quantum.
Amongst other things, yes.
Yeah, amongst something. So it's relevant to both.
Indeed.
Okay. On the issue that's arisen before let's deal with reason for refusal 2 first. The paragraph, I think, 5.61 of your evidence, just so we can see where the battle lines are.
Yes.
If you got that, you refer to the Mayor of London's housing SPG, paragraph 2.3.36, and you talk about in the midway through that paragraph, planning guidance for privacy. Well, let's start at the third, fourth line down. Designers should consider the position and aspect of habitable rooms, garden and balconies, and avoid windows facing each other where privacy distances are tight.
Yes.
So first of all, it's dealing with windows facing each other, isn't it?
Yes.
And secondly, it's where privacy distances are tight, and then that's where it explains in the past, one's talked about achieving a minimum distance of 18 to 21 between facing homes, between habitable room and habitable room.
Yes.
So the Mayor's SPG is facing windows of habitable room, habitable room. And that's where in the past 18 meters has been identified. But you go on to quote from the document, although you haven't shown it as quotation, it's pretty accurate. These can be useful yardsticks for visual privacy, but adhering rigidly to these measures can limit the variety of urban spaces and housing types in the city being London.
Yes.
And can sometimes unnecessarily restrict density.
Yes.
So the guidance about not applying it too restrictively isn't limited to urban areas, is it? It's applicable to London as a whole.
It says these can be useful yardsticks for visual privacy, but adhering rigidly to these measures can limit the variety of urban spaces and housing types in the city. So to me, that says urban spaces within the city. It doesn't say London as a whole.
So are you suggesting that this guidance, therefore, is limited to those areas defined as urban in the housing SPG, or is it a general guidance about applying too restrictive standards in the city of London having an effect on urban spaces and housing types?
Well, it does make the clear distinction about urban spaces, and I do think that this is what should be sought to be achieved, and we apply it flexibly where it can't be for those reasons in
Yeah,
urban areas.
It's a simple question, Mr. Ring. I just want to know your answer. Is it limited to urban locations in London? Is that your evidence, or
The
is it
18 to
applied-
21 meters distance?
No, the principle of flexibility.
No.
Right. So even if the inspector concludes this were a suburban location as for the purposes of the SPG, one should still be applying this guidance with appropriate flexibility in any event.
Indeed, less flexibility than in an urban or a central location, but with flexibility nonetheless.
All right. So, okay, that's helpful. So then let's just see what's actually an issue now. ST15, sir. Is that probably the best diagram? Mr. Tickle's Appendix 15, ST15. No, ST15. Let me know when you're... Yep. Everyone got it?
Yes, I do.
That's the overlooking mitigation plan, is it?
Yes, sir, it
Yes.
is. And it shows block D and C and their relationship with Perkin Close.
Yes.
And as I've understood it, but correct me, Mr. Ringer, if I'm wrong, this is the only privacy distance where you're expressing concern in relation to this piece of guidance.
With regards to 13 and 28, is that your question?
Well, this relationship, block C and block D, but there's no other part of the scheme that you're concerned about in relation to habitable room
No,
relationships.
I'm concerned with the relationship with Perkin Close, and as you know, I'm concerned with the relationship with the Gurdwara as well. But in terms of the habitable rooms, yes, it is just 13 to 28.
Well, the relationship with the Gurdwara, you're not concerned with any habitable room relationship.
No, as I said, the habitable room relationship I'm concerned with is 13 to 28.
That's fine. And then you clarified in your evidence that you're not concerned or you're satisfied with the relationship in relation to block D and 29 to 44.
With the habitable windows, not the amenity space, or for either properties, for both properties.
Right. Where do I find that distinction in your evidence?
I believe I do reference the
Now, where do I
garden
find
space.
that this is a concern only about the amenity, not 29 to 44?
Well,
Maybe it's there. I just didn't.
In my proof of evidence, I don't cite conflict with 29 and 44 in terms of the habitable room distance.
Right.
In paragraph 6.12 on page 44 of my proof, I mentioned how
6.12. 6.12. You say both properties.
So it may assist that Mr. Ubaka put in a note before we began in August, confirming that he didn't have any concerns with the relationship between Block D and the building facade of 29 to 44, but his concerns in relation to the amenity space remained.
All right. So 613 requires correction, doesn't it? Because you're alleging you refer to the 16.7 meters there, but we can be clear you're actually happy with that relationship.
yes.
Is that sufficiently clear for you, sir? I mean, I just wondered. Reading 613, one would read it as if you're unhappy, but you're not. You're happy.
No, certainly. And as Mr. Fuller said, Mr. Ubaka's note following in advance of his examination in August, it explained the council's position a bit more detail.
So on this topic, you're similarly relying upon the analysis of Mr. Ubaka.
No, as a planner, it's very much what we assess separation distances and privacy and overlooking. Mr. Obaka was appointed to act as a design witness and give evidence, and I'm very much capable of assessing impacts on privacy.
Okay, so back to the plan then, ST15, so the inspector knows what's an issue. That relationship we can see on the plan there is an acceptable one as between block D and 13 to 28 Perkin Close. Correct?
With block D and 13 to 28 Perkin Close.
Yep.
Yes, I don't think that the habitable rooms in block D would impact 13 to 28 Perkin Close.
So I think we had offered obscure glazing, but you don't think there needs to be any. Is that right?
For the block D?
Yes.
No, I think for...
there was the potential for the bedroom window to have a window treatment to minimize views, but you're not concerned about that.
No, as I said, there's still an issue of the amenity space, and whilst I think obscure glazed windows is a suboptimal design approach, I think it would be important to assist in reducing the impact on that amenity space.
So, okay, and the amenity space issue arises from because the obscure glazing along block D is proposed in the sort of corridor areas. And you're suggesting what? Having one bedroom window overlook an amenity space that's already overlooked by, I think, more than 16 windows from the existing block is unacceptable.
It's not just one bedroom. It's okay. One bedroom per floor in that corner. There are two bedrooms facing that way. So two bedrooms on each floor.
Which bedroom? Sorry, there's one bedroom, isn't
there? Is it not there's one on the corner as well? I mean,
will you tell me what's unacceptable?
There is one on the corner. I'm just explaining that there are two windows on each floor rather than you said one to a habitable room. But the issue is still again, it's a suboptimal design approach to have to put that on a window. There will still be issues of a perception of overlooking, certainly, and particularly a really impressive and overbearing nature on both of those properties. With regards to the actual distance to the habitable windows, I think they're acceptable.
Right. So the windows are acceptable, but sorry, I don't think you're saying, Mr. Ringer, you'd be turning down planning permission for this scheme as a result of any part of this relationship with 29 to 44 Perkin Close, would you?
Not just 29 and 44 Perkin Close. When you compound all the relationships or the harm you've identified to 13 to 28, as well as a Gurdwara, that would warrant a reason for refusal.
So you say, but so far as the relationship between 39 to 44 and in the amenity area, you're not suggesting you would be turning down this scheme?
If the scheme was in complete policy accordance with every other policy, and that was the one issue of this appeal scheme, then the benefits would outweigh the harm if it's just on that.
All right, and the harm you're saying arises to the amenity space. Let's be clear. In fact, on this, it's one bedroom window which would be. And it's currently alignment looking into a part of an amenity space. Is that right?
One bedroom per floor, and then
so
all of the circulation windows as well, which I appreciate aren't habitable rooms, but still adds to the perception of an invasive relationship.
Well, even with their obscure glazing?
Even with obscure glazing. Because they can still be openable as well, so there's no guarantee. And if you have obscure glazing on a bedroom, people want to open their bedroom windows. Likewise with the living kitchen diner on block C.
I discussed this with Mr. Ibaka. This is all capable of control by condition, isn't it? Insofar as it's thought necessary, it's capable of control by condition. The way the windows open, a fin, or even a directional window are all capable of being controlled by condition under the condition that's proposed, aren't they?
I think even regardless of
Mr. Ringer,
I'm answering your
questions. Are capable of being controlled by condition.
Indeed they are. Indeed they are. But that would not outweigh the still perceived overlooking and the intrusive nature of this very long elevation that fronts both of these properties.
Right. So we're now into perceived overlooking and perception of overlooking. Is that right?
No, I still think actual overlooking can take place, particularly when we take account for the roof terraces on the top of block C.
right? Let's just try and stick with what we're talking. You want to introduce the roof terraces now. They are also capable of being controlled by condition.
No, I agree, but
Right, so
I
what-
do think it's suboptimal design approach.
Well, okay, you come back to suboptimal design approach. We disagree. Your other officers disagreed, didn't they?
The original officer, yes.
Well, not the original officer and your head of planning.
Yes.
So there can't be any criticism of the applicant or the appellant now in putting forward a proposal that the council officers considered to be optimal design, or not suboptimal, but perfectly acceptable design, can there?
I disagree, Mr. Strawn. I don't think that.
You disagree with that?
Yeah.
You're criticising the appellant for coming forward with a scheme which
No,
they had
I don't criticize the appellant
Well, that was my
for
question.
that. No, okay, I don't criticize the appellant, but
Right.
I still think the relationship isn't acceptable.
Right. But your point, I think, was a sort of, again, a process point about suboptimal design. Just be fair about this, Mr. Ringer. This went through many pre-application processes where the relationships were considered, changed, altered, and eventually a design reached which met with the approval of the council officers and indeed the head of planning.
But not the council. The members
I
took
know
a different
that.
view.
I know that. But the appellant can't be criticising producing a design which was acceptable to the officers, albeit council members have then disagreed. But there can't be a process criticism, can there?
You wouldn't criticize the appellant, but you'd criticize the scheme. I'd criticize the scheme that's in front of me.
You say, but in relation to that, you then need to properly consider what can be controlled by condition, don't you?
Indeed.
And all actual overlooking can be controlled by condition.
Through the use of obscure glazing, windows could still be open, whether that's by a little bit or not. I don't think it completely overcomes the issue.
Which bits? Where's the actual overlooking going to occur?
I think
Mr. Ringer,
the primary issue is still block C. In terms of
I'm going to
those
come to
windows
that. I can't deal with everything. I'm doing block D.
Okay, for block D, as I said, the key issue for block D is the amenity space.
Yeah, but sorry, actual overlooking, assuming, which we don't agree with this, that surveillance of amenity space is somehow harmful. Actual overlooking can be cured by condition, correct?
If all of these windows are, but through conditions, secured to be completely fixed shut and obscure glazing, then that would prevent any overlooking into that, in any actual overlooking into that area. But that does raise other concerns in terms of quality of accommodation for myself. As I said, I think that's suboptimal, and to have to fix shut a window and obscure glazing.
Why do you have to have a window fixed shut?
Well, that I think it suggested that was the case. If it's obscure glazing, you can still open it. Then you would be able to see.
No,
to
only
see
if
through.
you can open. If what happens? I don't understand your point, Mr. Ringer. You must be aware of them very many ways. Windows can be
a little sliver.
Well, you say a little sliver. If you want it for ventilation, you can open it.
But some people might not want it just for ventilation, but outlook and aspect as well. Outlook and aspect is a key aspect of designing high quality and internal conditions.
Right. I'm just testing whether this is reasonable. Block D, this is all of the windows in the circulation space. Is there any difficulty in your mind, of those being obscure glazing? To the extent one wants ventilation, they can be controlled in the way they open, but they don't actually need to have any actual overlooking of the properties, do they?
From the circulation space, no.
Right. The bedroom could be angled, couldn't it, in the way other windows are, if it were considered to be a problem?
It hasn't been presented at this point. If they are angled away, as I said, if they're fixed shut and you can't see through them, then there wouldn't be actual overlooking. So if they're angled away, again, if there was no view of Perkin Close from those windows, then there wouldn't be any actual overlooking.
But sorry, no view of Perkin Close. You're happy with the 16.7 meter view of Perkin Close. You're just concerned about the amenity area.
Yes.
Right. So any arrangement which just angles it away from the amenity area and it can open is perfectly acceptable.
Yeah, if you couldn't see that amenity area at all, then there would be no.
And what's the basis for your professional planning view that being able to see it into a communal amenity area is harmful in planning terms? Where's that set out in any policy?
There are policies about, and I believe it is in the National Design Guide as well. The policies are about protecting amenity. You referenced that overlooking of amenity space is encouraged, and it certainly is within a development. You want to have that passive overlooking, and indeed, as you mentioned, there are those windows looking into that space as well. Those parking close properties have established that relationship and community, and that sense of overlooking that their building has on their space is acceptable. Now, when you put this mass on there, that there is a need to protect the amenity of existing residents, which lots of policies do distinguish.
Where's the policy basis for that?
So policy D3 shortly responds to a site's context.
Yeah, but that's just raising the question.
GD2 rounded approach to the way in which neighbours operate. CC2 adequate levels of privacy.
Hold on, we're going to spend a lot of time. If you're going to just look at general principles, that's not going to answer the question. Mine is a specific question. That there's some harm from, in this case, perceived overlooking. I think you can cure the actual overlooking if you're worried about it, that's harmful to a communal amenity space.
There is paragraph within the National Design Guide, core document 9.11, PDF page 11.
Yes.
Just put it up now.
CD which, sorry?
9.11.
Yeah. Where are we going?
Just looking for the exact point now. Apologies, I've seem to have lost the point that's in the National Design Guide. Paragraph.
I've got page 27.
I'm on page 39.
Do you want? Okay, we'll go there.
If
We'll
you
go
could.
back to page 27. Do you want?
No problem. Paragraph 126.
Yeah.
The quality of internal space needs careful consideration in high density developments, particularly for family accommodation, where access, privacy, daylight, and external amenity space.
Right. So that doesn't say
important.
what you said.
No, it doesn't. Apologies.
Do you want to go? Just
No. If you go to H2, apologies, Mr. Straw, in paragraph 129, it expects amenity spaces to have a reasonable degree of privacy.
Yeah. So reasonable. It's not suggesting any overlooking is prohibited.
No, but in this case, I think that the relationship with Block D and that and the amenity space wouldn't respond. They wouldn't have that reasonable degree, at least by way of perception and the invasive nature of that elevation. Anyway.
What? So this is not even actual privacy; it's perceived privacy.
No, as I said, this says amenity spaces should have a reasonable degree of privacy.
Right. Okay, and just go back to page 31, dealing with communal amenities, communal spaces.
Yeah.
This is all about surrounding homes providing overlooking, isn't it?
Yes.
And page 27, another document, open space well overlooked by homes.
Yes, within a development. So you would design a development to, as the appeal scheme has, to overlook the communal amenity space, but you wouldn't design it to overlook neighbouring communal amenity spaces because they deserve that degree of privacy.
Right. Okay. So can we agree, if you're interpreting the word reasonable, perceived overlooking, i.e. no overlooking, actual overlooking, could hardly be said to be unreasonable, could it?
I disagree.
Okay. All right. And go back to an ST15.
Yes.
Incidentally, is there any, for the purposes of the inspector applying policy, London plan policy or local plan policy, any support for that notion, your disagreement? Just to be clear, I mean, other than general policies which talk about being well designed, etc., but to the effect that even glazed, obscure windows overlooking communal amenity areas are unacceptable.
I still think that
And
perception of privacy is an important thing, and I think there is a degree of actual overlooking there. The perceived privacy.
That wasn't
and
my
the-
question. I was asking for
Mr. Ringer,
policies.
it's not helpful to repeat the same thing over and over
I
again.
do
and
apologise,
to
I don't
restate
mean
your
to.
case every time you get asked a question. I'm aware of that. So if you could try and focus, please, on the questions that are being put and the specific answers.
Indeed,
to
sir.
those.
Apologies, Mr. Strong. Please could you repeat your question?
You've advanced what I'm going to suggest as a personal view, which I'm not encountered before, but that's fine. But is there any assistance for the inspector, any local plan policy or London plan policy which expresses that view, i.e. perceived overlooking of any communal amenity area is unacceptable? Actually, it's more qualified that it's perceived overlooking from another development of a communal amenity area is unacceptable.
No, I don't think I can provide a policy specifically at this point.
Any example of Hounslow refusing a scheme on that basis, other than this one, in the material before the inspector?
But that isn't the refusal reason. I don't think there is a case in that I can provide an example with a perception of overlooking being the sole reason for refusal.
Okay, let's do block C then, please. The guidance that we're talking about here is the 18 to 21 meter yardstick, and you talked about a 9 meter relationship.
Yes.
Where are these 9 meter relationships?
First of all, I do take issue with some of these the annotations on here in terms of the distances, but I think an easy example for the inspector with the 9 meters is if I could ask him to turn up core document 1.2.20, which shows a distance of 9.3 meters between the block C and 13 to 28.
1.2.20.
Yes.
Right. Go there. Where am I looking? Which section?
On the top right. It is labelled 11 Perklin Gardens, but I believe given the relationship of Block C, that could only be 13 to 28 Perkin Close.
Right.
Section FF.
So where's the habitable 9.6 meter relationship on the?
I don't believe I said that the habitable distance was that. I think I specified the distance between the 2 blocks.
Right. Well, that's not what the London plan is dealing with, is it, in relation to privacy? It's
No.
dealing with windows facing each other,
Indeed.
which are habitable rooms.
Yes, and having measured myself from these plans, I do think that there's some slight discrepancies, as there has been for measurements throughout.
Right. So, because you referred in evidence in chief to these 9 meters being, halfway below the 18 meters. That's just a false comparison, isn't it? That's not what the guidance is doing. It's dealing with privacy between face-to-face windows of habitable rooms.
Yes, indeed.
Right. What is the relationship what are the habitable room relationships which are face to face that you're concerned about?
So where it is annotated to be 11.5 meters, I consider that to be 11.02. And likewise, where it's labeled 12.8,
Right.
consider
That's
that
just
to be 12.6. So marginal differences.
marginal. Okay, let's not argue about the marginal differences. First of all, they're not face to face, are they?
That is the distance measured between them.
Yes, they're not face to face windows, are they?
But they're not directly in a parallel alignment with
Yes,
each
which
other. No.
matters for privacy, doesn't it? Because in order to look in, if I'm looking from the bedroom with the 11.5 meter distance, I'd have to be standing at the window looking to the right, and I'd be looking into a secondary window of a living dining room.
Secondary in terms
into
of
the
daylight and
corner of
sunlight.
the corner window, into the corner of the room.
Yes, you don't just look straight out of a window,
Yes,
though.
so it matters, doesn't it, in any assessment? If it's not face to face, if it's oblique, it may well be
But there would
applying
still
these.
be a view
Hold on,
from that
Mr. Ringer.
direction.
Applying these are talking about face to face relationships, aren't they?
Yes.
This isn't a face to face relationship, is it?
No, it talks about distance between habitable rooms. It doesn't say they have to be directly in front of each other for there to be a level of overlooking.
Well, I took you to the guidance. It's talking about face to face. But
I
can we
don't think
agree,
it
Mr.
explicitly
Ringer, there's
says
a
that.
difference if the inspector's approaching us in the real world and concern about privacy, there's a difference in terms of a privacy relationship, the more oblique the angle is.
With the more, if you continued that angle, then it would gradually reduce. But still, from this relationship, there would still be that degree of overlooking.
Yes, that
You would still
degree,
be able
that
to
begs the
see
question. You can, yes, right, so there's a degree. I discussed this with Mr. Ibaka, but don't you agree? If, and we don't think for a minute this is an unacceptable relationship, if there were any concern, it can be addressed by a condition, a fin, for example, making it even more oblique.
I mean, I think a fin would have a contract impact on other considerations as well, such as the design of that elevation. If we're continuing having to add these external alterations to try and mitigate that relationship.
Yeah, we don't think we need to mitigate. It's just you and the council members for the first time. They don't specify the problems in their reason for refusal. So it only comes when we get your evidence. You then express what the issue is. So that's where we are in the design equation. We don't think it's necessary, but if the inspector were concerned about it, a fin just making it even more oblique, doesn't even have to be a very significant fin, because you just attach it to the side window. Mr. Ibaka gave some examples. It makes it virtually impossible to see into that.
It would reduce it would reduce the visibility.
So it'd be capable of addressing, if it were a concern, the actual overlooking into that room, wouldn't it?
Yes, but I do go back to the point that having to put opaque windows onto a
not dealing with opaque windows.
Translucent glass onto a bedroom or a living kitchen diner provides a poor quality of accommodation. I would say that.
Why is that's not right, is it? Just look at the other windows where there were issues about overlooking of
Mr. Strawn. I think I'm quite clear about these relationships now. So
right. Okay. The only other one on that block C is the living, dining, kitchen room, which is a secondary window, and again that could be obscure glaze, can't it? If it was thought to be a problem, we don't think it is.
Yes, I think it is.
All right. So that's before we even get into the debate about urban and suburban. I think we're agreed that conditions can control any actual overlooking of concern in this scheme before we even have a debate about urban, suburban. Actual overlooking.
But the refusal reason isn't just about actual overlooking, Mr. Strawn. I think these conditions.
Can you just stick with my question?
I'm trying to, Mr. Strawn. I'm trying to. I think these, if these are the solutions to prevent any actual overlooking, then yes, that would be mitigated for as a refusal reason. But as these are being introduced, I do think that has implications on the quality of accommodation that's being provided to those dwellings.
I've heard it a number of times, Mr. Ringer. Please, can we just try and
Yes.
focus?
But he's been asked the same question. He's entitled to answer, sir.
Well, as I've just said,
Well,
I'm
yeah.
quite clear. I've had
Yeah.
the answer several times now.
Yeah.
Shall we move on, please?
The insofar as there's any residual difference between us, Mr. Ringer, on either actual or perceived overlooking, the inspector's heard enough evidence on that. We get into this debate about urban and suburban, also relevant to amenity space. And let's see if I can deal with that relatively shortly. The origin of this, as you just indicated, is the Mayor of London's housing SPG. Correct?
Yes.
Because the Mayor of London's housing SPG is what you're referring to in relation to privacy distances. Yes?
Yes.
And we've got that document, CD 10.2.9, and page 44 has the categories of settings: central, urban, suburban. So it's page 44 of 169, CD 10.2.9. Yeah.
Yes.
And this document is identifying for London an approach to housing, and identifies three general categories: central, urban, suburban. And I think I've got to the position, Mr. Ringer, you disagree, but everyone else I've asked and everyone else who's given evidence so far has agreed that this would be described as an urban location. Mr. Rubaka?
Yep.
Agreed. Ms. Cook?
Who is a daylight and sunlight consultant?
Yes.
Yes.
The other council officers, we went through that earlier.
Indeed.
And of course, Mr. Tickle. And they did that simply by taking the definition of urban in this location: areas of predominantly dense development such as, and what's meant by predominantly dense development includes terraced houses.
Yes, but I don't consider any terraced house to mean that it's in an
No.
urban environment.
Not necessarily, but that's what they're referring to, as opposed to, say, detached and semi-detached.
Yes.
And it also mix of different uses.
Yes.
Yeah. And we also then have the location with 800 meters walk distance or along a main arterial route.
Yes.
So we can have a debate about, and the inspector make his own judgment, but on any basis, there are a number of boxes or a number of those examples which are ticked for this site.
Yes, terraced houses.
Terraced
2
houses.
to 4 stories, 800 meters on an arterial route.
Well, let's just do a mix of different uses. That's going to include the allocated use for this site, isn't it?
Yes.
Which is educational and residential.
You would find a school in a suburban area, and as I said,
That's
my
not the
chief
point.
in my proof, I don't cite any conflict with what's on the site, but this suburban and urban is how I have categorized the wider area around it.
No, it doesn't matter. You find houses in urban and suburban
Indeed.
areas. You find schools in urban and suburban areas. You find industrial estates in urban and suburban areas. That's not going to help us, is
Yeah.
it? What it's identifying is a mix of uses in the area, and there is a mix of uses in this specific area.
Primarily to the east of the site, and then the industrial properties on Alice Way. The majority of the area around the site is predominantly residential.
Well, you've left out the site itself, which is allocated for a different mix.
Yes.
Yes, educational and residential. The Gurdwara, which is a community use, and the business premises on Alice Way. It's a classic mix of different uses.
My
isn't it?
assessment of this
Sorry, Mr. Ringer, I'm not asking for your assessment. I've just put to you a number of different uses in in and around the site. It's a classic mix of different uses. Isn't
Yeah,
it?
I just want to. My assessment of the area does not
Yes or
include
no?
what's on the site at the moment. There are a mix of uses, but as I've explained, it also fits within the suburban definition
Okay,
as
so
well.
you've ignored what's proposed for this site itself. You shouldn't ignore that because that's an allocated part of the development plan, that there should be a mix of education and residential on this site.
Most certainly, but
Right.
summarizing the
Back to
character
my-
of the area at the moment, that site isn't adding anything to the character of the area. But the site allocation anyway doesn't add anything to the character of the area as it stands.
Right. What's the previous use was industrial, wasn't it?
The previous use, and there's no building on the site at the
I
moment,
know,
so
because
it's not.
it's been demolished, but it was industrial.
Yes.
Right. So this location is try again. It's a classic example of a mix of different uses in and around this appeal site.
There are industrial properties
and
to the
around.
east, not in it, but there's not a mix of use. There's no use of the appeal site at the moment.
Right. I'll let the inspector judge whether you take into account the appeal site, even without the appeal site. Hold on, Mr. Ringer. Even without the appeal site, there's a community use to its west. There's an industrial use to its east. There's some other uses on Hanworth Road, including retail.
Yep.
It's a classic mix of different uses.
But that is not the only point
Is that
within
right?
the
Yes
urban
or
area.
no?
There is a mix of uses, and I have addressed that in my
Right,
proof
that's
of
my
evidence.
only question to you.
Yes,
Right,
I
so-
answered.
Well, now you have. Okay. So we've got terraced houses. We've got a mix of different uses. Medium building footprints. It doesn't tell us what that is, but and then typically buildings of 2 to 4 stories.
Yes.
Yeah.
But
And we're located within 800 meters, not just of a district centre, but actually of a metropolitan centre.
yes, but then if we look at the definition of suburban, it's predominantly medium to lower density, as I've shown on the floor area ratio density plan in my note on the emergent SPD. It's I think a very equal mix of terrace, semis, detached, and cul-de-sacs that surround the site, and they are also 2 to 3 stories. They're only 4-story property within the vicinity of the appeal site is Perkin Close, and I think there are certainly mitigating factors that would preclude that from being called suburban.
It's not even right, because you said the Gurdwara is 3 stories. I'll let the inspector judge, but it's obviously not 2 stories, is it?
No, I said there was the only 4 stories is Perkin Close. I said 2 to 3 stories, and the Gurdwara is 3 stories.
All right, let's just move away from, because the inspector can come to his own conclusion on those categories, but let's just try and read it in context. This plan, this SPG and the London plan that accompanies it, is about addressing, optimizing sites for previously developed land, amongst other things, in urban locations, even suburban locations.
Indeed.
Yeah. And what you don't do is consider at all, in this context, the other parts of the text which apply to these categories, where one of the central elements, emphasis, is on the public transport accessibility of a site.
Whereabouts in the document are you looking, Mr. Strong?
But I'm okay. Well, just below. Do you want to start applying the density? You've got the document.
Yeah.
It's applying the density matrix.
Yep.
Talks about character context 1.3.9. 1.3.10, conversely, greater weight should not be given to local context over location or public transport accessibility unless this can be clearly and robustly justified. It usually results in densities which do not reflect scope for more sustainable forms of development which take best advantage of good public transport accessibility. So if there's any doubt, in a location which we all agree has a PTAL score of 6A, I think it's virtually the top score you can possibly get in London. This is about optimizing rather than erring on the side of lower densities, isn't it?
Indeed.
Where
and
do you address that in your evidence?
I have not cited any conflict with the density, and in my examination of chief, I highlighted I don't have a problem with what the quantum or density of what's being proposed on the site.
Well, it's not just about density, it's about flexibility, isn't it, in achieving density, including on privacy separation distances, isn't it? It's all of a piece.
It doesn't say that in that paragraph. It just says
Yes, but if
densities.
you put it to, I know, Mr. Ringers, this is your problem. You're not reading it as a whole. Putting it together, you can debate for as long as you like about urban and suburban. We very clear, as everyone else is, it's urban, but you're just missing the bigger point. You don't just set the definition and then say, I'm now going to apply a rigid rule to separation distance. This is actually guidance, which is emphasizing the need to optimize greater density on a site of this kind because of its p-tau score, isn't it?
Yes, and I certainly agree with you, Mr. Strawn. And in my examination in chief, I did try to make the point that it wasn't about what's being proposed, and that even if it is an urban or suburban location, I don't think it has a particularly significant impact on how the inspector would assess the appeal scheme.
There's an awful lot of evidence from you about that. To get to that point, okay, but so be it. 1.3.16. Higher density housing can be particularly suitable in town centre and edge of centre location. We're agreed this is an edge of centre location.
Yes.
And it's edge of metropolitan centre.
Yes.
And so therefore, in terms of the London plan, in terms of looking at separation distances, if they're below the 18, or indeed amount of amenity space, the inspector should be approaching it through that lens for a site with a p-tau score of 6A.
Yes.
Correct?
Yes.
Where do you address that in your evidence?
Mr. Strawn, my
Sorry,
evidence.
Mr. Ring, it's a simple question. Where do you address that?
What specifically? Sorry.
That the inspector should be approaching this site in terms of separation distances and amenity space through the lens of wanting to increase or maximize the density, bearing in mind its p-tau score.
I think you meant optimize.
Optimize, sorry.
But
optimize.
yes. No, I agree. The inspector should have that lens. It's
That
about
wasn't that,
optimizing.
I know we've agreed that. That was the preceding question. The next question is, where do you address that in your evidence?
In my evidence, I reference it to be suburban and then contain the assessment as to why I consider it to be suburban afterwards. I haven't in any part of my evidence suggested that the density of this development, which is what these paragraphs are referencing, focus on, is an issue.
No, you're missing the point again, Mr. Ring. I know you're saying density is not an issue. It's about the question of whether or not rigid standards are applied flexibly, amenity space, insofar as it's inadequate on the site. One thinks about the location. Where do you address that in your evidence?
I don't.
Right. And then the same point's made with even greater emphasis at 1.3.23, isn't it? p-taus expressly. This is where we get the p-tau scoring and its relevance. Yeah.
Yes.
And 1.3.26.
1.3.26.
Sound strategic measure for public transport connectivity. Yep.
Yes.
Right. And then can we then think about your other oversight in relation to this guidance about setting and character? 1.3.32.
Yes.
This is identifying both that a site itself may create its own character, but
Yes.
of course the whole point of the London plan in suitable locations may be to increase, i.e. the existing character in terms of density, etc. And that's directly applicable to this site, isn't it?
Yeah, I agree.
It's a product, maybe a product of underdensity in the past, but it's important to use this site consistently with its p-tau score.
Yes.
And 1.3.33, the central setting applies, for the sake of clarity, to locations in or within 800 meters walking distance of a metropolitan or major town centre as listed in Annex 2. Locations in or within 800 meters of a district centre are generally considered to give an area an urban setting.
Generally.
Where do you deal with that guidance to the inspector?
Mr. Straw, and I've set out my professional judgment on
Sorry,
what
that
I
wasn't my
consider the
question.
area to be.
Mr. Ringer, that wasn't my question. This is relevant policy, isn't it?
I don't understand your question, Mr. Strawn.
I'll try it again. Where do you deal with that guidance to the inspector in your
Paragraph
evidence?
1.3.33.
1.3.33.
This paragraph isn't specifically referenced in there,
Right.
but again, I don't think it's all within 800 meters are generally, and I don't think in this instance this is relevant because having conducted my assessment, this is a general approach to assessing it.
Right. It's identifying that particular, consistent with everything we talked about, PTAL scoring sustainability. It's identifying a more general presumption of 800 within 800 meters. Here, we're of a metropolitan centre. You'd expect it to be urban.
It still says generally, and for the reasons that I've outlined, I do disagree with that. And I do want to just go back to paragraph 1.3.32, where it says that it shouldn't be defined in a static way. And I think I've done that because I have accepted that they don't sit within one definition completely.
Let's come to 1.3.34, the 800 meter distance. We're well within that 800 meter distance, aren't we?
Yes.
Yeah. So we're edge of centre, edge of metropolitan centre. Generally taken to approximate 10 minutes walking distance. The character of areas around the CAZ and town centres can change quickly, and the central and urban setting should be applied to a shorter distance where a character appraisal prepared or agreed by a borough indicates that a tighter boundary would be appropriate. So it's there giving specific guidance, 800 meters, which we're well within, unless you've got a character study which tells you it should be a much tighter boundary.
Yes, but I don't think it's necessarily, if there isn't a character study that says it, then it isn't the case. I think you have to look at it holistically and exercise an element of your own judgment.
Okay, well, let the inspector, rather than just rely on your judgment versus the others, might then want to look at the character study that's the most recent character study that's been done in this context. He's already got the 2014 study, CD 11.5.2, and the differences of view on that. But there's a more recent study, June 2023, isn't there?
Yes.
That's CD 11.5.7.
Yeah.
So that was the map you were looking at earlier on. And in that document, we have been through the identification of this lying within a built character area of urban terrace, correct, Mr. Ringer?
Yes.
Which, as you fairly recognise, the use of the word urban doesn't really assist you.
Yes.
Yeah. But perhaps more fundamentally, ignoring all of the additional guidance in the housing SPG, you haven't actually taken the inspector to the identification in the urban study of where this site sits in terms of character. It's part of central Hounslow, isn't it?
Yes.
And the inspector can find that from the bit of the document you didn't take him to. It's called PAB6, but it's in the same series of 11.5 documents. I'm just curious why you didn't think it necessary to go to this. This is obviously the most directly relevant part of the document because it's focusing in, isn't it, on areas with character areas within Hounslow.
I do provide an assessment of this within my notes on the SPD.
Okay, it was just already you didn't go to it, but can we agree it's relevant? So if you've got that document open, page B6-6, you'll see a bluish area, sort of midway, Hounslow Town. So we're not only central Hounslow, but within central Hounslow, the appeal site lays in the Hounslow Town area, identified for neighbourhood purposes, neighbourhoods and places. See the company text on the left.
Yes.
It's helpful to think about character at different scales, we're told. And thinking about character at different scales, this study done by urban design consultants has identified our site as lying within the Hounslow Town neighbourhood area.
Yes.
Yeah. Certainly relevant for any assessment of the question of urban or suburban, isn't it?
Most definitely.
Yes. And within that, we're identified page B6-8, the approach of conserve, enhance, transform. There's a sort of arrow at the bottom of the page, sir. Have you got that? Left to right. B6-7, I'm so sorry. B6-7, transition themes. Within Hounslow, the Hounslow area, Hounslow Town sits on the right-hand side as an area for transformation. An area to bring about a level of change. Correct?
Yes.
Have you got that, sir? And central Hounslow is then dealt with in a bit more detail in the pages below. B6-13 is another map of Hounslow Town, distinguishing it from South Hounslow and Lambton, correct?
Yes.
And we're squarely within, just below the caption Hounslow Town, the grey, that's where our site sits. And then there's plenty of analysis of that then follows, and so you can consider it if you have any leisure time at your leisure. But what I just want to focus on is talking about Hounslow Town Centre design codes, B6-31 and 32. There's a lot of design codes relevant to Hounslow Town, which we're identified as falling within.
Hounslow Town Centre,
Hounslow Town Centre, okay.
which the appeal site doesn't lie within.
Well, let's go to, where do you say that?
But it's not in the town centre boundary.
Hounslow Town is the one it's the, well, no, I think I'm pretty sure B6-29.
Yes, that's Hounslow Town, yes, the wider area.
Well, yeah, but the Hounslow Town Centre design codes are the one that apply to Hounslow Town in the structure of this document, aren't
But it does say Hounslow Town Centre.
Yeah, because it's treating it as part of Hounslow Town Centre.
If it was treated as a part of Hounslow Town Centre, it would be within the town centre boundary, but it isn't.
Well, I'm sorry, that's just not right. For this character area, it's treated as one and the same. But I don't want to have the inspector can read it in due course, but can we just focus on this document? Oh, I think it's this one. There's a specific part of it which helps us with this site, doesn't it? B6-24.
Yes.
I'm not sure you, page B6-24, sir? I'm not sure you've referred to this. Maybe you have.
I think I have, yes, I think I did. Yes, page 11 of the note, paragraph 2.28.
And what it tells us here is Hanworth Road Site C. Series of key site present opportunities to enhance environment and contribution of Hanworth Road to this area. And then we get our site. The vacant site adjacent to Goodwara presents a great opportunity for a new community use development. Priorities for the site will include addressing boundary treatment on Hanworth Road, establishing a clear block structure and network of streets and landscape, mid-rise development would be appropriate on this site with a massing strategy that's sensitive to the setting of the Gurdwara. So it's
That's what it
identifying
says.
this site for mid-rise development, and mid-rise is defined, isn't it, in the document B615. I think it's. You just go back to mid-rise. There's a picture of, if you go onto page B619.
Yes.
What's identified there is higher density mid-rise forms of development. B613 is the figure. It gives the example of mansion blocks in South Kilburn Estate, and those look to be at 6 stories, I think.
As I said,
5 to
Mr. Strawn,
6.
I don't cite any issues with the density that's being proposed on this site. I will say that when we go to that paragraph that you just mentioned on the vacant Hanworth Road site, it does say mid-rise development that would be appropriate on this site and a massing strategy that is sensitive to the setting of the Gurdwara, which I don't think has been achieved.
Well, I know you said that, but your colleagues differ on that. We were dealing with the principle of what's expected on the site. It's right, isn't it, that however the inspector chooses to describe urban or suburban, in this context, the character study is identifying mid-rise as being the appropriate treatment, subject to obviously sensitivities for the Gurdwara, not for the specified Perkin Close.
It didn't, no.
But for the Gurdwara, and that, sorry, there is another illustration of mid-rise. It's 3 to 5 stories, B615, so on the right-hand side. So as it happens, the appeal scheme in terms of its levels are indeed 3 to 5 stories, aren't they?
Yes. And as I said, again, I don't cite any issue with the density of the appeal scheme or the mid-rise of it.
There's nothing that's suggesting the form of development on the site should be suburban.
No.
It's the opposite. It's suggesting a form of development which is intrinsically urban, having regard to the housing SPG.
Yes.
Right. ST2 was Mr. Tickle's examples of other separation distances for other schemes. Just a couple of points on this. And again, I'm looking at points of principle. You went to 6976 High Street, and you said it's an urban location. Well, we've dealt with.
I think I said it was a central location.
Central location doesn't matter. The point that was made there is that the officer report did rely upon the use of opaque windows and spandrels as a design solution.
Yes.
Yes. So in fact, there's a matter of principle. Use of opaque windows and spandrel as design solutions can create acceptable relationships.
I think this comparison is very much so apples and pears, Mr. Strawn. This is within a development. So the developer has the ability to control the design aspects for each window. So you can have opaque glass on one window and a spandrel on the other window, and they have the ability to implement that. Whereas they can't put a spandrel window on Perkins Close to ensure that no one can see in there. That's not within the scope of this application. So I don't think that's an appropriate comparison.
I'm not suggesting putting a spandrel window on Perkins Close, are we?
Your question was, do the combination of those prevent it? And this has been used within the development.
No, it wasn't about. Both opaque windows and spandrel solutions are used in order to address privacy relationships.
In this scheme, they were used, yes.
Yes, because they can address privacy relationships.
When you have control over both the receptive windows.
Why do you need control over both? If you opaque one window, why would you need to opaque the other?
Well,
That's
that's what they
facing.
did in this instance. They had opaque windows on one side and spandrel windows on the other to ensure that there was no possibility to overlook.
That's going to depend on the specific relationship.
Yep.
Mine was a simpler question.
There are design solutions to prevent
Right,
overlooking. I
okay.
agree.
Fine. And then there are various, I'll let Mr. Tickle deal with the other examples, but there are a number of examples outside even the central locations with distances below the 18 meters. I think you accepted that.
Yes.
13.7 meters on Charlton House, for example.
Yes.
Yeah. Okay. And there, one of the principles that was expressed was about windows not be directly facing each other.
Yes.
That's relevant. Yeah. Okay. Good. This is another example. So then, I think the only other matter which cropped up in your proof, but I think you've now confirmed, daylight and sunlight relationship. You're now accepting is there's no conflict with the relevant policy from this scheme.
There are adverse impacts that need to be weighted in the balance, but it's not unacceptable when comparing it against that policy. So there's no conflict with that policy.
Well, no conflict with the policy means it's an acceptable relationship.
It's not unacceptable, but the adverse impacts need to be weighted by the inspector.
Well, I'm getting your professional view, Mr. The not unacceptable, can I treat as, because I'll try and use one word without using two, not unacceptable means acceptable.
I think there is a difference in general.
Right. Not unacceptable.
Yes.
Amenity space then. And so I'm going to try and break this down into the three elements: private amenity space, communal amenity space, and play space. Reason for refusal 3. The committee report and your other officers are clear that this scheme as a whole does provide sufficient amenity space of all types with the off-site contributions that were being proposed.
Sorry, Mr. Strong, what was the question?
The officer report and your fellow officers were satisfied that this appeal scheme provided sufficient amenity space with the off-site contributions proposed.
Yes.
Yeah. Breaking it down into the different constituent elements, private amenity space in this scheme, that the provision of private amenity space exceeds significantly the standards set for in policy.
It does exceed significantly. I would like to go to my rebuttal for my answer to this, because I think it is important to consider various aspects. So
well, we will
1,538 square meters, so over provision of 778. But I would like to caveat that and say that only 65% of the dwellings do have an over provision. So it's not equally distributed between every residence. And I do think that's important to point out.
Every dwelling has access to sufficient provided.
A policy compliant level, yes.
Yes. And overall, there's significant over provision.
Yes.
So they're generous private amenity areas available to a very significant number of the dwellings.
Mainly on the ground floor and on the upper levels.
So be it. Okay. And that's relevant to an overall assessment of amenity space generally, isn't it? The acceptability of the scheme.
Yes.
This isn't a scheme which is deficient in all amenity space. Everyone will have access to not just a policy compliant, but in most cases, a greater than policy compliant amount of a place to be at leisure.
In terms of private space, yes.
Yeah, okay. Right. Then we come to communal amenity space. And just pausing there, so far as the London plan's concerned, it doesn't have any standards or requirements for communal amenity space, does it?
It has standards in terms of how they should be designed, but there isn't a metric, a number that should be provided per occupant or per dwelling. No.
Yeah. So We comply with the London plan in terms of delivery of private amenity space. We comply with the principle of delivery of communal space under the London plan. We provide some. There isn't actually any set amount.
I disagree.
Which part of the London plan communal amenity space are we conflicting with?
If I could take you to policy, I'm just going to double check. Table 3.2 of policy D3.
Right.
So communal outside amenity space should provide sufficient space to meet the requirements of the number of residents. So when I compare that to the policy for a local plan, I think that they should line up with each other, and I don't think that sufficient space to meet the requirements of this number of residents has been provided.
All right. So you're just relying on the Hounslow plan for that?
No, because whilst it doesn't say X amount should be provided,
Yes.
it says provide sufficient space to meet the requirements, and I don't think sufficient space to meet the requirements
Okay, you're
has been
saying
provided.
let's cut to the chase. There is no metric or standard that needs to be met in that respect. There's a judgment to be made about sufficiency.
Yes.
Okay. And let's then go to that plan CD 16.7. So we've got the different areas. And let's just see factually what's done and then compare it against policy. Are the appellant's amenity areas that they've included for these purposes are in effect shaded in a, well, they're all green colors, so that's not going to help, is it? But there's a key on your right. Communal amenity is a specific color green, isn't it?
Yes.
It's distinct from play space.
Yes. For the appellant.
For the appellant, for calculation purposes, the inspector can note that the calculations of communal amenity space under the site areas, 915 square meters, are in addition to play space of 383 square meters.
I don't agree with that those calculations as evidenced by the following page.
Right. Your calculations are 902 and 377.
Yes.
Right. Which you regarded as, I think you would say, marginal. Is the scheme going to turn or fall on those calculation differences?
No, I don't think it would.
Right. So it doesn't matter. Are you happy to use the appellants for the time being, or do you want to use your? It doesn't really matter to me. But the point is that whether it's 902 or 915, or whether it's 377 or 383, they're different areas.
Yes. Well, and what I would like to say as well is that my calculations do double count the amount of play space and communal amenity space, whereas the appellant separates that.
Yours double count. Well, let's just go to your proof of evidence then. Paragraph 6.35. This is one of the first points you know. So it's important to note the 902, which is our equivalent 915, also overlaps with the 377, so that the usable communal space for the future adult occupants is 525. So you've taken 902 from 377.
Yes, that's,
yeah, and that's just wrong, isn't it, Mr. Ringer? Because
no, I don't think it is. I'm saying my overall calculation is 902. I'm just drawing in this particular paragraph. I'm drawing it to the inspector's attention that of the 902, 377 consists of play space.
Well, that's just not right. No, your 902.
You can see the differences in the areas that I include. So the walkway in front of the bin store.
Sorry.
Let's
just go back to our go back to CD 16.7. Stick with our calculations. I'll try and work out how you've done yours in a moment. The 915 square meters does not include the play space.
Not for the appellant's calculation.
Not
no.
for the appellant's calculation. So it's 915 square meters of communal amenity space. And so you can see that from the caption. The darker green play space is an additional 315, sorry, it's additional 383 square meters. Correct?
Yes.
Right. Yours is what? So you're saying your
So where I have drawn a red line around the area and it's been filled in.
where's where's your red area?
So on
40.
6 I'm not sure if the red comes through where it's been filled with color, but if you zoom in, you can see the sort of red line I've drawn around those spaces.
No, I can't really.
So
You've got 518.
I think he means a red
Sorry.
line around the whole of the northern
Yeah,
courtyard
so-
and a red line around the whole of the southern courtyard on page 2 of that
Oh, I
document that
see
you were
yours.
just looking at.
I see you've double counted them.
yes, that's
So the appellant hasn't.
no,
Right.
but I have double counted them.
Okay. All right.
Which is the approach often taken by the council.
Well, you say it's the approach often taken by the council. Let's just understand that. We agreed that there has to be complete consistency in the approach to these matters.
Yes.
If we go to your proof itself, I know. Let's just start with ST9. ST9, Mr. Tickles. In that document, he's produced, I think, just 4 examples, and no doubt many others that could be used, of how the council's gone about calculating amenity space provided by other schemes. So if you've got them, you'll have the plans in front of you. And in each of those plans, the amenity space is calculated by measuring areas which include circulation space, correct? There's no exclusion.
Yeah, as have I.
Right? And they also include public realm, don't they?
Yes.
So if you go back to our CD 16.7, the council would have actually included the public realm calculations for this scheme, wouldn't they?
Now, I'd like to take you to one of Mr. Tickle's ST appendices. I believe it's the committee report for Charlton House, which is one of the key examples that has the public realm space included in the calculation. So that is ST11.
Yeah.
I unfortunately don't have the page number of my printed version, but beginning at paragraph 8.120, there's quite a detailed explanation here as to why these examples, or why in this case the public realm was included within the overall calculation. So this particular scheme, as we can see, sorry, just drawing back on ST9, the site plan that's provided, I think the proposed site plan might actually also be in the committee report, but I haven't got it. We can see it creates a new avenue of streets rather than on the appeal scheme that only public realm is on the site boundary. Now, from 8.120 all the way through to 1.827, it explains why the high quality of pedestrian environment that incorporates play space, seating, and various other features to promote social interaction, play, recreation. So that was a very high quality public realm scheme, hence it was included When we look at the public realm on the appeal scheme, we
Sorry,
have
which scheme are you looking at then? I'm just looking at. Have you got ST9? Is this Charlton House?
I was, so with regard to ST9, it was the Cavalry Barracks application on.
No, let's just. Well, I thought you were looking at Charlton. I mean, let's just apply. Let's just take them in turn then. ST9. Have you got that?
Yes.
Right. ST9. The land at Chiswick roundabout. These are all communal amenity areas that include all the circulation space to get to those areas.
Yes.
So if you got that, that's figure 1.
Yeah, and I have counted circulation space in my calculations.
Well, you haven't, because you've deducted some of the areas that.
Some of the areas that I think are simply functional access areas and not really usable for the purpose of communal amenity.
Well, let's just see if that's not consistent with the approach on figure 1 for these amenity areas.
I do
These
think
go
with
right up to the look at the green hatched areas.
Yes, I can see the plan, but I do think with particularly the land at Chiswick roundabout application, there are some significant constraints that do need to be considered. The site has an area of 0.28 hectares, whereas
That's totally irrelevant to the calculation.
No, I
of
think
the,
so. I think it is relevant because
Mr.
you have
Ringer,
to take into account the site context. Sometimes the context
It's
might.
got nothing to do with this. I'm not dealing with site context. I'm just dealing with straightforward calculation of what you include within amenity space.
Yes, but from these plans, we can't see any areas in front of bin stores, or that's not been indicated on here, and that's mainly the areas that I've removed from my.
I'll come back to stores in a moment, but it's all areas, including the bits you use to access them. Have you got that, sir? On figure 1, you'll just see it goes right up to the buildings and goes into the in parts of the buildings where you're accessing. There's no exclusion of those areas.
The communal amenity space for this scheme was incorporated internally and externally, I do believe, as explained in these, due to the site constraints. It's bound on all sides. The North Circular A4, M4, there's significant air quality issues, so some of that space was inside, whereas it's not the same issues here.
Okay, I'm not dealing with the quality of the space amount, just what you actually physically calculate. We can agree that you calculate everything that's shown, including the bits to access it, what you would call functional areas.
I disagree.
Which areas have been discounted on the basis of functional?
No, in this application that I can't see any areas that have been discounted, but
right.
This plan also doesn't provide that analysis or the comparison to the appeal scheme.
Right. Same. Then figure 2 is the Charlton. Is figure 2 the Charlton House? Again, look at the orange areas. Those are the communal areas, aren't they?
Yes.
They include those not just circulation space, but the access to the circulation space.
Yes, it covers all the areas, and
so there's no exclusion, for example, of the orange areas that go in between the 2 buildings to get to the courtyard area.
But there is still quite a detailed description justifying why that's all included in the officer's report.
No. Where are we looking at this? So I'm just holding it up, but these areas here, these 2 spurs. Yeah, the 2 spurs.
Yeah.
Can you see that? I know
Yes.
it's distant. There we go. All of this area, it's all included in the calculation, isn't it?
Yes.
Functional areas, you would call it.
Without having a further deep dive into this.
Well, you've had plenty of time. You've had, I think, 4 months.
Yes, but just looking at the site plan and going through the report as to why.
Yeah, well, where's the
justification?
Where's the detailed justification for including that functional area as opposed to just accounting it for our scheme?
I don't think that there is one. The focus is more on why the public realm was included.
Okay, but we'll come back to public realm in a moment. We haven't included any public realm in our calculations, have we?
No.
But on any basis, an inconsistent approach being adopted between you and the council in these other schemes.
With regard to the public realm?
Yes,
No,
not public realm. No, the communal amenity space.
These are all very different schemes, though, in how they're accessed. And the officer's report does say that he calculated those areas based on the removal of the areas he didn't feel were usable. So
Yeah.
I'm consistent with the officer's assessment in that regard.
No, stick with my question. Mr. Ringer, no discounting for areas that take you into the communal courtyard areas, is there?
For the areas that take you into the communal, no. Or
What do you
within these examples anyway.
No, okay, right.
Which is quite different to particularly the entrance is to the courtyards in the appeal scheme is very different.
Right. And then if we go to your own, I think the same is true of Cavalry and Manderson House. I'm not sure we've got a plan. Manderson House, same idea, isn't it? It's just a whole roof plan. In fact, it includes all the photovoltaic cells as well.
I do take issue with that specific point. Having gone through the committee report, it does say that the 2,000 square meters comes from 3 roof terraces and a podium, and we can see, well, I think it says productive gardens, and we can see where those 3 productive gardens are in there. It does say 2,000. I think if you add up the on here, it doesn't include that. But I certainly don't think that the PV
Right, well,
panels were included in when the officer who assessed that application made their assessment.
All right. Let's just go back to your own proof. I just want to have a consistent approach so that we know how to go about these things. We've got what's been done in these. I haven't been able to identify any example where what you're calling functional areas are discounted. It's functional areas being, you're circulating to get as part of the circulation area.
Well, the main areas I've
point-
discounted are in front of. I think the site, the context of the quality of these spaces makes it important to be discounted. For the northern courtyard, we were walking through one 5-story and the school's 3-story. But
Mr. Ringer, do you remember what my question was?
I'm just explaining why they've been removed from
I know,
my areas.
I know,
think
but
that'd
that
be
wasn't my
helpful for the
question, was
inspector.
it? What was my question?
Oh, can you repeat your question?
Yeah. Any examples where those sorts of areas have been discounted in any other scheme?
Only in front of me, the officer who was the original application discounted those access areas from his calculation as well. So it'd be consistent with that approach.
Right. And if we go back to CD 16.7, we have not included public realm, even though there are significant improvements to the public realm in Clarence Terrace. There's a landscaped area. So if you got that, you would have seen the plans. It's shown in grey. Both are up towards Thompson Road and down at Clarence Terrace, 2 areas of grey where public space is created. Indeed, the one in the south is, if you look at the drawings, planted up for, correct?
I certainly agree that the public realm benefits have a significant weight in the planning balance, as I address in my proof. But when you look at the public realm that's included within this scheme, it's simply planters and trees and soft landscaping. There's no benches or play space that have been integrated. ST11 and the paragraphs I mentioned very detailed as to why the public realm is included.
Well,
this is not of sufficient quality to be included in the calculation.
Right, so. But then if we go back to your proof of evidence, the example you provide of illustrating good communal space from the SPG, there's a little diagram. Yes. It's illustrating communal space. It doesn't discount circulation space or areas which allow you to access storage, does it?
I do.
I'm sorry, sir. It's in Mr. Ringer's proof of evidence, and it's a little diagram. I've just lost my note to it. Sorry. Where's his?
It's page 33 of my proof.
33. Sir. Thank you very much.
I think, Mr. Strawn, this image, and I do understand storage, but we have, if you look at the rest of the policies or the rest of the guidance, should I say, within this LPG, it does say opportunities for food growing, and then this little storage has a space and a a fork. It doesn't have a bin and a cycle store. So I think that is distinguished. I don't think anyone would want to stand and have a chat in front of a bin store, particularly enclosed. Not much passive surveillance from the other areas in the.
Not much passive surveillance in
No,
our
on the areas I have discounted, particularly if we look at the between Block C and Wings Academy, the passive surveillance is limited compared to the other spaces. You're in front of a bin store, which is going to generate odors. You're exposed to the activity on Thompson Road, so you may want to move into the site and be in a more quiet and overlooked area. Now, I accept if we go back to this figure that you pointed out, the courtyards are well overlooked. There is opportunities for play. There aren't any opportunities or specific facilities for exercise. There is seating, there is planting, and there's no growing or storage for what it indicates would not be bin or cycle storage.
Right. Very long answer. There's no discounting merely because you can access a cycle store, is there?
No, but I think that for the reasons I've outlined, it's sufficient for these areas to be discounted from that calculation.
All right. So you say, okay. So that's the difference between us, I think, in these calculations. We differ from you from what you've excluded. Give me your answers about any precedent for that. Let's just then take the resulting figures. And in terms of play space calculation, you talked earlier about a figure of 489 being required.
Yes.
Have I got that right?
I think that is the policy requirement, yes.
Versus 383.
Yeah. Sorry, did you say 389 or 489?
489.
489, yes.
And it's fair to say, isn't it, bar, I think you talked about 7 square meters, that the play space provided on site meets all the play space requirements for anyone up to the age of 12.
Not quite. It's slightly short. 14.
Did you hear what I said? Bar the shortfall, I said 7. But
apologies. Bar the shortfall of 14, yes.
Okay, well, I think we've calculated 7. You say it's 14. You're not suggesting that difference is going to be a reason for refusal?
The difference, no.
No. So am I subject to the difference between us of 14 square meters? We say 7. In effect, this appeal scheme materially provides for all play space requirements for up to 12-year-olds.
For up to 12-year-olds?
Yes.
Discounting what I've already caveated, yes.
What, the 14 square meters? Yeah. Okay. And the shortfall, therefore, is in the region of 107. You might say it's 114. I'm not quite sure, but that's the regional. Yes. Yeah. Let's take that first of all. So, play space provision on site for all 12-year-olds minus the 14 square meters. 12-year-olds deficiency of, say, 107, 114. Immediately adjacent to the site, I think it's actually on the site, but I don't know whether you want to debate or not, is a newly created multi-use games area, which would be, of course, suitable for 12-plus-year-olds. Correct?
It would be a suitable facility for 12-plus-year-olds, but it is really important to make this distinction. Firstly, the southern courtyard, the policy compliant level would be 120, so 107 we're slightly below that. Whereas
we've been over that several times.
I'm just giving you my answer as to why I don't think the play space provides sufficient. The space you've identified sufficiently offsets that harm for the over 12s. Now, the biggest area of deficiency of around 100 square meters is the northern courtyard, which is essentially the social housing block where the majority of the affordable units are. So that to me suggests that they're even less likely to pay that fee, which isn't open access, which the housing SPG states those facilities that are intended to offset the harm of an under provision need to be open access. It's not available all the time. It's cost comes at a fee and it doesn't provoke that informal activity. So whilst I do think that in the plan and balance that facility has a significant benefit due to what it can provide for the wider community, I don't think that when relating it back to this main issue, that that facility offsets the harm to those
Right, well,
12-year-olds.
Okay, long answer.
It needed a long
Immediately
answer.
on the site. I say on site. Do you say it's on site?
It's
or
within the
off-site?
red line boundary.
Right. So it's on site is a multi-use games area. Correct.
Yes.
It is in the excess of 480 square meters. Correct.
Yes.
And in principle, multi-use games areas are ones which constitute play space for 12-plus-year-olds.
Yes.
Right.
With open access.
Well, you say with open access. Let's just see what the GLA supplementary planning guidance actually says. Paragraph 3.26 of the SPG, which is
The play SPG.
play SPG, which I don't think you've got open yet, sir. (10.2.3).
Apologies, Mr. Strawn. What page was that?
10.2.3,
Page
paragraph
10.2.
3.26, which is on page 32, PDF 42. Got it? Let me know when you're there because I can press on.
Yes.
This identifies, doesn't it, that school facilities and school playing fields can provide an important contribution to high quality play spaces for a range of community activities. Where possible, children should be allowed access to use them outside school hours. Maximum use of schools or after school hours or at weekends contribute to reducing deficiencies in play provision, providing children with greater choice for play activities and respond to the needs of working parents, etc. So in principle, this is recognizing the ability for play space to be subject to contribute to play space from school facilities, such as the one we've got on site here.
I think a free facility certainly should be
It
considered.
doesn't say free, does it?
It doesn't, but I certainly don't think that having to pay for this facility is going to add any value to the residents of those blocks, whether it be in the southern portion or the northern portion.
Right.
£20 an hour for your child to go and play in a playground.
It's not £20, it's for the whole facility, isn't it?
Okay, well, regardless, I think to pay a £20 fee, whether you want, if your child wanted to use that every day after school, you just wouldn't pay for that. So I think the benefit that has to the future occupiers of the development is very limited.
Right. That's your view, Mr. Ringer. Can we, paragraph 4.12, page 52.
Sir, I just note that it is 10 to 4. I wonder if we might find an appropriate spot for a comfort break at some point soon.
Yes, we didn't start till 2:15, but yes, we are due to have a break soon. How are we doing, Mr. Strawn? We passed the 2.5 hour mark now.
Oh, have we?
How long do you think you've got left?
Not too much. I'm on my last topic, but probably more than if people need a break, then I'm happy to have one. I'm also happy to press on, subject to what Mr. Ringer thinks. Maybe
I would rather press on if
20,
possible.
but it rather depends on everyone else. But
yes, well, I think I'd like to have a break actually,
Okay.
So we'll do that and come back and finish it. Do you want to finish the point?
well,
you were
I
just
think why
making,
don't we just if everyone can wait for a couple more minutes, then I'll
Yes.
finish this point. Yeah, there's reference to an audit of play areas in 4.12, isn't there? I want to come back to that on the document you've introduced.
The open space study.
Exactly.
Yes.
And then finally in this document 443,
Yep.
Similar point about school facilities being calculated or potentially used for off-site contribution. In this case, it's actually on the site, but 443.
Yes, it does say that.
It's the end. In cases where school permit use of their grounds, ways could be sought for developers to provide support to achieve this, particularly where such uses are identified in the play strategy and local circumstances support provision. This could be considered a contribution to off-site provision. So subject to your views on money and charges, in principle, the multi-use games area is capable of contributing towards the provision of play space for 12-plus-year-olds.
Yes, I think it would certainly be a valuable facility for the wider community, and it should be afforded a significant benefit in the plan and balance. I say again, I still
That
don't
wasn't
think.
my question, Mr. Ringer. This is about contribution to play space in terms of quantity.
Yes, it's
No,
providing new facilities for the borough.
Well, I know that.
So what
In
is there?
calculate, there's a 107.14 square meter deficiency on site. It's right to the inspector to take into account the multi-use games area on site of 485 square meters, subject to your caveat about a charge.
No, I still don't. I stand by the fact I don't think this adds any. This improves the facilities for the children that this development is going to accommodate.
You don't
So they
think
haven't
you
met the
don't think
benchmark space
it doesn't
standards.
improve. Sorry, it will be available to them to use, won't it?
Very limited. It's won't be available in the terms that they can just go in and walk in there. If that was the case, then I would certainly agree it should be included in the calculation and would overcome my
Okay.
concerns.
Well, all right. Does it count at all?
I think it counts in the plan and balance, but it
Okay.
shouldn't be counted towards the provision for the children of this development.
Counts for other children, but not for the children of this development.
In terms of, I don't think that it would offset the harm that is caused by the lack of play space for children within this development.
Okay. So is that the convenient moment? Okay.
Thank you. Yes, we'll just adjourn until 4:10, please. Right, okay, let's resume then, please.
Sorry, Mr. Ringer, nearly there. We dealt with the mugger on site and your views on that as opposed to ours. And let's put it on one side, just ignore it in the way I think you're suggesting we do for the children on site. What, in this context, the inspector's looking at is the 107 square metre play space deficiency for predominantly 12-plus-year-olds and a communal amenity space for adults, etc., of around 790 square meters. Slight difference between us, but and in that context, one turns to the question, in principle, of provision off-site, which is accepted in suitable cases by the council.
Yes.
And you've referred to the draft open space study in that context, haven't you?
Yes.
That's CD 12.2, sorry, 12.12, so I'm not sure we've had that out recently. And CD 12.12 is the council's commissioned a draft open space strategy.
Yes.
And that document, I think, is the document recommended to be produced under paragraph 98 of the National Planning Policy Framework,
Yes.
requiring councils to look at their open space and the strategy towards it.
Yes, and the Play SPG also encourages the same thing.
Play SPG, paragraph 2.20,
Yes.
and policy S4 of the London Plan.
Yes.
And the idea is that the specific needs and the approach of the council should be set out in that document.
Yes.
And that's why you've produced it.
Yes.
Yeah. And in that respect, we can also note that your rebuttal proof of evidence from earlier concedes, I think it's the word you use, paragraph 2.23 of your rebuttal, that your reliance upon a 800-meter walking distance from the Play SPG was incorrect in relation to communal amenity space.
For adults, yes.
For adults. Because you say that only referred to children.
Indeed.
Yeah.
And then I set out the policies that seek to suggest what a suitable walking distance should be for adults.
Well, you say you're doing that. However, you're not, because you're referring to access of walk times to, in policy TC5 and SC10 at least, that relate to facilities like going shopping or public transport.
Yes, indeed. And the following paragraph 2.25, I note that these policies aren't specifically engaged in this appeal, but they are indicative of the distance a local plan considers to be convenient.
Well, we can do better than that, can't we, Mr. Ring, if you're being straightforward about it? The draft open space strategy actually identifies walk times for Hounslow.
Based on respondents.
Yes, well,
survey that
we
was
can't get much
conducted.
better than that, can you?
Yes. Well, I
Well,
think only
this is a local-
700. I think only 700 responses were received in that regard. So maybe
well, that
not.
sounds to me an awful lot. But anyway, that's the position. If the inspector wants to know for Hounslow what people would reasonably do to walk to different facilities for open space use, the best document before him is the draft open space strategy, isn't it?
Yes. Now, I think with the respondents who you're referring to, you're referencing figure 3.1.
I'm not referencing anything. I'm just
No, but
establishing that this is the best evidence of how far people would.
indeed,
wish
yes,
to-
and that those responses are in here. So if I could ask you to take up figure 3.13 on page 15 of that statement. Now,
Well, okay. Is this an answer to my question?
I hope you think it is, Mr.
Well, I'm
Strawn.
just trying to
So
finish
the-
my cross-examination.
No, I understand, but I do think this is important. We can see
See-
here that it breaks down the types of the types of open spaces, and then
Where are we going to? Just so I
figure
can follow.
3.1.3 on page 15 of the document. So it's a graph of the percentages of responses and how far that they said we would travel. They would travel 5 minutes being 400 meters, 10 minutes being
Page
815. Page 15 of the document.
Yeah.
So we can see here, you are right that the majority and only slightly. So if we look at the local parks and
I haven't
public
put
gardens,
anything. I'm right. I haven't put anything to you yet.
you
What are you
mentioned.
answering? What question? You think
Okay,
you're
would you
answering?
like to ask me a question?
Well, what did you think you're
No,
answering?
you were suggesting that this strategy suggests that people would walk longer distances.
I haven't said that. I said it's all I've said. Is
Apologies,
that
I've
this is the
assumed
best
your
evidence
question.
of how far people would want to walk to open space
Yes.
for Hounslow.
Yes.
That's right, isn't it?
Yes.
Okay. And you don't identify that for the inspector in your evidence, do you?
My evidence relies on the areas of deficiency that are in
Just
there.
straightforward yes or no at this point of the day would be really useful, Mr. Ringer. Do you identify? We're agreed that this is the best evidence in
Yes.
front of the inspector of how far people will walk in Hounslow to get to these facilities. You
My
don't
evidence.
identify that for the inspector.
No,
do
I
you?
haven't drawn on that. I've relied on the policy guidance rather than the respondents in this document.
The policy guidance, which is not relevant.
But
As you
as
say
I
in
said,
your
I think
proof.
is a general indication of what a convenient walking distance is.
No, convenient walking distance to a shop is different to a convenient walking distance to a open space park, isn't it? What's the difference?
No,
What-
okay, it would be different, but it
Right.
still says a convenient walking distance. So requires for SC10 or for HMOs, it's not related. Requires accommodation to be within reasonable walking distance, which is considered to be 400 meters.
HMOs. Well, we're not walking to Sainsbury's to pick up our shopping, are we? We're going to use, in the case of a older person, if they want to go to a Muga and they're not prepared to pay the £1 per 20 people or whatever it is that you object to on the site, then they will have a choice. They can walk to various facilities.
Yes.
Right. So this is the best evidence of how far people are prepared to walk.
I think so. Yes.
Right. And you don't identify that for the inspector. Those are the three questions I put
No.
to you. Right. Now that we do turn to it, the position is summarized. Yes, of course, there are respondents, and some people will walk further and some people will walk shorter distances. The position overall in this strategy is summarized, isn't it, in table 2.3.
I think
on page
I think a better
11.
summary. I think a better summary of those responses is figure 3.1.3 on page 15, which breaks down how long are you willing to travel to each type of green space based on the distance and for each typology of green space.
Yes, okay. And,
So
it's synthesized, isn't it?
Yes.
Because the strategy then has to work out whether you're in a area of deficiency depending upon certain walk times.
Yes.
And it does so, having considered all the responses received. It does so by summarizing the position. We can go into the detail. I'm happy to do that. Table 2.3, page 11.
Yes.
None of this you tell the inspector, but having introduced this document, but it's obviously clearly relevant, isn't it? A park and garden, the accessibility catchment, based on all the respondents and a view being taken, they'll prepare the most popular walk time is 15 minutes, 1,200 meters.
That is what table 2.3 says, but I do want to bring back to figure 1.3.
Well, we can go to that's fine
because I think it's important in assessing that yes, what this document has done.
Okay,
Mr. Strawn, if I may finish my
yeah, that's
answer,
fine.
if
Once
I
again,
may
where are you
finish.
going? Where are you going?
Using table 2.3 and then figure 3.1.3 on page 15.
Yes.
So
3.1.3.
the table takes what the highest respondents were and assumes that the highest proportion is what the catchment is. But when you look at that in reality, if you are saying that the 15 minutes or the 1200 meters should be appropriate, then we're excluding the 19.9% people that walk up to 5 minutes and the 28.8% that walk up to 10 minutes, and relying only those people willing to travel more would actually do that. So
No,
I do think you have to take that into consideration.
That's what the authors of this document have done, isn't it?
But you can see that the percent for
So,
the
Mr. Ringer,
park and
that's
green
what
space,
they've
it's
done.
1.1% difference. So they've taken the higher one, and I do think that having a look at that, we should try to make sure it's inclusive as possible.
Right. That's what the authors have done. They've looked at all the responses, thought about what is an appropriate maximum walk time to assess catchments in accordance with the national planning policy to say, are you within a reasonable distance? And they've come up with the right, I say right, they've come up with their figures.
Yeah.
Right. Using that document, judgments being made by the authors, table 2.3, let's just be clear. I'll give you all the references where it's set out in more detail. Parks and gardens, it's 1,200 meter, 15-minute walk time. Natural and semi-natural green space, they've given a 30-minute drive time. Amenity green space, 1,200 meters again. Play areas are divided based on the responses. For children's play, which we're not looking for here because we're on site, but that's 800 meters. For youth provision, that's the 12 plus, it's 1,200 meters.
Particularly for the young people, that would be different to what's recommended within the play SPG.
Well, you say it's different. I think the whole point about the SPG is to identify CMPPF and paragraph 2.20 your own local authority assessment.
Yes.
Right. Having done that, this is the result, isn't it?
Yes. But I still think you need to take into consideration the people that aren't willing to travel up to that distance when we're looking at the appeal scheme.
Yeah, and you look at the number of people willing to travel a lot more. You have to make a judgment.
Indeed.
Yeah. Making those judgments, these are the distances.
This is the distances that the studies say. It isn't in for. I accept that position, but as I said, I do think that we need to take into consideration that still over 50% of the respondents for the parks and public space wouldn't travel that far.
Right. So, okay, let's put it all in context. So if you want to take parks and open space, I think that's dealt with under section 4.3, isn't it? So the way this is divided up, it's into different areas. So part 4 is parks and gardens. I've just been looking at the summary, but part 4 is parks and gardens. There's an assessment of current provision and accessibility, 4.3, page 24. You get a range of different times. Most common times willing to be traveled by survey responses up to 15 minutes, 30%. This closely followed by those willing to travel up to 10 minutes, 29%. On this basis, a 50-minute walk time equivalent has been applied to all parts to reflect the most popular walk time.
And that's exactly my point, Mr. Strawn. They're taking the highest proportion of responses, and that excludes then those people that wouldn't be willing to travel that far.
Right. So 59% would be, and some are prepared to walk further, some are much less, but 59% are prepared to walk 10 to 15 minutes.
Yes, that's what
it says. Somewhere 800 to 1,200 meters approximately for a local park. That's what this local survey is saying.
Yes.
Yeah. If you got ST5,
would you like me to take up the most recent
version of it, sir? It's one of the documents that came in, I think, recently, ST5. So don't know where that's been put in the CD. Not sure it's on the core doc list yet. Have you got a spare? Can we give you a hard copy? You've got it, have you, Mr. Ringer?
Yes, I do have an email copy. However, it's not.
Sorry, could I just check, has this been added to the most recent core document electronic list? Okay. Okay, sure.
Just an update tomorrow.
Have you got it, Mr. Ringer?
Yes. Yeah.
Right. Based on the draft, the open space study for the London Borough of Hounslow, within the subject to debates about whether it's 790 or 800 or 810, Inwood Park is either within or very close to within the bottom range of
Indeed.
where most people would be prepared to walk to for a park.
Yes.
Indeed, it's well within the 1200 metre range, which is the identified most popular walk time for respondents in Hounslow.
Within the study, yes.
Within the study, there is no better evidence.
That
We've
was my
agreed.
answer.
Right. Okay. And that's just one park available to residents of this scheme who might be wanting to access open space, the adults you were talking about,
Yes.
parks. They can also walk, let's be clear about this, they can walk to Wolsey Close amenity space, 600 meters away. Oh, the smaller area accepted, but 7.
I think it's around 170 square meters, that Wolsey Close area.
They can walk to Murray Park. The peculiarity of your study and your evidence, of course, is you've excluded that from this because it's not in your borough.
Not the case at all. I focused on the closest one, which I consider would be the most likely place that future occupiers would go to.
Okay, but people for amenity space purposes don't choose them based on local authority areas, do they?
No, as I said, I didn't choose it based on the fact it was outside of our borough. I chose the one, Inwood Park, which was the closest.
But when you talk about open space deficiency in the south central area based on this study, it's because it doesn't pick up any of the open spaces available to the south in the neighbouring borough.
Granted, yes, the study doesn't include that, but notwithstanding that, there's still a significant area of deficiency for amenity green space, parks and play space.
Because the borough boundary comes up to the southern area. Where's the assessment of any of these other areas available in the London Borough of Richmond upon Thames?
I haven't looked at that or looked into that specifically. But I do think that it is really, regardless of whether it's out of the borough or not, the south central area has a very significant deficit for parks and gardens, amenity green space. That.
You haven't done the assessment.
The south central area, which with the appeal site lies within, is.
You don't know that because your assessment doesn't take account of any open spaces outside the borough.
Well, I consider this study to be robust enough to understand the spaces.
Mr. Ringer, is that right?
That Murray Park is not counted within this space.
Yes, so the open space deficiency is identified by reference to a borough boundary, not the reality of, for example, those sitting on the edge of Hounslow South area may be much closer to Murray Park and would use it.
Possibly.
Yeah, okay.
It's still further away than Inwood Park, and it would be Inwood Park, I still think, is the most likely destination.
Fine. So Inwood Park is either at the cusp of what the bottom end of the range, but certainly well within the 1200 meters being identified as the most popular walk time for people to walk to, and therefore accessible under this study.
I still think that it does have to come back to looking at who said 30% say 1200 and 29%.
That's why I took the boundary.
Yes, I know. I do appreciate that, but I still think you have to take in consideration the areas of deficiency and those distance and the actual route to these parks. I haven't seen a route analysis of any of these other parks, only to Inwood Park. I've undertaken a site visit and walked that route, and I do not feel, taking account of the barriers of movement, the traffic, and the general perception of the area, it's a safe route. And if the appellant thought that these were appropriate provisions to offset the harm, I would like to think that a route analysis was done, which is suggested by these the Play SPG, to see if that's a safe and convenient route for future occupiers.
Right. Well, this ST5 has been around for some time now, Mr. Ringer, but
this isn't a route analysis.
Leave that aside.
I'm going to walk
He
the
can
route
walk-
to Inwood Park on the site visit,
Right.
aren't I? So let's
So
try and keep
in
moving.
terms of choice, not only can they walk 790 meters to, or 810, whatever it may be, to Inwood Park, they've got Murray Park, 1,000 meters, and they've got Hounslow Heath, open space, 1,100 meters, so within that most popular time. Hounslow Heath, which is a very, very large area, isn't it?
Yes.
That stretches way off the page. It's a huge amenity
Yeah.
space. Going back to the study, in terms of most popular walk times to such an area, table, it's, sorry. It's 6.3, but it's 2. Sorry, it's part 5 of the document. 5.3.
What page is that, Mr. Strawn?
Page, sorry,
33, sorry.
33, thank you. Yeah. Most common times willing to be traveled by service ones up to 30 minutes, closely followed by those traveling up to 15 minutes. On this basis, a 30-minute walk, and it should be equivalent to 2,400 meters, shouldn't it?
What was the question? Apologies, Mr. Strawn.
5.3, the accessibility
Yes.
is equivalent to 2,400 meters, a 30-minute walk.
Yes, a 30-minute walk would be 2,400 meters, yes.
Yeah, and the respondents were referring to the most popular times being up to 30 minutes, but it's going to be 58% will walk 15 to 30 minutes. Yeah.
What the response is here?
So available to these residents within 30-minute walk time is one of the largest areas in this part of London,
Yes.
which is what people consider to be accessible.
It's what the document says. I still think that you do have to consider the other percentage and excluding other people from that who wouldn't walk that distance. And I do think that generally the distances coupled with the deficiencies isn't sufficient.
Well, you say that, but there's no analysis of these distances at all in your evidence. So you're giving that evidence now,
but purely based on the distances and particularly the walk to Inwood Park from the appeal site, I don't consider to be a convenient or a nice route to take.
Well, okay, that's about the quality of the route. I'll leave that for the inspector. Just in terms of accessibility and distance-wise, isn't it? It's fair to say, leave aside your views about the quality of the walk, which I'll let the inspector judge. There is a significant choice for residents of this scheme, both of parks and indeed much wider amenity green space to address that 790 square meter shortfall on site.
If they're willing to walk more than 800 meters.
Well, that's the difference between a 790 or 810. Yeah. Okay. And then just on the 107 square meter for youth space, can you just turn up paragraph 6.3? I think it is. No, sorry, that's 6.3 is amenity green space. And then finally, the youth space is dealt with in section 7, part 7.
Yes.
Turn to page 48. It gives you the difference between provision for young people and then older age ranges, what types of different areas they might use, 7.1. And it then identifies, page 49, the difference that's applied to children's play provision, below 12s, and the longer walk time for over 12s based on the respondent survey. So hence you get your 15-minute walk, 1,200 meters, most popular time for children of an older age, 12 plus. Is that fair?
The highest, it says 33% would like to travel longer than that, and then in the same for the older age range as well. So I do think that the 800 meters should be the maximum distance here.
It says 33 and 33. 33% up to 10
Yes.
minutes and 33 up to 15 minutes. So within 10 to 15 minutes, it's covering 66% of all respondents.
Well, no, 10 minutes covers 66% of the respondents. 15 minutes only covers 33%.
10 to 15 minutes, what I said.
But the 15 minutes would only cover the 33%. So just to be clear.
No. If you're willing to walk 15 minutes, you're also willing to walk 10 minutes.
Yes, that's what
so
I mean.
66% covers
This is
the
10 minutes.
range of 10 to 15 minutes.
It's a 66% up to the but I don't think we need to argue about that.
Okay, do the maths. There's another 20% who are willing to walk 30 minutes. Same paragraph. Correct?
Yes.
So just applying that to Inwood Park, which does have multi-use games areas, other recreational facilities, the park itself, whether it's within the 10 minutes on our analysis or just above it on yours, it's also well within the 15 minutes and certainly the 30 minutes.
Based on those respondents, but I would like to pull up policy S4 of the London plan, particularly paragraph 5.46, where it does say it should still usually be within 400 meters of the development and be accessible via safe routes. So I do think we also have to consider that policy as well as these respondents.
Right. Well, I'm only doing what this is the best evidence, isn't it?
Yes, but we also have to go by the London plan guidance as well within the play SPG and the development plan policy.
So the inspector has now all the relevant figures, the slight dispute about 790 versus 810 or whatever it may be. That then all needs to be set in the context which we described earlier of urban or sites with PTAL scores, seeking to optimize them and looking for best use of those sites, having regard to open space in the area. That's a sound principle.
Yes.
Yeah. Thank you very much. And I believe that is at least it in terms of the most material parts of your objection to the scheme. There's nothing I haven't covered, which I need to or haven't covered with others such as Mr. Ubaka. Well, I'll have to assume I haven't. Thank you very much, Mr. Ringer.
Right, okay, thank you. Mr. Ringer, could you just remind me, please, what the current housing land supply position is in Hounslow?
Yes, I'll just pull up the details. I believe it
may
is
well be
within
an
my
agreed
proof at the end, sir. We have met our 5-year housing land supply. Just
I think it might be page 60, sir, if that helps with Mr. Ringer's proof, where he discusses the provision of housing. There's a sub-paragraph 2 on there. Do you see provision of housing?
yes, that's it.
261% of local plans, that one.
Right, thank you. And any re-examination then, please?
Thank you, sir. Yes. Um, Mr. Ringer, you were asked about the weight that should be afforded to the views of officers who wrote or were involved in the production of the officers' reports. To what extent has their evidence been tested through an inquiry process in the way that your evidence has just been tested?
Not in any way, I don't think.
Okay. And in your view, is that relevant to the weight that should be attributed to views that have not been tested in such a way?
Yes, I think that does have an impact. There hasn't been that very detailed scrutiny of their assessment and a breakdown of their assessment. And I also do think that in terms of the weighting, that the views of the members certainly holds more weight than the views of the officer who wrote the report.
Why do you say that?
Because at the committee level, the members are the decision maker. It is our role as officers to make a recommendation based on our judgment, and they will weigh up the planning merits and the balance and make the decision at that level of democracy.
Thank you very much. Could I ask you please to take out core document 9.2, which is the planning statement for schools?
Yes.
Let me know when you have that up. Thank you. Do you recall it was put to you, Mr. Ringer? Well, there's two separate things here. There's a presumption in favour of school developments, and then there's the great weight that you attribute to the benefit to schools, and they're separate things. And you said you thought they went hand in hand. Do you remember that line of questioning? Okay. Can you just see on that first page, the first bullet point at the bottom?
Yes.
There should be a presumption in favour of the development of state-funded schools as expressed in the National Planning Policy Framework.
Yes.
Okay, let's have a look at what the National Planning Policy Framework then says about the provision of schools. Paragraph 95, that's core document 9.1.
Yep.
Page 27 to 28. So it's important there's a sufficient choice of school places, etc. Local planning authorities should take positive, proactive, collaborative approach. They should give great weight to the need to create, expand, or alter schools, etc.
Yes.
Okay. So when the policy statement for schools that says there should be a presumption in favour of schools as expressed in the NPPF, do you understand that to create any different policy test to that which is contained within the NPPF?
No, I don't.
Thank you. Could I ask you please to turn up the noise policy statement for England just briefly? It's core document 9.3.
Yes.
Okay. Now, do you recall the line of questioning that was, I think it was in the context of policy D13 of the London Plan, and you were saying you didn't think it applied just to significant effects.
Yes.
And Mr. Strawn was putting it to you, so you're concerned with insignificant effects?
Yes.
Okay. And you, I think, were looking for something. You said, I think there's a hierarchy somewhere. Can I ask you just to look up paragraph 2.23 of this document?
Yes.
Well, you're faster than me now. It's on page 9. So can you see it says the first aim of the noise policy statement for England is to avoid significant adverse impacts on health and quality of life, etc.
Yes.
Significant adverse should be avoided.
Yes.
While taking account of the principles of sustainable development. And then the second aim is to mitigate and minimise adverse impacts on health and quality of life from environmental neighbourhood noise within the context of sustainable development. Yes. Okay. So even where a noise impact doesn't reach the threshold of significant, what is the advice in the noise policy statement for England for something below significant? You said Mr. Strawn characterised it as insignificant. Yeah. What's the approach mandated here?
It states that all reasonable steps should be taken to mitigate and minimise those adverse effects.
Thank you. And could I ask you briefly just to take up Mr. Leach's noise proof of evidence and turn to page 10. Let me know when you have that.
Yep.
Do you have a core document reference that I
Sorry,
can use?
sir.
for that?
I
It's
have them.
14.3.1, sir.
Uh,
Did you say page 10?
I did. Thank you. Page 10. Okay, do you see he sets out a table there, which I think is from the PPG on noise from his preceding page.
Sorry, is it document page 10?
It's in the hard copy, page 10 of 68.
Yeah, yes.
Yeah. Okay, so at the bottom of that table, there are 2 entries for significant observed adverse effect level.
Yep.
And they're to be avoided and prevented. And above that, there's an observed adverse effect level, so something less than significant,
Yes.
which is described as present and intrusive.
Yes.
And we're told that it can cause small changes in behavior, attitude, and other physiological responses, potential for some reported sleep disturbance, affects the acoustic character of the area such that there's small actual perceived change in the quality of life.
Yes.
Okay. And again, the action there is to mitigate and reduce to a minimum.
Yes.
Okay, so with that context in mind, what is your position on whether there's a dichotomy between significant impacts which should concern the inspector and something below significant impacts which shouldn't be of any concern to the inspector?
Well, this table does, and I think the small changes in behavior is quite helpful for the inspector. If it's not significant, it can be obtrusive and it can result in small changes of behavior or attitude. And in this case, I think that would be a change in behavior towards the patrons of the Gurdwara.
Okay, thank you. And so your view then about whether a noise could be classified as a nuisance within the context of D13 if it was at this observed adverse effect level?
Yes, I think that would be considered a nuisance.
Thank you. There was a line of questions put to you about the density policies and why you hadn't drawn the inspector's attention to particular parts of, I think it was the draft SPG, which talked about density. Now, given the direction from the planning inspectorate that evidence should focus on the matters in dispute, and given that you don't dispute the density of the development, how appropriate is it would it have been in your view to spend time drawing the inspector's attention to those sorts of matters?
Yes, my proof focused on the main issues and only the main issues in relation to those refusal reasons. There is, of course, the assessment on the plan imbalance and the wider benefits of the scheme. I don't think that the density comes into that at all and doesn't need to be weighed as a positive against the scheme. Hence, I didn't feel that it was needed to be included, as we don't have an issue with the density that is proposed.
Okay. What's your view about whether optimizing the site, not maximizing, inevitably results in the separation distances and the shortfall in play and amenity space that we see on site?
Sorry, could you repeat the question?
Sure. What's your view about whether optimizing the site inevitably results in the separation distances that we see with Perkin Close or the shortfall in play and amenity space?
Yes, I think optimizing the site is about responding to the context and making sure that it can provide what is needed for the future occupiers of the development. So I think when you're optimizing the delivery of a site, you have to again optimize the quality of accommodation that is to be provided, as well as optimizing the relationship between neighboring properties, which I don't consider to be the case.
Thank you. Again, you were criticised for not referring to parts of the housing SPG, which talked about the 800 metres from a metropolitan area and the classification in that document. Now, in your rebuttal proof at paragraph 2.2, you set out the definitions from the housing SPG on central, urban, suburban, which include reference to that 800-metre
Yes.
distance. Can you think of any reason why you would consider it necessary to identify additional paragraphs which say the same thing?
I don't think so, particularly because it was within my rebuttal, slightly more time pressing, and it was very much try to be a succinct document that I didn't feel like I need to repeat myself.
Just to be clear, they don't say the same thing, and that wasn't the question I put, and it's not what the paragraphs say.
Okay, the reference in the draft SPG to the site being within the Hounslow town and the relevance of that. Can you turn up, please, your note on suburban urban issues, which is core document 14.20?
Is this the note on the emergent SPG?
Yes. And can you just turn within that to paragraph 2.29, which is on page 12?
Yes.
Do you remember Thank you. Yeah. Do you remember you were asked questions? Well, the appeal sites within the Hounslow town area. To what extent did you take that into your account in your consideration of suburban versus urban and draw it to the inspector's attention in this note?
Very, very much so. I tried to provide as a thorough summary of this section of the SPD as I could, and I think I did encapsulate the general guidance that's provided in that SPD, and indeed in assessing the character of the area around the appeal site as a whole. I tried to take a holistic approach and assess as wide a radius as possible.
Thank you. You were asked about the over provision of private amenity space, and you confirmed, and it's not in dispute, that there is an over provision. To what extent has that already been taken into account in calculating how much communal amenity space is needed?
Yes, so the policy SC5 states that you have the benchmark requirements based on how many habitable rooms, so per 3, 4, and 5 habitable rooms, and then however much private amenity space is provided for the occupiers is deducted from that figure, which results in a reduced requirement in this case of 1,700.
Thank you very much. There was a long line of questioning on why certain areas have been excluded from your calculation of amenity space. Yes. I think there were some further points you wanted to say that you were cut off from, but Mr. Ringer, let's be clear. I don't think it's proportionate when the difference between us is 13 square meters to go into that again. Yeah. Could you please just confirm whether your views as to the acceptability apply, whether it's 915 square meters or 902?
I think regardless of if you take the appellant's calculations or myself, there's still a significant under provision that I don't think has been offset by those contributions. And I think that both render the appeal scheme unacceptable.
Thank you. Could you take up, please, the play SPG, core document 10.2.3? Now, you were referring, when you were discussing the Muga and the fact that it would have to be paid for and wouldn't be accessible at all times, you discussed open access, and Mr. Strong said he was going to come back to you on paragraph 4.12 of this document, which is on page 51 of the hard copy and PDF 61. But I'm not sure we did come back to it. So can we just have a look at 4.12?
Yes.
So the preparation review of play strategies will involve an audit of current play provision. In deciding what play spaces to include in the audit, consideration should be given to the range of spaces, etc. As a minimum, audit should assess areas where play is intended to be at least one of the main functions, and then the dedicated play space included in the audit should be free and accessible and provide unrestricted opportunities for play and informal recreation for children and young people. Okay, what's the relevance of that in your view, please, to the Muga?
That does make it quite clear that facilities that aren't always open and facilities that are paid are not as of a value that can be beneficial for children.
Okay, thank you. And then table 4.3, I think it is, which is on PDF page 64. There's page 54, although there's no actual page number on that one.
Yes.
It says assessing areas of deficiency. What counts as an existing space for play? And for young people 12 plus, there's reference to sport or recreation space that's open access. What do you understand that to mean?
For me, open access means open at any time of the day, within reason. So 9 till in the evening or something along those lines, and particularly free. So you can go enjoy those activities without having to take the financial burden on, as I don't think any child should have to pay to play.
Okay, thank you. Now, the contribution that the appellant proposes to offset the shortfall in communal amenity and play spaces, the appellant's intention is that should be dedicated to Inwood Park.
Yes.
Why do you understand the appellant proposes Inwood Park should be the recipient of that contribution?
Because it is the closest park, closest play space available, and it's likely that's the most likely destination for future occupiers of the appeal scheme, and those obligations would have to directly impact the future occupiers. So they've selected what was the closest distance.
Okay. Is Inwood Park in the South Central area?
Yes, it is.
Okay. What's the problem as you see it? Is adding more residents to an open space within the South Central area?
Yeah, so we can see from the draft open space study some significant deficiencies. So just pull it up now.
Just a summary at this stage, Mr.
Yes.
Ringer. So significant deficiencies in
parks and gardens, amenity green spaces, and children's play space. So the FIT Trust recommends.
I think it's okay. Significant deficiencies. The inspector can look at the exact
Yeah.
details. So what's the problem then in adding more residents to areas with significant deficiencies?
So if there's an already and the deficiencies are calculated based on hectares per 1,000 population. So adding more population is going to further reduce that. And I would like to say that this was a study produced in 2018, and significant increases in population have already occurred. So the figures may be further. It could be further deficient in practice.
Understood. Thank you very much, Mr. Ringer, and thank you, sir. No further questions.
Right, okay, thank you for that, Mr. Ringer. That brings us up to 5 o'clock, and we're not quite where we were hoping to be based on the timetable. So I think we'll finish there, but could I ask the parties to have a think about the time estimates that have been given? I don't know if you can give any indications now, but do they seem accurate still, the times that I've been given, or are there to be any revisions?
So for my part, I think for evidence in chief, that should be about right. I think I said 45 minutes. Can't
Yes.
actually remember what I said for cross now, but
An hour and a half, I think, is
an hour and a half. Yeah, I wouldn't anticipate being any longer than that.
Mr. Strawn?
I'm going to be shorter of Mr. Robinson than I anticipated, and I think I had 2.5. Did I?
You did, yes.
Yes, I would certainly. I'd hope it would be more like 1 hour 30, perhaps 1 hour 45. I always slightly hesitate with these things because you never know what's going to be said in chief. But if it's based on what's in the proof.
Right, okay. And Mr. Furr, any revisions on yours?
No, sir. I think, well, if anything, I'm hoping I might be able to beat it. I think my estimate is 2 hours for cross-examination. I will have a look again overnight, and I will also, sir, if it's acceptable to you, try not to cover every single matter, but focus on the key ones, as long as it's understood that that doesn't detract from anything that Mr. Ringer said in his evidence, if I don't pick up every single point with Mr. Tickle.
Yes, okay, thank you. Well, we're obviously with the appellant's witness, we're going to have more than one party cross-examining. So again, I don't need to have the same ground covered
we
from
will
both.
endeavour
just
to
to-
ensure that's
That's it. We're
Yes.
liaising to ensure that we don't duplicate
Good.
effort unnecessarily.
Right, thank you. Okay, are there any matters then that anyone wants to raise before we adjourn for today? No. And is everybody available to start at 9:30 tomorrow? Yes. Okay, right. Well, thank you then, and we'll adjourn until 9:30 tomorrow.